A warm good morning to everyone. I request everyone to kindly take their seats. कुछ ही समय में हमारे अतिथिगण हमारे बीच में आने वाले हैं, तो कृपया आप सभी से निवेदन है कि आप सभी अपना स्थान ग्रहण कर लें। आप सभी से विनम्र निवेदन है कि अपने मोबाइल फ़ोन को या तो स्विच ऑफ या फिर साइलेंट मोड पर कर लें। थैंक यू। वार्म गुड मॉर्निंग टू ऑल। आप सभी से पुनः निवेदन है कि कुछ ही समय में हमारे अतिथिगण हमारे बीच में आने वाले हैं, तो कृपया अपने मोबाइल को स्विच ऑफ कर लें, अन्यथा मोबाइल को साइलेंट कर लें। धन्यवाद। आप सभी से निवेदन है कि इस ऑडिटोरियम के अतिरिक्त मेरे बाईं ओर एक और अन्य हॉल में भी बैठने की व्यवस्था की गई है। यदि किसी को इस हॉल में स्थान न मिले तो वे इस बराबर के हॉल में अपना स्थान ग्रहण कर सकते हैं। उस हॉल में इस प्रोग्राम के लाइव स्ट्रीमिंग की भी व्यवस्था की गई है। थैंक यू। हमारे बीच में जो भी सबसे जूनियर मोस्ट लॉयर्स हैं, उनसे विनम्र निवेदन है कि वे केवल इनॉग्रल फंक्शन के लिए हमारे अतिथिगण कुछ ही समय में हमारे बीच में उपस्थित होने वाले हैं। I request Shri Dharminder Singh, Registrar General, High Court of Madhya Pradesh, to kindly escort our dignitaries on the dais. Honorable Mr. Justice Jitendra Kumar Maheshwari, Judge Supreme Court of India. Honorable Mr. Justice Satish Chandra Sharma, Judge Supreme Court of India. Honorable Mr. Justice Alok Aradhe, Judge Supreme Court of India. Honorable Mr. Justice Rajendra Menon, former Chief Justice, Delhi High Court and Chairperson, Armed Forces Tribunal. Honorable Mr. Justice Sanjeev Sachdeva, Chief Justice, High Court of Madhya Pradesh. Honorable Mr. Justice V. Kameshwar Rao, Judge, Delhi High Court. Honorable Mr. Justice Vivek Rusia, Administrative Judge, High Court of Madhya Pradesh. Honorable Mr. Justice Vivek Agrawal, Judge, High Court of Madhya Pradesh and Chairman, Governing Council, Madhya Pradesh State Judicial Academy. Mr. Prashant Singh, Advocate General, High Court of Madhya Pradesh. Honorable Judges from Delhi High Court and High Court of Madhya Pradesh. Former Honorable Judges, Mr. Radhila Gupta, Chairman, State Bar Council of Madhya Pradesh. Mr. Dhanya Kumar Jain, President, Madhya Pradesh High Court Bar Association. Mr. Sanjay Agrawal, President, High Court Advocates Bar Association, Jabalpur. Mr. Aditya Adhikari, General Secretary, Senior Advocates Council, Jabalpur. Office Bearers of the Bar Associations and members of the Bar. Mr. Dharminder Singh, Registrar General, High Court of Madhya Pradesh and officers of the Registry. Mr. Umesh Pandav, Director, Madhya Pradesh State Judicial Academy and officers of the Academy. Mr. Krishnamurti Mishra, Principal District and Session Judge, Jabalpur and Judicial Officers of the District Court, Jabalpur. Kumari Suman Srivastav, Member Secretary, Madhya Pradesh State Legal Services Authority and officers of the Madhya Pradesh State Legal Services Authority. Officers from the District Administration, participants, dignitaries present in the auditorium, members of the print and electronic media, viewers who have joined us virtually, ladies and gentlemen. Warm greetings to everyone. I, Saurabh Kumar Singh, Officer on Special Duty, Madhya Pradesh State Judicial Academy, welcome you all to the conference on Advocacy and Professional Competence, Pursuit of Excellence for Advocates, being organized by the High Court of Madhya Pradesh and Madhya Pradesh State Judicial Academy. Commencing the program, I request the honorable dignitaries and the esteemed gathering to kindly rise for National Anthem.
जन मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
To mark an auspicious beginning of the inaugural event, I humbly request the dignitaries on the dais to commence the conference by lighting the lamp. I would request them to please proceed towards the same. As we light the ceremonial lamp, may it remove the darkness of ignorance and fill our surroundings with radiance of wisdom, peace, and divine blessings, guiding us towards enlightened deliberations. Guided by the ancient Indian ethos, Atithi Devo Bhava, the guest is equivalent to God. We express our deep reverence to those who grace us with their presence. As we proceed to the next segment of the inaugural session, may I please request the felicitation of our honorable guests. I request Mr. Dhanya Kumar Jain, President, Madhya Pradesh High Court Bar Association, to please welcome our chief guest for the conference, Honorable Mr. Justice Jitendra Kumar Maheshwari, Judge, Supreme Court of India, by presenting him a sapling and a memento as mark of our respect and gratitude. Thank you, sir. Now I request Mr. Sanjay Agrawal, President, High Court Advocates Bar Association, Jabalpur, to please welcome Honorable Mr. Justice Satish Chandra Sharma, Judge, Supreme Court of India, by presenting a sapling and a memento as a mark of our respect. Thank you, sir. Now I request Mr. Aditya Adhikari, General Secretary, Senior Advocates Council, Jabalpur, to please welcome Honorable Mr. Justice Alok Aradhe, Judge, Supreme Court of India, by presenting a sapling and memento as mark of our gratitude. Thank you, sir. Now I request Mr. Manish Mishra, President, District Bar Association, Jabalpur, to please welcome Honorable Mr. Justice Rajendra Menon, former Chief Justice, Delhi High Court, and Chairperson of Armed Forces Tribunal, by presenting a sapling and memento as mark of our respect. Thank you, sir. Now I request Mr. Radhelal Gupta, Chairman, State Bar Council of Madhya Pradesh, to please welcome Honorable Mr. Justice Sanjeev Sachdeva, Chief Justice, High Court of Madhya Pradesh, by presenting a sapling and memento as a mark of our respect and gratitude. Thank you, sir. Now I request Mr. Paritosh Trivedi, Secretary, Madhya Pradesh High Court Bar Association, to please welcome Honorable Mr. Justice V. Kameshwar Rao, Judge, Delhi High Court, by presenting a sapling and memento as a token of our respect. Thank you, sir. Now I request Mr. Nikhil Tiwari, Secretary, High Court Advocates Bar Association Jabalpur to please welcome Honorable Mr. Justice Vivek Rusia, Administrative Judge, High Court of Madhya Pradesh, by presenting a sapling and memento as a mark of our gratitude. Thank you, sir. Now I request Mr. Amit Jain, Senior Vice President, Madhya Pradesh High Court Bar Association, to please welcome Honorable Mr. Justice Vivek Agrawal, Judge High Court of Madhya Pradesh and Chairman Governing Council Madhya Pradesh State Judicial Academy, by presenting a sapling and memento as a mark of our respect and gratitude. Thank you, sir. Now I request Mr. Gyan Prakash Tripathi, Secretary, District Bar Association Jabalpur, to please welcome Mr. Prashant Singh, Advocate General, High Court of Madhya Pradesh, by presenting a sapling and memento as a token of our gratitude. Thank you, sir. Moving towards the next segment of the inaugural session, I humbly request Honorable Mr. Justice Vivek Rusia, Administrative Judge, High Court of Madhya Pradesh, to kindly deliver the welcome address.
Honorable Mr. Justice Jitendra Maheshwari, Judge, Supreme Court of India. Honorable Mr. Justice Satish Chandra Sharma, Judge, Supreme Court of India. Honorable Mr. Justice Alok Aradhe, Judge, Supreme Court of India. Honorable Mr. Justice Sanjeev Sachdeva, Chief Justice, High Court of Madhya Pradesh. Honorable Mr. Justice Kameshwar Rao, Senior Most Judge, Delhi High Court. Honorable Mr. Justice Rajendra Menon, former Chief Justice, Delhi High Court and Chairperson, AFT. Honorable Judges of Delhi High Court, Honorable Judges of Madhya Pradesh, Mr. Prashant Singh, Advocate General, Justice DM Dharmadhikari, former Judge, Supreme Court, all retired High Court judges, distinguished resource persons, officers of Registry and Academy, member of the Bar, participants, member of media, a very good morning to everyone. It gives me great pleasure to welcome you all to this conference on advocacy and professional competence pursuits of excellence for advocate, organized by Madhya Pradesh State Judicial Academy under the guidance of High Court of Madhya Pradesh. Advocates are one of the most important pillars of our judicial system. Their role in assisting the court and ensuring that justice is done cannot be overstated. The purpose of this conference is to help advocates to enhance their professional skill, understand new areas of law, and strengthening their ethical foundations. The practice of law is constantly evolving. New laws, changing social realities, and growing complexity of the litigation requires continuous learning. This conference gives us an opportunity to exchange ideas, share experience, and learn from some of the most respected names in the legal field. The session planned for today cover very important topics, namely appreciation of evidence, conduct of trial, effective legal drafting, and understanding of commercial and intellectual property. These are the areas in which every practicing advocate must have clarity and confidence. I am sure today's discussion will highly beneficial for all the participants. Speaking for our honorable guest, we are deeply honored by the presence of our chief guest, Honorable Mr. Justice Jiten Maheshwari, Judge, Supreme Court of India. Honorable Sir's vast experience and the words of guidance will be great inspiration to all of us. I would like to inform you that after finishing the Friday motion hearing work, Sir traveled from Delhi to Indore to attend a marriage function. Thereafter, woke up early in the morning to catch a flight to Jabalpur. From here, he will return to Delhi, take a break of 2 hours in the airport, then again will go back to Indore to attend another marriage function. And Monday, he will reach Supreme Court by 10:30. So this level of energy and commitment is required for judges and the lawyers. We also warmly welcome Mr. Justice Satish Chand Sharma. Sir is full of humbleness. He is always helpful to the needy person. When he was advocate, then he became a senior advocate, there was no change. Thereafter he became judge, no change. Chief Justice and Supreme Court. He is always available to the needy person, gives help. So this type of compassion is required in advocate as well as in judges. Honorable Justice Alok Aradhe. Justice Aradhe, when he was advocate and judge, he was always ready with latest law and latest judgment on the field. Whenever you ask in the corridor or in the courtroom, he will give you the latest judgment and the oldest judgment on that point. So this level of preparation is required for lawyers and judges. Mr. Justice Rajendra Menon, my senior, my mentor, my guru. Not only for me, he is always available for everyone. Whenever any help is required to lawyer and judges, he is always available. I have learned ABCD of law from him, how to discharge the duties as judge. Sir, thank you very much. I take this opportunity to warmly express my heartfelt gratitude to Mr. Justice Sanjeev Sachdeva, Chief Justice, High Court of Madhya Pradesh, for his constant encouragements and the leadership in taking judicial education forward. This initiative of reaching out to the members of the bar is devised by Sir, and we could not be more thankful. His Lordship's emphasis on training, dialogues, and collaboration between the bench and bar is truly commendable. Within short period of less than 1 year, he has organized 4 conferences for upgradation of knowledge of lawyer. This is required to be returned to the institute, what you have got from the institute. Sir, we are thankful you are returning to the institution, to the lawyers, the knowledge which you have gained. I would like to acknowledge the efforts of Justice Vivek Agrawal, Chairman of Madhya Pradesh State Judicial Academy, whose guidance this program is being organized. We are privileged to warmly welcome Honorable Judges of Delhi High Court. Your presence adds immense grace to this occasion. We look forward to benefiting from your wide range of experience. I also welcome Mr. Prashant Singh, Advocate General, for his continued support to all of our programs and for motivating the members of the bar to practice actively in academic initiative of our academy. I encourage all the participants to engage actively in the session, share your experience and make the most of this learning opportunity. I once again welcome all our honorable guests, dignitaries and participants. I am confident that the conference will enrich our understanding and strengthening our shared commitment to the excellence in the legal profession. Thank you. Jai Hind.
Thank you, my lord. Your address has set the tone for the deliberations ahead. I now request Mr. Prashant Singh, Advocate General, High Court of Madhya Pradesh, to please address us.
Honorable Mr. Justice Jiten Kumar Maheshwari ji, Honorable Mr. Justice Satish Chandra Sharma ji, Honorable Mr. Justice Alok Aradhe ji, Honorable Mr. Justice Rajen Menon ji, our Honorable Chief Justice Shri Sanjeev Sajdeva ji, Honorable Mr. Justice Valluri Kameshwar Rao ji, Honorable Mr. Justice Vivek Rusia ji, Honorable Mr. Justice Vivek Agarwal ji, all honorable judges from Delhi High Court, all companion judges of this honorable High Court, बार के मेरे साथी श्रीमान राधेलाल गुप्ता जी, चेयरमैन स्टेट बार काउंसिल ऑफ मध्य प्रदेश, श्रीमान धन्य कुमार जैन जी, मध्य प्रदेश हाई कोर्ट बार एसोसिएशन के अध्यक्ष महोदय, श्रीमान संजय अग्रवाल जी, अध्यक्ष मध्य प्रदेश एडवोकेट्स बार एसोसिएशन, श्री आदित्य अधिकारी जी, जनरल सेक्रेटरी सीनियर एडवोकेट्स काउंसिल, धर्मिंदर सिंह रजिस्ट्रार जनरल, उमेश पांडव जी, यहाँ उपस्थित सभी मेरे साथियों, मैं माँ नर्मदा की इस पावन भूमि में, ऋषि जाबाली की तपोभूमि में और संगमरमर की वादियों में माननीय सभी अतिथियों का हृदय से स्वागत करता हूं, अभिनंदन करता हूं, वंदन करता हूं। हमारे हाई कोर्ट में जब से हमारे मुख्य न्यायाधीश श्रीमान संजीव सचदेवा जी वे पधारे, तब से हमने देखा उन्होंने एक अनूठा प्रयत्न किस तरह से बार का विकास हो और किस तरह से एक बार अपनी वही पुरातन पहचान को लेकर के आगे बढ़े और एक के बाद एक उन्होंने अनेक प्रयोग किए। सबसे पहला उन्होंने इंदौर में कोलोकियम किया, उसके बाद एक और बड़ा इसी तरह का कॉन्फ्रेंस, और आज उसी क्रम पे यहाँ पर एक कॉन्फ्रेंस का आयोजन किया गया है, कॉन्फ्रेंस ऑन एडवोकेसी एंड प्रोफेशनल कॉम्पिटेंस परसूट ऑफ एक्सीलेंस फॉर एडवोकेट्स। मैं ऐसा मानता हूँ और ऐसी अपेक्षा भी करता हूँ हम सभी बार के साथियों से कि इस कॉन्फ्रेंस के विभिन्न सेशंस में हम सभी अपनी सक्रिय सहभागिता निश्चित रूप से देंगे और जो मंच से ज्ञान वर्षा अमृत वर्षा होगी उससे लाभान्वित होकर के हम निश्चित रूप से आज की कॉन्फ्रेंस का और लाभ लेकर के और अपना स्वयं का विकास करेंगे। ऐसी आशा, ऐसी विनम्र अपेक्षा आप सबसे करते हुए मैं अपने विषय को समाप्त करता हूँ। जय हिंद, जय भारत।
Thank you, sir, for the informative address. Now I humbly request Honorable Mr. Justice V. Kameshwar Rao, Judge, Delhi High Court, to please address the August gathering.
Good morning, everyone. Honorable Mr. Justice Jitendra Kumar Maheshwari, Honorable Mr. Justice Satish Chand Sharma, Honorable Mr. Justice Alok Harade, Judges of the Supreme Court of India, Honorable Mr. Justice Sanjeev Sachdeva, the Chief Justice of the High Court of Madhya Pradesh, Honorable Justice Vivek Rusia, Honorable the Judge of the Madhya Pradesh High Court, Honorable Justice Vivek Agarwal, the Judge of the Madhya Pradesh High Court, Mr. Prashant Singh, Learned Advocate General of the Madhya Pradesh, all the judges of the Madhya Pradesh High Court, my colleagues on the bench in the Delhi High Court, Justice D.M. Dharmadhikari, former Judge of the Supreme Court of India, Justice Mukta Gupta, the retired Judge of the Delhi High Court, Justice Rekha Palli, the retired Judge of the Delhi High Court, all the Additional Advocate Generals and all the functionaries of the Bar Association of the Madhya Pradesh High Court and all the advocates, both old and the young one. Thank you very much. And well, I must thank the Honorable the Chief Justice, Justice Sanjeev Sachdeva, and all the judges of the High Court who have given this opportunity and hosting us for this conference on advocacy and professional competence pursuit and excellence for advocates. Well, I feel that this kind of an interaction is really very important. This I feel that for two reasons. One, it is not that we are interacting, we are speaking to you, but I believe that this is a continuous learning process, which is a two-way process. It's not only that we are putting our views, we are also hearing your views on the subject. This is only for the reason that even as a judge also, I continue to learn each and every day. And I feel that, this kind of an interaction must happen at pan-India level, not only confining to the Delhi and the Madhya Pradesh High Court. And surely as a judge also, surely after discussion with the Honorable the Chief Justice, surely we also shall reciprocate this kind of a gesture on the part of the Honorable the Chief Justice and the judges of the Madhya Pradesh High Court. And I can say on behalf of my colleagues who are here from Delhi High Court, we are going to see a very encouraging and a lovely, interaction with all of you. Thank you very much. Looking forward.
Thank you, Lordship, for addressing us. Now I take the privilege of inviting Honorable Mr. Justice Sanjeev Sachdeva, Chief Justice, High Court of Madhya Pradesh, to please address the August gathering.
Honorable Mr. Justice J.K. Maheshwari, Judge Supreme Court of India, Mr. Justice Satish Sharma, Mr. Justice Alok Harade, Judges Supreme Court of India, Justice Rajendra Menon, Chairperson Armed Forces Tribunal, Justice V. Kameshwar Rao, Administrative Judge, Delhi High Court, Justice Vivek Rusia, Administrative Judge, Madhya Pradesh High Court, Justice Vivek Agarwal, Chairman, Advisory Committee, State Judicial Academy, brother and sister judges, resource persons and judges of the Delhi High Court, Justice D.M. Dharmadhikari, former Judge Supreme Court of India, former judges of Madhya Pradesh High Court, Mr. Prashant Singh, Advocate General, Mr. Radhilal Gupta, Chairman, State Bar Council, Mr. Dhanya Jain, Mr. Sanjay Agarwal, Mr. Adhikari, and their respective teams from the respective bar associations, senior advocates, members of the registry, Registrar General, Director, State Judicial Academy, officers of State Judicial Academy, ladies and gentlemen.
It gives me immense pleasure to extend a warm welcome to everyone in this conference on advocacy and professional competence, pursuit of excellence for advocates. It was around this time last year that we had organized a session on intellectual property laws, followed by art of cross-examination by leading experts from this field in Jabalpur. We've had 2 sessions, 2 colloquiums in Indore. We've had a training session in Indore. Jabalpur, we've had now, this is the 3rd session, and this was persistence of the president, secretaries of the Bar Association here that we were sort of coerced and forced into doing this conference, but we wanted to do it. And now there is one planned in December in Gwalior also. So we have the privilege of having 3 high courts, 3 benches, but the thing is we need to reach out to all of you. I am overwhelmed with the presence of all of you, and there in fact a adjoining classroom where there are about 200 more participants who are joined and watching us virtually. The objective of the conference is to harness the legal acumen, refine the professional skills, and enrich the understanding of contemporary legal developments. The symbiotic relationship between the bar and the bench must be nurtured through continuous learning, shared understanding, and a mutual commitment to excellence. Such collective capacity building efforts contribute not only to the efficiency of the justice system, but also to greater cause of ensuring fair, speedy, and effective justice to every litigant. I would like to add that in the journey of legal profession, each member of the bar must recognize the immense influence they have. Whether we realize it or not, our conduct, our ethics, and the way we engage with others shape the experience of countless people, colleagues, clients, judges, and young lawyers. The bar must consciously strive to ensure that this impact is always positive, dignified, and enriching. A truly great bar is one where its members uphold values that endure long after they leave the corridors of the court: courtesy, fairness, integrity, and professionalism. It is these qualities that people remember, not titles, not victories, but the grace with which we lead our professional lives. The bar should work towards cultivating a culture where every advocate becomes a source of encouragement, guidance, and strength for others. The bar should also commit itself to fostering a positive, respectful, and collaborative environment. A bar that supports its members, especially the young and the first generation practitioners, creates a more robust justice delivery system. Mutual respect between members of the bar, between the bar and the bench, strengthens the very soul of this institution. We are privileged and honored to have amongst us distinguished jurists who have graciously consented to grace this conference and share their insights with us. I am thankful to Honorable Mr. Justice Jitendra Kumar Maheshwari, the chief guest of this conference, whose distinguished journey in the field of law continues to inspire generations of legal professionals. I am equally thankful to Honorable Mr. Justice Satish Chand Sharma, Justice Alok Aradhe, and Mr. Justice Rajendra Menon for lending prestige to this ceremony with their presence. As we learn from their experiences and insight, may each of us renew a resolve to pursue excellence with integrity, humility, and to uphold the noblest ideas of our profession. Their presence today reminds us that true measure of a lawyer or judge lies not merely in the knowledge of law, but in the ability to apply it with fairness, empathy, and courage. I am equally thankful to honorable judges of the Delhi High Court who have graciously joined us for this conference. Delhi, with its vast and diverse spectrum of legal work, presents advocates with unique challenges, each demanding rigorous preparation, adaptability, and depth of understanding. The dynamic exposure that such practice offers greatly refines a counsel's professional attitude and advocacy skills. We are confident that the insights shared by such distinguished jurists will make this conference a truly enriching experience for all the participants. In recent years, the very nature of litigation has evolved, with commercial, corporate, and intellectual property disputes gaining prominence. The rise of complex financial transactions, cross-border commerce, and technology-driven contracts require advocates to combine traditional reasoning with commercial awareness and global perspective. In this context, our role as legal professionals becomes crucial in ensuring that we stay abreast of these changes, adapt technology efficiently, and serve clients more effectively. Conscious learning, therefore, is vital. It is only then that we will be able to navigate the modern legal landscape with confidence and competence. Lastly, I would like to highlight that the history of our nation reminds us that some of the greatest reformers and nation builders, Mahatma Gandhi, Jawaharlal Nehru, Vallabhbhai Patel, were advocates who perceived law not just as a profession, but as a tool for social transformation. The same spirit must continue to inspire every member of the bar to look beyond individual briefs and see advocacy as a noble contribution to justice and nation building. In conclusion, I hope that each participant will take this conference as an opportunity not just to learn, but to rediscover the joy of lifelong learning. As far as law is concerned, we remain students forever. The true beauty of law lies not merely in knowing it, but in living it with empathy, depth, and dedication to justice. Stay humble, stay curious, and keep refining your craft. I wish this conference a great success. Thank you very much.
Thank you, my lord, for your thought-provoking and enlightening address. Now, I request Honorable Mr. Justice Rajendra Menon, former Chief Justice Delhi High Court and Chairperson of Armed Forces Tribunal, to please share his lordship's thoughts with us.
Good morning to all present. Honorable Justice Jiten Kumar Maheshwari, Shri Justice Satish Sharma ji, Shri Justice Alok Aradhe, Judges of the Supreme Court of India, Chief Justice of the Madhya Pradesh High Court, Justice Sanjeev Sachdeva, Justice Kameshwar Rao from Delhi High Court, Justice Vivek Rusia, Justice Vivek Agarwal, the Advocate General of Madhya Pradesh, Mr. Prashant Singh, Justice D.M. Dharmadhikari ji, Justice S.S. Jha, Presidents of the various High Court associations in Jabalpur, the District Court associations, my esteemed colleagues from the Delhi High Court and the Madhya Pradesh High Court, senior advocate, the participants, ladies and gentlemen. It's a pleasure to come to Jabalpur and be in the midst of the advocates of my parent home, Jabalpur. And I wish to thank the Chief Justice, Justice Sanjeev Sachdeva, to have taken this initiative for holding this conference to enlighten and to train the members of the bar. I am constrained to refer to you something that was said by Professor N.R. Madhav Menon, the architect who changed the legal education in this country. The days I did my graduation in law from the law schools, we didn't have law schools, we had mostly evening law colleges. That has changed. And when Justice Madhav Menon was the Vice Chancellor of the first National Law University in Bangalore, in one of his lectures he said, and I quote, "The transformation from a law graduate to a legal practitioner is full of challenges and uncertainties. Even for a person who comes from the family of lawyers and judges, the challenges are there, and the challenges are much more for those outside lawyers, outside family lawyers coming from poor, rural, urban household migrating to urban centers where courts are situated." Having said that, he further went on to say in that speech, and we need to take note of this warning which he gave way back in 2015-2016. He said, unfortunately, the bar councils and the bar associations responsible for professional development take very interest in giving the new entrants to the profession the basic competence necessary. Law colleges are ill-equipped to do the job as they do not possess the resources to impart training of skills and professional to the students. I am happy to note that in the backdrop of this statement made by Professor Madhav Menon, when your Chief Justice was telling us that the law training courses undertaken by him, and particularly this one in Jabalpur, is because of the initiative of the High Court Bar Associations of Jabalpur. I congratulate them for having taken this initiative, and I feel that if we continue to do this, the system of advocacy, the expertise of the lawyers would increase, and this would go a long way in the process of administration of justice. I had prepared a very long note on the subject, but time constraints prevent me from going through it. I would be giving it to the in charge of the Judicial Academy with a request to him to get it printed and circulated in the Jyotiri magazine for lawyers and everybody to go through it. The contours of adjudication dominates and decides the contours of legal training. Judges need fact for framing their legal proceedings, and therefore the most paramount thing which a lawyer should keep in mind is that he should be abreast on facts. It is the facts which should lay the foundation for a case. I have heard lawyers who argue a bail matter do not even refer to the FIR during their entire argument. I have heard lawyers arguing service disputes, disciplinary matters, they complete their argument but never refer to the charge sheet and the allegations made in the charge sheet. And therefore, what I emphasize is that knowledge of facts, the facts should be in the fingertip of a lawyer. The advocate visualizes and advances the probable developments in the case, keeps his powders dry as and when required. The lawyer comes with his problem in the form of a grievance, and narrates certain facts. Those facts have to be evaluated, developed, and presented to the court in a manner that the law can be applied for reasonably deciding the case as per the law. Therefore, training in the skill and training an advocate for reaching an appropriate professional level is absolutely necessary, and I am very confident that this 2 days workshop and conference will go further in that. And as your Chief Justice said, we have eminent judges from the Delhi High Court present here. I have been in the Delhi High Court, and as he said, I agree with his contentions that what comes before the Delhi High Court are typical matters which it's very difficult to have in any other high court. And therefore, the expertise of the judges of the Delhi High Court who have been lawyers in Delhi would go a long way in imbibing knowledge and training skills to my learned brother advocates in this High Court. What a client does, he has a grievance, he chooses his lawyer, and thereafter it is the choice of the lawyer how to go about the case, how to prepare it, what procedure to be followed, what is to be done. So therefore, a big responsibility rests on the lawyer in the matter of developing the case and taking it to a logical conclusion as per law. The skills of communication, the skill of developing the arguments, and the skill of presentation of the matter are all to be decided by the lawyer. skill without knowledge is useless. You may know the law, you may know everything, but the knowledge with regard to how the case has to be progressed and how you have to communicate it to the court is something which is very important, and therefore developing a communication skill is one of the important aspects of a good advocate. Integrity is being discounted these days in the profession. Yet, it should be kept in mind that no profession or no professional can ultimately succeed without a reputation about his integrity. The site may sometimes bring you short-term advantages and benefits, but be sure it is going to cost you heavily in the long run. If you, as a lawyer, acquire a reputation of trust, worthiness, people will start believing you, and you will not be required to prove each and everything. Things, as you said, would be accepted because of your integrity and your honesty in the profession. These are few of the things which I have noted. Due to, as I said, due to paucity of time, it may not be possible, and it is not proper on my part to go through each one of them, because my learned friends from Delhi have to take the afternoon flight back to Delhi, and it would be a bad, I would not like to detain them, except for saying that I am very thankful to the Chief Justice and the High Court for having permitted me to come here, and I promise you that given one more opportunity, I would come and spend more time with my lawyer friends in Jabalpur to impart them more training, skill, and ensure that as this bar is one of the best bar in the country, I am a product of this bar, and therefore I want this bar to be as it is. It has produced skilled lawyers like Justice J.S. Verma, R.C. Lahuti, Justice G.P. Singh, and let us all follow their footpath and develop this bar as one of the best in the country. Thank you very much. Jai Hind.
Thank you, Lordship, for addressing us. I now humbly request Honorable Mr. Justice Alok Aradhe, Judge Supreme Court of India, to please share his Lordship's thoughts with us.
A very good morning to all of you. It's indeed good to be in Jabalpur and among so many familiar faces after a long time. Honorable Mr. Justice J.K. Maheshwari, Honorable Mr. Justice Satish Chandra Sharma, my esteemed colleagues on the bench in Supreme Court, Mr. Justice Sanjeev Sachdeva, Chief Justice of Madhya Pradesh High Court, Mr. Justice Vivek Rusia, Administrative Judge High Court of Madhya Pradesh, Mr. Justice Vivek Agarwal, Chairman Madhya Pradesh State Judicial Academy, Mr. Justice V.K. Rao, Judge Delhi High Court, Judges of High Court of Delhi and High Court of Madhya Pradesh, Mr. Justice Rajendra Menon, former Chief Justice of Delhi High Court and Chairperson Armed Forces Tribunal, Mr. Prashant Singh, Advocate General, Mr. R.L. Gupta, Chairman of State Bar Council, Mr. D.K. Jain, President of the Bar Association, Mr. Sanjay Agarwal, President of the Advocates Association, Registrar General and officers of the registry, learned senior advocates and members of the bar. It's indeed, as I said, my privilege to be amongst you all on this, for this inaugural session. The theme of the conference resonates deeply with noble traditions of our legal profession, a profession that has been the conscience keeper of our democracy, the custodian of constitutional ideals, and the primary medium through which voice of justice finds articulation. The success of any judicial system depends as much as on the quality of bench as upon the caliber and commitment of the bar. The advocate is not a mere participant in the judicial process. He is one of its pillars. Courts may pronounce judgments, but it is the advocate who breathes life into the cause, who brings facts to light and presents the argument with clarity and persuades the mind with reason. The advocate is both an artist as well as a craftsman, an artist in persuasion and craftsman in precision. Professional competence, therefore, is not mere a technical attribute, it is a moral and intellectual commitment. It encompasses not only the mastery of law and procedure but also the discipline of preparation, ethics of advocacy, and humility to learn continuously. Excellence in advocacy is not achieved overnight. It is pursued over a lifetime. It demands study, reflection, integrity, and an unyielding devotion to truth. The young lawyers, in order to rise from competence to excellence, have to acquire intellectual, ethical, and technological competence. Younger members of the bar must consciously cultivate each of these dimensions by reading deeply and by observing the crafts of seniors and learning the unwritten traditions of the courtroom. In pursuit of professional competence, ethics must remain our North Star. No amount of brilliance can be a substitute for integrity. Justice Krishna Iyer once observed, and I quote, "Law is not a trade nor briefs broker's business," unquote. Advocacy an instrument for social good. It is a means by which weak may find voice and the powerful may be held accountable. Excellence in advocacy is incomplete without empathy. The pursuit of excellence is not without obstacles. The legal profession has undergone profound transformation. Amongst most pressing challenges is the increasing commercialization of practice. Another challenge is uneven quality of legal education and professional training. We also face challenges of delay and docket pressure, which affect both advocates and the judges. A further concern is decline of mentorship and collegiality within the bar. The old culture of seniors nurturing the juniors is slowly giving up to isolation and competition. Last is the technological divide, where some lawyers embrace new tools of research while others struggle to adapt them. To meet the challenges, we must return to first principles, that is, integrity in action, industry in preparation, and intellect in argument. Before I conclude, I wish to state that High Court of Madhya Pradesh occupies a place of unique distinction in India's constitutional history. It is from this court that the celebrated case of Shivakant Shukla versus ADM Jabalpur originated. This court has tradition of scholarship, independence, and quiet moral strength. It has produced judges and jurists whose judgment continue to be cited for their clarity, precision, and deep moral vision. This court has been headed by legal luminaries like Justice Hidayatullah, Justice G.P. Singh, and Justice J.S. Verma. We all are part of this great legacy and traditions and therefore should feel proud about it. The conference organized by the High Court and the State Judicial Academy is an exemplary initiative, for it affirms that learning is not confined to classrooms and the best lawyers are lifelong students. I take this opportunity to congratulate Honorable the Chief Justice of Madhya Pradesh High Court and his team for this great initiative. May the deliberations of the conference inspire our bar to rise higher in learning, in integrity, and in service. I am sure that this conference would serve the purpose for which it is being held. Thank you for your patience.
Thank you, my lord, for your profound words of wisdom. Now I humbly request Honorable Mr. Justice Satish Chandra Sharma, Judge Supreme Court of India, to please address us on this landmark occasion.
Honorable Justice Jitendra Maheshwari, Judge Supreme Court of India, Honorable Justice Alok Arade, Judge Supreme Court of India, Honorable Justice Sanjeev Sachdeva, Chief Justice High Court of Madhya Pradesh, Honorable Justice D.M. Dharmadhikari, former Judge Supreme Court of India, Honorable Justice S.S. Jha, former Judge of this court, Honorable Justice Rajendra Menon, Chairman Armed Force of the Tribunal. In fact, I'm finding it difficult to say Honorable Justice because I call him Raju Bhaiya. When I was 5 years old, I used to go to his house and his mother used to make coffee and dosa for us. Esteemed judges of the High Court of Madhya Pradesh, esteemed judges of the High Court of Delhi, Shri Sanjay Agrawal, President of the High Court Advocate Association, Shri D.K. Jain, President High Court Bar Association, Shri Prashant Mishra, Advocate General, and his team, Shri Radhilal Gupta, Chairman MP Bar Council, Shri Suresh Mohan Guru, Deputy Solicitor General of India, Mr. Manish Mishra, President, District High Court Bar Association, officers of the Madhya Pradesh State Judicial Academy, of judicial officers, senior advocates, advocates from various districts of Madhya Pradesh, dear participants, and all others who are in attendance today. A very good morning to all of you. It is always a matter of great delight and personal privilege to come to Jabalpur, and when the invitation is extended by this great institution of High Court of Madhya Pradesh, the honor feels different. I must begin by congratulating the High Court and the Judicial Academy, especially the Chief Justice Shri Sanjeev Sachdeva and Justice Vivek Agrawal for organizing this thoughtful conference, which is designed to enhance the professional competency of the advocates. There are few aspects of the profession which bears a close connection to the functioning of the judiciary. The professional competency of the advocates is one such area, and for this very reason it holds a position of great importance for all of us. An advocate is a crucial pillar in the delivery of justice in a system. Both court and the litigant are dependent upon the assistance of the advocate to great extent for reaching a just decision in the case. It is for this very reason that the advocates are termed as officers of the court. However, with great power comes great responsibility. The foremost responsibility of an advocate is to continue to strive towards excellence in the profession, not only for his own growth, but also for providing fair assistance to the seekers of justice. It is a profession which hardly makes one feel settled, and unsettling feeling is always there in mind, especially of an advocate. But you must remember that this unsettling feeling keeps you on your toes and keep walking on the path of excellence. Today, the profession is undergoing crucial changes. With the advent of artificial intelligence, the working of an advocate is changing in more ways than we can imagine. Earlier, it used to be a task to find the right judgment for the facts of a given case. Now, you come across hundreds of judgments at the click of a button. Whereas it has made research easier for many, we must exercise due diligence and caution in relying upon the judgments in the court. There are always cases of counsels relying upon overruled or sub judice or even non-existent judgments in the courts, not consciously, but solely because of placing over-reliance on the online research tool, which are largely driven by artificial intelligence. This easy access has also increased mechanical reliance on the precedents merely by looking at the operative portion without examining the similarity of facts. Therefore, in this world of over-information, it all falls upon you to filter the grain from the chaff, and there's need to exercise great caution in the consuming the readily available information in the online space. The profession is also facing a number of ethical issues. Unfortunately, there is a growing tendency to achieve quick outcomes, and in that process, one often tends to cross the ethical line. Whereas such practices may be rewarding in the short course, they are certainly detrimental to the system in the long run. The mobility of the profession of law rests upon the soldiers of the advocates, and it is your solemn duty to walk on a path which is not legally but also ethically sound. As an advocate, you must not forget that your duty does not only lie towards client but also the court. To the young members of the bar, I would only say that keep upskilling yourself as you move up the ladder. The practice of law is constantly evolving domain, and you must remain equipped to deal with the emerging areas and challenges. You may have a number of apprehensions as you enter the profession, but always remember that the profession rewards merit and merit alone in long run. I would also advise the young members to not shy away from taking up new kind of work in your initial years. As an advocate, you must prepare yourself to know all aspects of the practice of law, including client counseling, drafting, filing, and arguing. As you grow up the ladder, you may choose to pick what you like, but in the initial years, be assured that this choice does not exist. Friends, there is a lot that one could say on the subject. However, my experience tells me that sermons don't work as much as the actual practice. One has to step on the ground to understand what practice of law is. But I must assure you all that your merit will never go unnoticed in this profession, and thus keep your focus only on excellence. On this note, I thank you all for giving me this opportunity to interact with you all and express my best wishes to all the members of the bar. I would like to express my gratitude to Honorable Justice D.M. Dharmadhikari, who is present in the audience. And I must tell you that most of the judges from Gujarat who come to Supreme Court, they always say, oh, you are from that court, from where the Justice D.M. Dharmadhikari was. I mean, the kind of respect he enjoys. I am grateful to you, sir, for attending the conference.
Thank you, my lord, for guiding us and highlighting the significance of this conference. I now most respectfully request our chief guest for the event, Honorable Mr. Justice Jitendra Kumar Maheshwari, Judge Supreme Court of India, to please deliver the keynote address.
Brother Justice Felicitation Sharma ji, Justice Aradhe Saab, Chief Justice of the High Court of Madhya Pradesh, Justice Sanjeev Sachdeva, Brother Justice Rajen Menon, Brother Justice V. Kameshwar Rao, Vivek Rushia, Vivek Agrawal, Prashant Singh, Advocate General of the State, Justice Dharmadhikari, former Judge, Supreme Court of India, Honorable Judges, former and sitting Delhi High Court, Honorable Judges, former and sitting Madhya Pradesh High Court, Registrar General and his team, Director General, Director Judicial Academy and his team, Principal District Judge, Jabalpur and his team, Radhilal Gupta, Chairman State Bar Council, D.K. Jain, President High Court Bar Association, Sanjay Agrawal, President High Court Advocates Bar Association, Sri Aditya Adhikari, General Secretary General, Senior Advocates Council, Manish Mishra, President District Court Bar Association, Additional Advocate General, Deputy Solicitor General, Judicial Officers, learned Senior Advocates, Advocate Friends, and the viewers, advocate who are connected virtually, gracious ladies and gentlemen. जब जबलपुर आने की बात होती है तो रुशिया साहब ने जो कुछ भी बताया ये तो कुछ नहीं है, ऐसा लगता है कि अपने घर जा रहे हैं। और घर जाने के लिए हम क्या नहीं करते, तो यदि मैंने कुछ कर दिया तो ये मान के चलिए कि ये कहने की बात नहीं, ये तो मुझे अच्छा लगा कि मैं आप लोगों के साथ कम से कम मुखातिब हो सका। शुरुआत सोचता हूँ कहाँ से करूँ। जब मैं प्रोफेशन में आया तो हमको जो कहा जाता था वो ये कहा जाता था, एडवोकेट इज जस्ट नॉट अबाउट स्पीकिंग, इट्स बीइंग हर्ड। बात आती थी कि क्या, व्हाट इज टू बी हर्ड, क्या मोर देन ए लाउड, more than a clever words, more than a confidence. In fact, it requires professional competence. When I was looking this topic, well designed, you see how steps have been given to this advocacy and professional competence, pursuits of excellence for advocates. Advocacy, then professional competence. When you have a competence, then go pursuit for excellence. Just I was analyzing this, I thought it is a topic well designed. Probably Justice Sachdeva and Vivek may have this application of mind, what is to be done for the advocacy. They want to brought every advocate with professional competence towards excellence. This is the thought process, and I think this must be a theme of today's, if I am not incorrect. I thought, what is this speaking heard? I can tell you one thing. A well-prepared argument carries more conviction than a loud one. This profession is not just like something ordinary profession. It's a profession of commitment. Why it is commitment? Question comes, why commitment? Commitment for so many reasons. What you are, it is connected with dispensation of justice. Where from? It is from the courts, but it only the court can do everything. मेरी नज़र में नहीं हो सकता. सिस्टम न्यायपालिका है तो एडवोकेट उनकी आत्मा है. और मैं हमेशा जब भी आता रहा बहुत रिक्वेस्ट करता था, और वो हमेशा एक कॉन्फ्रेंस रखते थे और मुझसे वायदा लेते थे कि आप आएंगे चीफ साहब. उनका वायदा था, इनको मालूम है लास्ट कॉन्फ्रेंस इन्होंने इंदौर रखी थी, मैंने कहा मैं आऊँगा, मैंने वायदा दे दिया. मुझे मालूम था कि मैं आज के लिए मुझे बहुत टफ है, लेकिन वायदा था. और बात ये नहीं कि मुझे आने में कोई परेशानी हुई, बात ये है कि मैंने अपनी फील्ड में जो कुछ भी पाया आप लोगों से, ब्रदर जजेस से, डे टू डे अपने आप को कॉम्पीट किया और अपने आप को यहाँ खड़ा किया. तो मैं अकेला क्यों? इट शुड बी एवरीवन. I myself is nowhere until institution is there. An institution coupled with both, जब हम देखते हैं तो उसमें दोनों चीज़ें होती हैं कि जुडिशरी और एडवोकेसी. चलिए अब मैं बात करता हूँ कुछ एडवोकेट्स की लाइफ की क्या होती है शुरुआत. लाओ त्जू ने कहा था कि द जर्नी of 1,000 miles begins with one step. Now we started with one step. What was the reason? मेरा थिंकिंग प्रोसेस था कि जब भी एडवोकेट्स आते हैं दे प्रिपेयर देमसेल्फ, हम भी करते थे, लेकिन अभी जिस तरह की रिगनस ट्रेनिंग हाई कोर्ट जुडिशियल ऑफिसर्स को देता है, आई थॉट द एडवोकेट इज आल्सो पार्ट ऑफ द हाई कोर्ट. विदाउट एडवोकेसी nothing can possibly be done. Any good judgment, if it is delivered, the preparation of the advocates is paramount therein. So how it is to be proficient? Advocates must be proficient. Once this training was started, and this may be a way of conferences, today's conference we are discussing so many issues, that may be better for everyone. What is the reason for the advocates? When you stood, जब आप कोर्ट में खड़े होते हैं तो आपके सामने 3 चुनौतियां होती हैं. फर्स्ट, मैं इसको ड्यूटी भी कह सकता हूं. पहली आपकी आपके मुवक्किल के प्रति, दूसरी कोर्ट के प्रति, और तीसरी सत्य के प्रति. मुवक्किल के प्रति आपका दायित्व तो है, लेकिन सत्य को तोड़ना आपका अधिकार नहीं. आपको जो करना है वो कुछ इसके बीच में है. और ब्रदर आलोक आराधे ने शिवकांत शुक्ला के जजमेंट का उदाहरण दिया. मैं उसका दूसरा पहलू आपके सामने रखा. दूसरा पहलू उसका यह है कि आपका सोचने का दृष्टिकोण ऐसा होना चाहिए, करने का दृष्टिकोण ऐसा होना चाहिए कि लोग सोचने को मजबूर हो जाएं. जब जजमेंट यहाँ से गया, मध्य प्रदेश ने कहा कि फंडामेंटल राइट कैन नॉट बी सस्पेंडेड और अफेक्टेड. इट वाज रिवर्स्ड. और जस्टिस HR खन्ना ने डिसेंटिंग ओपिनियन दिया था, और वो डिसेंटिंग ओपिनियन 2017 में अप्रूव हुआ. बात वो थी जो सोचने को मजबूर कर दिया था. और ये एक एडवोकेसी का जो पहलू है ये ज़रूरी है. और क्यों ज़रूरी? इसलिए है कि इस सब के पीछे था कौन? वो आम जनता थी जिसके साथ ये किया जा रहा था. और जब उस जनता के साथ ये किया जा रहा था तो एडवोकेट्स का जो ओवरऑल बैकबोन है वो है उनकी क्लाइंट्स. किसी ने बहुत अच्छी 2 लाइनें कही हैं, मैं आपके साथ शेयर करता हूँ. उन्होंने लिखा है, सितारों के आगे जहाँ और भी हैं, सितारों के आगे जहाँ और भी हैं, अभी इसके अदालत में इंतहा और भी हैं. तुम जीत के जश्न में खो मत जाना, तुम जीत के जश्न में खो मत जाना, तुम्हारे इंतज़ार में मजलूम बेजुबां और भी हैं. आपको जो करना है वो मजलूम बेजुबां के लिए करना है जो आपकी ओर देख रहे हैं. अब बात करें कैसे करें. एक बार देखता हूँ सुप्रीम कोर्ट का पैटर्न थोड़ा डिफरेंट है. फाइलें पढ़ के जाना पड़ती है. जब घर पर फाइल पढ़ता हूँ तो देखता हूँ कि वकील साहब ने अपनी रात दिन सब कुछ गंवाया और केस बनाया, और कितनी मेहनत की होगी उस केस को बनाने में, जिसको हम 1 मिनट में डिस्कार्ड कर देते हैं. नो 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 नो, नथिंग डूइंग, सॉरी, प्लीज़ कम टू दिस. रेखा जी देख रही हैं, आजकल हमारे यहाँ मुक्ता जी अपियर होती हैं, वो देख रही हैं. जितेंद्र माहेश्वरी जी का कोर्ट ऐसे ही है. बात ये नहीं है. मैं एक एडवोकेट्स के लिए एक बहुत इंपॉर्टेंट बात कहना चाहता हूँ. आप एक करेज होना चाहिए. मुझ में था, मैंने ये किया, और मैं अपने आप को बात शेयर कर रहा हूँ. वी शुड नॉट से आई डोंट नो, एंड दिस इज ए परस्यूट हियर स्टार्टेड. आई डोंट नो व्हाट शुड यू शुड से दैट आई विल फाइंड आउट. आई विल फाइंड आउट. then you will have this commitment with yourself. You will find out. You will find the answer of everything. What you prepared, that is fine. But you have to go ahead in the field of law, technology, human psychology, communication skills, ethics, culture, and economics. Without economic, in these days, this litigation pattern has entirely been changed. बिल्कुल चेंज हो गया है. हमको ये सोचना ही होगा कि कैसे करेंगे. When I talk this profession, competence, study, everything is fine. But ethic is the backbone of competence. I am using the word ethic is the backbone of competence. Why? It is necessary. There is no excellence without ethic. I am coming to that path. There is no excellence without ethic. There is no advocacy without integrity. There is no competence without honesty. Once you have all this in yourself, I feel the कर्मण्य वादिका रस्तु, you will go, परिणाम आपके सामने ही होंगे. और आप सब जानते हैं क्या परिणाम किसी केस में जीत जाना परिणाम है? नो. जीतना हारना एक पहलू है, लेकिन इस सब से हटके डिस्पेंसेशन ऑफ जस्टिस, हम एक्सेस टू जस्टिस की बात करते हैं जब भी हम लीगल सबसे अथॉरिटी में होते हैं. अभी मैं कर्नाटक गया था, मैं वहाँ का गार्डियन जज हूँ, वहाँ गया, मैंने देखा बड़ा अच्छा कुछ काम हो रहा है. मैंने सीजे साहब से भी डिस्कस किया. तो मेरा कहना ये नहीं है, बात ये है कि क्या हमारा कार्य इस तरह का है कि हम उस मुवक्किल को न्याय दिलाने के लिए अपनी पूरी मेहनत और समर्पण कर रहे हैं या नहीं. और यदि मेहनत और समर्पण हम करते हैं तो आप मान के चलिए कि आपको आगे जाने से कोई नहीं रोक सकता. वकीलों के लिए दो लाइन जो आपको करते हैं, आप न मंजिल से न रास्तों से हैं, अपने हौसलों से जंग. जो सच के साथ खड़ा हो वही है वकालत का ढंग. आप देखो आपको क्या करना है. मैं एक बात आपको आह्वान करता हूँ कि न्यायपालिका की साख केवल जुडिशरी नहीं, आपके हाथ में है. आप इस न्याय के रथ के दूसरे पहिए के रूप में जाने जाते हैं. आपको क्या करना है? 3 लाइनों में. एडवोकेसी इज ए प्रिविलेज, कॉम्पिटेंस इज ए ड्यूटी, एक्सीलेंस इज ए कॉलिंग. इफ यू हैव दीज 3 थिंग्स, भारतीय न्यायपालिका आज विश्व में शिखर पर है. भारतीय न्यायपालिका को विश्व में शिखर पर माना जाता है. मैं जब भी जहाँ भी कभी भी ग्लोबली गया तो भारतीय न्यायपालिका का स्थान बहुत ऊंचा है. तो इस सब के लिए मैं आप सब से आह्वान करता हूँ, प्लीज़ दिस इज अ मूवमेंट एंड मेंबर ऑफ द बार, प्लीज़ गो फॉर ए प्रिविलेज, ड्यूटी एंड कॉलिंग, देन यू कैन अचीव द एक्सीलेंस. थैंक यू वेरी मच एंड आई विल कन्वे माई थैंक्स to Sachdeva ji, Vivek ji and High Court to invite me and to share my views with all of you. Thank you.
Thank you, my lord, for guiding us. Your exemplary vision has been instrumental in shaping our judicial system. I now respectfully request Honorable Mr. Justice Vivek Agrawal, Judge High Court of Madhya Pradesh and Chairman Governing Council Madhya Pradesh State Judicial Academy to propose the vote of thanks.
Good morning to all of you. Honorable Mr. Justice Jitendra Kumar Maheshwari, Honorable Mr. Justice Satish Sharma, Honorable Mr. Justice Alok Aradhe, Judges of Supreme Court, Honorable Justice Rajendra Menon, Chairman Armed Force Tribunal, Honorable Justice Shri Sanjeev Sachdeva,
Chief Justice Madhya Pradesh High Court, Honorable Justice V.K. Rao, Administrative Judge Delhi High Court, Honorable Justice Vivek Rusi, Administrative Judge High Court of Madhya Pradesh at Jabalpur Bench, Shri Prashant Singh, Advocate General, Shri D.M. Dharmadhikari, former Judge of Supreme Court, judges from Delhi High Court, former judges from Delhi High Court, judges from my own High Court, and former judges from Madhya Pradesh High Court, members of the post-bearers of the Bar Associations, senior advocates, members of the print and electronic media, dear advocate friends. It is my privilege to extend a heartfelt vote of thanks on behalf of the Madhya Pradesh State Judicial Academy. If we observe the life of the legal stalwarts, one thing which stands out is their love for learning. You will find it to be a common feature amongst us all. Love for learning, constant introspection, and a desire to add something of value to each day is what makes us important. Their lives remind us that the bar and the bench are inseparable pillars of our legal system, and the continuous learning is indispensable for both. In an era where advocacy shapes social change and legal challenges grow increasingly complex, structured training and professional competence are not only merely desirable, but they are essential. The Madhya Pradesh State Judicial Academy has therefore placed priority emphasis on strengthening legal education, refining courtcraft, and nurturing a generation of advocates equipped to uphold justice with skill, integrity, and compassion. We conduct several training sessions throughout the year targeting different groups of advocates, namely special workshop for advocates who are practicing at the High Court, having experience of less than 5 years, regional workshops for advocates targeting the district and tehsil advocates, amongst many others, so as to help in capacity building. It is in this larger spirit of institutional growth and commitment to excellence that we gather here today. At the outset, I express my deepest gratitude to our Chief Guest, Honorable Mr. Justice Jitendra Kumar Maheshwari, for gracing this inaugural function with his presence. Sir, your insightful keynote and your constant encouragement towards strengthening the justice delivery system inspires us profoundly. We are equally grateful to Honorable Mr. Justice Satish Chandra Sharma for your thoughtful words and for illuminating the challenges and opportunities of the evolving legal landscape. Your guidance adds immense value to the Academy's mission. I also extend my sincere thanks to Honorable Mr. Justice Alok Aradhe for your valuable address and for sharing perspectives that will guide our collective efforts in fostering excellence within the judicial and legal community. A special thanks to Honorable Mr. Justice Rajendra Menon, whose reflections today were both enriching and insightful. Sir, your vast experience and clarity of thought always serve as a beacon for young advocates and officers of the court. I also gratefully acknowledge the inspiring presence and address of Honorable Mr. Justice Sanjeev Sachdeva, Chief Justice of the High Court of Madhya Pradesh. Sir, your leadership, vision, and continued support, along with mentorship, strengthen every initiative of the Academy. My heartfelt thanks to Honorable Mr. Justice Vivek Rusia, Administrative Judge of the High Court of Madhya Pradesh, for the warm welcome address and for constantly guiding the Academy. I am especially thankful to Honorable Judges from the Delhi High Court for sparing their valuable time. We look forward to learn from their enriching experience. My special thanks to our own Purshendra Kauravji, who has chosen to go to Delhi, but we still treat him to be part of Madhya Pradesh High Court. We are thankful to all dignitaries, guests, academicians, members of the bar, and participants whose presence has added grace to this occasion. I am thankful to Shri Prashant Singh, Advocate General,
and members of the bar for their wholehearted support and encouragement. I also place on record our appreciation to Shri Dharminder Singh, Registrar General, High Court of Madhya Pradesh, officers of the registry, Shri Umesh Pandav, Director, Madhya Pradesh State Judicial Academy, and faculty members and the dedicated team of the Judicial Academy whose untiring efforts have ensured the smooth conduct of this program. I would also like to thank IIITDM Jabalpur for providing us their space to conduct the conference and the entire team of volunteers. Conduction of a conference is a cumulative effort of many. I may have missed some names, but effort of everyone who has directly or indirectly contributed to organization of this workshop is much appreciated and gratitude for the same. Finally, my thanks to each one of you sitting here today for your participation and your commitment to continuous learning and professional excellence. Before I part, I want to share one thing with my young friends, that now this is an opportunity to grow out of, जिसे हिंदी में कहते हैं, अब समय आ गया है कि आप गमले से बाहर निकलें, बंजर भूमि में जाकर बरगद का रूप धारण करें, आकाश में नई ऊंचाइयां प्राप्त करें और इस प्रोफेशन को जो है एक ग्लोरियस प्रोफेशन के रूप में स्थापित करने में अपना योगदान दें. थैंक यू वेरी मच.
Thank you, my lord. We have come to the end of the inaugural session. I invite all for the high tea. Arrangements for the dignitaries, honorable judges, former judges, president and secretary of bar associations are in the VIP hall, and arrangements for others in the common area behind the auditorium. Thereafter, we shall begin the first technical session at 12:15 p.m. I request Shri Dharminder Singh, Registrar General, High Court of Madhya Pradesh, to kindly escort all the dignitaries to the VIP hall for high tea. Thank you.
Sir, before we proceed to the for the high tea, may I request you that some law students are waiting for us in a
हेलो चालू कर दीजिए। हेलो हेलो ये वाला माइक चालू नहीं है। नहीं नहीं हेलो
Good afternoon. I request everyone to kindly take their seats as we are about to begin the session. I request Shri Dharminder Singh Tada, Faculty Member Senior, Madhya Pradesh State Judicial Academy, to kindly escort our esteemed resource persons of this session on the dais. Thank you, sir. Good afternoon to all. I, Saurabh Kumar Singh, Officer on Special Duty, Madhya Pradesh State Judicial Academy, welcome everyone to the first technical session of the day. The theme of the session is Appreciation of Evidence and How to Conduct Criminal Trial. This session shall be chaired by Honorable Mr. Justice Manoj Kumar Ohri, Judge, Delhi High Court, and shall be joined by esteemed panelists Honorable Mr. Justice Purushendra Kumar Kaurav, Judge, Delhi High Court, and Honorable Mr. Justice Mukta Gupta, former Judge, Delhi High Court. Before we proceed further, may I take a moment to briefly introduce our distinguished chair and panelists. Honorable Mr. Justice Manoj Kumar Ohri was born in 1969 in New Delhi. His Lordship completed BSc Honours and MSc in Physics from Delhi University before graduating in Law from the Campus Law Centre in 1995. His Lordship further completed the prestigious course in English and European Commercial Laws on British Chevening Scholarship at College of Law, York, United Kingdom. His Lordship practiced before the Supreme Court and the Delhi High Court. His Lordship's legal practice covered a wide range including representing the Union of India and high-profile government agencies in significant matters, demonstrating his Lordship's experience in both civil and criminal laws. His Lordship was designated a senior advocate in 2014 and was elevated as a judge of the Delhi High Court on 20th November 2018. Honorable Mr. Justice Purushendra Kumar Kaurav was born on 4th October 1976. His Lordship completed LLB and from NES College Jabalpur in 2001. With a rich practice spanning constitutional, civil and arbitration law, his Lordship has served as Advocate General of Madhya Pradesh and held several important statutory positions. His Lordship was designated a senior advocate in 2017, elevated as Judge of the Madhya Pradesh High Court in 2021 and transferred to the Delhi High Court in 2022. His Lordship brings to the bench a rare combination of intellectual depth and humility. It is noteworthy to mention that his Lordship is the first generation lawyer and has appeared from Tehsildar to the Supreme Court. Honorable Ms. Justice Mukta Gupta was born on 28th of June 1961. Her Ladyship is an alumna of Hindu College and Faculty of Law, Delhi University. Her Ladyship served as Additional Public Prosecutor and Standing Counsel for Government of National Capital Territory of Delhi and handled several notable criminal matters such as Jessica Lal and Nitish Katara. Her Ladyship has significantly contributed to rehabilitation initiative for women, juveniles and prisoners. Her Ladyship was the first ever judge in the country invited to take session in the Lal Bahadur Shastri National Academy of Administration. Her Ladyship is the only non-political lawyer to be featured in the 8th standard textbook of NCERT, being role model of public prosecutor. Her Ladyship is the first woman judge in all over the world to be in the top 50 for the work related to intellectual property in 2020. Her leadership was elevated as a judge of the Delhi High Court in 2009 and retired in June 2023. To welcome our dignitaries, I request Shri Saurabh Bhushan Srivastav, Joint Secretary, High Court Advocates Bar Association, to kindly welcome Honorable Mr. Justice Manoj Kumar Ohri, Judge, Delhi High Court, by presenting a sapling and a memento. I request Shri Devendra Gangrade, Treasurer, High Court Advocates Bar Association, to kindly welcome Honorable Mr. Justice Purushendra Kumar Kaurav, Judge, Delhi High Court, by presenting a sapling and a memento. I request Mr. Kamlesh Bharadwaj, President District Bar Association Damoh, to welcome Honorable Ms. Justice Mukta Gupta, former Judge, Delhi High Court, by presenting a sapling and a memento. I now request the Honorable Chair to kindly address us.
Good afternoon, everyone. I must first thank the Honorable the Chief Justice and the companion judges for this conference on seminal topics. I firmly believe that this not only guide young lawyers, but also is a refresher course for all of us. I've been assigned the task of chairing this first session. My co-panelists have been introduced to you, while Justice Kaurav will give his thoughts on the third topic, which is hearing of accused at pre-cognizant stage in complaint cases under BNSS 2023. Justice Mukta Gupta will throw light on the first two topics, understanding the concept of evidence and pre-trial preparations. I'll be attending on the last two topics. I'll now hand over the mic to Justice Kaurav.
Thank you very much, Justice Ohri sir. Madam Mukta Gupta, former judge of Delhi High Court, from whom we have learnt a lot in criminal law especially. And now she is sometimes attacking our orders in Supreme Court, sometimes she is seen to be defending those orders. But nevertheless, it's a pleasure to be part of the panel and to address all of the young colleagues in my parent High Court. The topic which has been chosen has certain background. The background is that earlier in CRPC, when the magistrate courts were to issue the summon, there was no incorporation of the principle of natural justice. If the magistrate is satisfied on the basis of the material brought before him, he may choose to go 156(3), he may choose to go under 200, but in none of those, the eventuality, he had any right or he had any liberty to take the version of the accused. But with the change of this, the CRPC provisions to now BNSS, which we called Bharatiya Nagarik Nyaya Sanhita, Bharatiya Nagarik Nyaya Sanhita, BNSS, there is a change in the legal regime, and I would like to briefly address the same. But before coming to the main topic, let me remind all of us with the quotes of Justice Oliver Wendell Holmes, who was like 29 years judge of the US Supreme Court and has greatly contributed to the American jurisprudence. What he says is, the life of the law has not been logic, it has been experience. This one sentence of Justice Holmes captures the spirit of the entire justice dispensation system. Why I say so? Because it's not only the syllogism of the legal terminology, it is actually the experience which eventually guides the judges, guides the litigants, guides even to the lawyers. Why we go for some time, a litigant always choose to have the lawyer who has the experience. One may have number of the medals, one may have scored a very good number in his academics, but we always look for the lawyer who has the experience. So the sentence of Justice Holmes actually captures the ground reality, and it says, and therefore, when we present any case, the law may be a little guiding factor. The circumstances may support your case. To some extent, the mind of the judge will also be helpful to understand as to how one has to proceed. But at the top of it, it is the experience of the lawyer as to how a case is to be presented. It is the experience of the judge also as to how to deal with that particular case. It is for this reason I have quoted Justice Holmes. Now our experience also evolves the law, changes the law, so as has happened in the amendment in the BNSS. Because earlier no opportunity of hearing, now there is opportunity of hearing. Now how this opportunity of hearing can be understood with the heading and the caption of this legal provision. Now today this is Bharatiya Nagarik Nyaya Sanhita. This, according to me, this has a certain significance. This is Indianization. Attempt has been made to Indianize the colonial baggage which we were carrying for more than many decades. Therefore, it can be described to be a न्याय संहिता फॉर भारत के नागरिकों के लिए, भारत के नागरिकों के लिए अप्लाई की जाने वाली न्याय संहिता. Therefore, it is called भारतीय नागरिक न्याय संहिता. And this particular section to which I am going to deal with is, this is only 22 words. In section 223(1), there's a proviso. All of you, I need not to read it. All of you can go log in from your the Google device. But it is exactly 22 words. But this 22 words, I think as of now, has already been interpreted in more than thousands of pages. The pages after pages are being written by the jurist. The various articles are being written as to how these 22 words will have to be interpreted. Like our article 21 in a constitution, that is also a very small article, but look at the literature which is available now. Now proceeding further, the question may occur as to why the opportunity of hearing at section 200 stage is available. One may argue that look, the cognizance is not the punishment. The magistrate will take a cognizance, then the charges will be framed and the trial will be conducted. The accused in any case will have a right at a later stage to put forth his case. All this can be considered. And it is for this reason the one will have to keep in mind that yes, at the charge framing stage also he will have a right. At the trial stage also he will have a right. But now at the very inception, a provision has been inserted to nip in the bud the frivolous litigation. Sometime a case which actually from its prima facie reading doesn't make out any offense, then why the notice should be given to the other side? Because as we understand, even issuance of notice or a summon or taking cognizance itself sometimes results in causing a greater punishment than the actual punishment which one has to undergo. Like 5 years, if one has to undergo a trial, after 5 years he may be acquitted or he may be punished with a smaller like fine. But the 5-year mental agony which one have to suffer, it is just to deal with this kind of mischief, this provision perhaps has been inserted. Now, in the case of R.R. Chari, the 3-judge judgment by the Supreme Court, Justice Kania, the first Chief Justice of India, he said that I don't want to define cognizance because this cognizance itself has, multiple, sometimes it is being interpreted that, the moment magistrate applies his mind, he looks into the allegation, he passes even one order that the complaint is received, this itself is a cognizance. Sometimes the court say no, this is not a cognizance. When the notice actually issued, then only the cognizance. And like 75 years before, Justice Kania said, I don't want to define it. His exact word is, and I have no desire now to attempt to define it. It has some significance. Because cognizance has not been defined neither in the erstwhile CRPC nor in the present BNSS. Now under 200, as I said, one may frame a complaint in a way where the magistrate is forced to take a cognizance and thereafter one may suffer 5 years, 6 years because he doesn't have any remedy. He has to challenge it in the superior court. When he challenges the superior court, we all know how those like the challenges at an interlocutory stage we consider. We normally say, all right, you'll all have a right to defend, go for a trial. Then the next is like what steps now after the change in the CRPC, now in BNSS, the magistrate will have to take. I am just describing it by way of an example. Whether notice to accuse is to be issued before or after pre-summoning evidence. A very crucial question that comes to the lawyer's mind, to the magistrate mind, like a complaint is presented. A complaint is presented, there is a provision which says the accused is to be heard. Now what the magistrate should do now? One may say that a moment complaint is presented, you don't do anything unless you hear the accused. Please issue notice, please issue someone to the accused. And if you issue someone to the accused at that point of time, this itself may amount to taking of a cognizance. To deal with this situation, and what I am telling is just on the basis of the overall experience, because this is now emerging law and there are divergent opinion by different high court. Therefore, I am not taking you through those decisions. I am just explaining as I understand from the plain and simple interpretation and looking at the kind of mischief which may occur in future. A complaint is presented. On perusal of the complaint, magistrate finds that look, no offense is made out because this is for eviction or this is for encroachment removal. This is for recovery of the money. How a complaint is made out? No offense is made out. He can immediately reject the complaint. That is the one stage which the possible view which the magistrate may take. But if the magistrate thinks, no, there is something, some substance, then according to me, he should not venture into recording the statement immediately. He should then send the notice, that is to 23(1), to the accused. Then let the accused come. Then the question will occur, then what the accused will do in that case? Will you do a mini trial? The answer is no. What the accused at that stage will do is, he will simply sit quiet in a court and in his presence, the magistrate will proceed to record the statement of the accused, statement of the complainant, and if any witness is produced. The moment this exercise is conducted, and if the magistrate finds, yes, there has to be further proceeding, then immediately he can call upon the accused. Yes, what do you have to say? Then accused will say, please allow me to cross-examine these witnesses. Can he do it? The answer is no. Because that will happen after either at the stage of framing of charge or after the charges are framed. And if the magistrate allows the cross-examination, there are some judgments which say no. Can the accused at that point of time produce any documents to satisfy the magistrate, look, the allegation of such and such date, on this date I was abroad, this is the passport. Can he consider it? Prima facie this seems to be reasonable explanation of the allegation, but law does not permit. This, according to my view, is as good as the provisions of Order 7, Rule 11 of the Code of Civil Procedure. Then what the purpose of the accused being heard? What the purpose of issuing him notice? The purpose of issuing him notice is, again, answer lies in 711, the analogy I would say, where on the basis of the material produced by the complainant, if the accused is capable of establishing that, look, even you accept this entire the complaint, no offense is made out. Yes, that can be considered by the magistrate then and there, and the complaint can be dismissed. But he will not venture into taking into consideration the material, evidence, cross-examination, all this. This is what as we understand. Then there comes a few examples as to, like illustration I would like to, let's say a complaint is filed alleging criminal breach of trust by a society treasurer for depositing members' contribution, for not depositing members' contribution. On receiving notice under 223, the treasurer points out that the society audit reports of the subsequent year, which is incidentally on record, clearly establishes that in a subsequent year, even the complainant himself shows that the amount was received. The amount may have been received on a particular date, but the account shows, yes, it was received, it's only delay in the payment, can the offense is made out. The accused at this stage, without pointing out any new material, only on the basis of the complaint material itself, is able to show that no offense is made out, the complaint can be dismissed then and there. The second example, a complaint alleges cheating by a hospital administration for cancelling a surgery and pocketing part of the advance money. The accused, after being issued a notice, points out that the complaint itself shows that the refund receipt issued after some delay. The magistrate again declines to take cognizance. This is the approach which the magistrate should undertake. And while deciding these cases, arguing these cases, dealing with these cases, one has to keep in mind that in India, around 2 crore 94 lakh criminal cases are pending before the magistrates in India. And around 14 lakh cases are pending before the courts of session judges and magistrates in Madhya Pradesh. And out of those 14 lakh, 12 lakh cases are pending before the magistrates court in Madhya Pradesh. And if the magistrate is asked to undertake this repeated exercise, I think it would further delay, which is not the mandate of this amendment. The amendment mandate is to nip in the bud the litigation, frivolous litigation, and also to ensure that the timely justice is delivered to the victims. And if we do this repeated exercise, according to me, the same would frustrate the very purpose of the amendment. Now, there may arise certain questions which I have already answered in the discussion, but just to conclude it, because we are already running short of time, just to conclude it, concluding the remark, I would frame a question and then answer. Thereafter, if something like some more queries are forthcoming, then we'll try to answer at the end of it. Like a question can be whether notice to accuse is to be issued before or after pre-summoning evidence. The answer, yes. Before pre-summoning evidence is recorded, the notice has to be given to him. Question number 2, whether notice is to be issued by moment complaint is received and registered or after some basic inquiry into its merits. Without doubt, after some basic inquiry is done. What is that basic inquiry? I have already told. One has to look at whether this is a case for encroachment, whether this is a case for only recovery money, recovery of money, or whether this is case of some like sort of eviction, where no offense is made out, he should immediately reject those complaints. That is the minimum inquiry which he may undertake. Then question number 3, what would be the extent of the involvement of the accused at this stage? For instance, whether an accused can produce evidence at this stage, or question complainant's evidence documents. As I have already explained, this is similar to 711 application, and the accused is to be heard only to show the defense in the complaint. No additional document can be seen, no reply can be filed, no cross-examination can be permitted. Allowing this would surely delay the trial. Question number 4, whether the accused should be made aware of all the material against him in order to provide him a reasonable opportunity, that is adequate opportunity. The answer is yes. One may say, I have given you complaint copy. No sir, you please give the entire set of documents, even the whatever document you have placed. Yes, there is no doubt that if the hearing is to have any meaning, then the complainant statement, the accused, other witnesses, and all other documents relied upon by the complainant will have to be given to the accused. The next question is there an application of mind envisaged before issuance of notice to the accused, or is the order to be passed mechanically the moment a criminal complaint comes before the court? As we explained before, the issuance of notice must be after judicial mind and has already been applied to the complaint. It cannot be passed in a mechanical manner. In case the accused chooses not to show up, will her rights be waived off? In some cases, after even notice, one may not appear. The broader overarching purpose must always be remembered that I have already explained: expedite hearing and speedy justice. If the accused, despite service of notice, has not appeared, naturally the magistrate may proceed. However, that does not mean mechanically cognizance can be taken. The last question is, will this lead to a mini trial before trial? The answer is no. In my opinion, there will be attempts to make it into a mini trial by one of the counsels, one of the parties, but judges must guard against it. The lawyers also have to guide them that no, at that stage there should not be a mini trial. Otherwise, in CRPC or now in BNSS, at the stage of the issuance of summons or taking cognizance, it's a brief order which is required to be passed. There is no necessity of passing a detailed order. Otherwise, that will eventually prejudice the case of the parties. This is how I understand. But at the end of it again, I repeat the opening remark to re-emphasize that all this will have the fundamental bearing significance with the experience of the society, experience of the lawyers, experience of the litigants, experience of the judge. This, all of it, once is like put into, applied into a particular matter, then the order emerges, and that is all I wanted to explain. Thank you very much for all of you for giving me patience hearing.
Thank you, Justice Kaurav, for sharing your eloquent thoughts on the rights of the accused at the stage of cognizance. What we used to have at the stage of charge, the accused now can argue from the documents and the complaints produced at the time of the complaint that no case is made out. I'll try to take the next two topics, which is trial management and effective submissions. As we all understand, As we all understand, trial management from point of view of a lawyer would be to control the direction, flow and pace of the trial. What it does ensure that a fair and effective administration of justice, and also that evidence is collected and presented in a systematic manner. Timely examination of witness is integral, as while fresh testimony carries authenticity, long delays on the other end breed inconsistency and hostility. Day-to-day recording ensures accuracy and prevents external influence. Prevention of delays lead to reduced wastage of court's time and higher disposal and reduced pendency in courts, speedy justice for litigants, and more bandwidth for lawyers to take up new matters. Effective trial management also ensures minimization of errors and discrepancies, which will be important even at the appellate stage. There are two stages in a criminal case. One is pre-trial and post-trial. Pre-trial involves registration of FIR, investigation, filing of charge sheet, cognizance by magistrates or sessions. Stages in trial would include opening of a case, discharge of framing of charges, plea bargaining and plea of guilty, prosecution evidence, statement of accused, followed by defense witness, and then final arguments and judgment. For the lawyers at this stage, I would advise, we have often seen many OTT programs where based on law, where abroad we have opening statements and closing statements. Though we don't have this structure here, but opening statement and closing statement define your roadmap. It gives an idea to you as to what is to be argued, what is your best point, and also to the judge as to what is coming. Procedural management requires document collection. The very first stage is the documents which are handed over at the stage of 207 in a state case, where police report, documents, FIR, statements under 161, 164. Any document forwarded to the magistrate along with the police reports are generally seizure memos, arrest memos, site plans, photographs, forensic reports, medical reports, post-mortem reports. In case any voluminous document, code or sensitive document, in case the court says, then its inspection can be granted. Next comes documents which are handed over by the client. Some are public documents like birth and death certificate, land records, government communications. Certified copies can be used under Section 76. In case of private documents such as contracts, letters, bank records, need and proof of execution and authorship under Section 67 to 73 of the Evidence Act. Electronic evidence such as CCTV recordings, call records, WhatsApp chats, emails, social media posts must be accompanied by Section 65B certificate. The plea of alibi, if it's available, has to be taken at the first instance, and in this regard, clients normally rely on CDRs or CCTV footage, which get destroyed periodically. In case in the investigation, police doesn't collect these documents because these are majorly defense documents, then appropriate applications need to be moved before the court concerned so that these can be preserved and can be used at the appropriate stage. Preserve metadata, hash values, timestamps, to avoid disputes about tampering. Every photograph taken has a metadata in the form of hash values and timestamps, which defines when was the photograph taken and its place. It has a unique number. Then verification of original documents. The source of evidence is to be verified, chain of custody is to be maintained. And I've seen many lawyers maintaining an evidence register, noting the source, date of collection, purpose to be used at the appropriate stage in the trial. Keep a digital backup. The documents scanned, sometimes are lost. It can be used in cloud storage if feasible. Ensure that you don't become an unwitting participant in any forgery or altered document being placed on record. Sensitize. It's the duty of a counsel to sensitize the clients not to engage in this dubious practice. It may lead to complaints under section 340 and a fresh case against the client. Development of legal strategy. After assessing your documents, the defense counsel has to prepare defense strategy on the basis of which he would conduct the trial. Some strategies are like denial of actus reus, that is where you challenge the identity of the accused, providing an alibi, making the occurrence of act by the accused impossible, discrediting physical evidence. It can be denial of mens rea, where the act is not denied, but highlighting the absence of motive, malice, and portray the incident as a mistake or accident. Providing an alternative account of the incident, developing a counter narrative by using independent witnesses, pointing out the contradictions in the prosecution witnesses, and alleging framing. Attacking the flaws and lapses in the investigation. This includes delay, improper chain of custody of documents or exhibits, lack of public witnesses, non-compliance with statutory safeguards. Contending non-fulfillment of ingredients of the offence is another thing what a lawyer should look at. Jurisdictional and other procedural objections, and then general objections under IPC, like plea of juvenility, which again has to be taken at first instance. In case your client turns out to be only 18, then procedure under Juvenile Justice Act, section 94. Unsoundness of mind, self-defense, these are general exceptions in the IPC. Next comes witness preparation. Prepare a witness chart with the name and the purpose for which witness is to be cited and to be crossed. One has to keep in mind that witness is cross-examined on the basis of their 161, 164 statements. One has to be thorough with what improvements, what contradictions, what inconsistencies are there, how statements, previous statements of two witnesses during investigation also contradict each other. Conduct a background check of witnesses. Sometimes we have seen in there are stock witnesses produced by police. Official witnesses, they who routinely make this testimony in a mechanical manner, largely in PC Act cases where a shadow witness or independent witness is required. I've seen where witnesses ask these questions as to in how many cases you have appeared as a witness, as a shadow witness, and the answer comes, and this sometimes helps the accused. During trial, there are types of witnesses, like interested witness. We can discredit an interested witness by showing the motive for false implication. Conduct a background check on the witness to see whether they are interested, if there are any animosity, criminal antecedents, or financial gains to be made. Independent witnesses, one has to try to accept a favorable admission without antagonizing them. Hostile witness, one who doesn't support the case of the prosecution. Let them harm the prosecution case on its own by deposing as freely as they can. Experts witness like doctor or a forensic expert. Official police witnesses, and then the accused has a right under 315 CRPC to produce his own witness, or he can appear himself. I'll now come to the next topic, which is effective submissions. This is the most crucial topic, most crucial stage in any criminal case. It is the culmination of all your hard work which you have carried through the trial. As it was said in the earlier session, that it is the mastery of facts which one must practice. Know your case file inside out. When a court asks a particular document, you should be able to respond with precision. Every court, every judge appreciates this. Research the law thoroughly. This means more than reading the statutory section. Know not just what precedents say, but why they say it. Be prepared to explain why an adverse precedent should not apply. Anticipate opposing arguments. Put yourself in opposing counsel's shoes, what we call devil's advocate. What will they argue? What weak points exist in your case? You have to prepare them thoroughly. Then understand the procedural history. Know what orders have been passed in the case, what directions were earlier given, and whether they were complied with. Courts respect advocates who grasp the complete timeline. Fumbling through papers is again seen very unprofessional. Begin always when you make submissions, you also at that time must have a roadmap as to how to initiate, how to start argument. The lead always give your strongest point first. Normally the cases are lost or won in the first few minutes only. If you are able to catch judge's attention with your strongest point in the first few minutes, you will not have much difficulty. Court may not have patience sometimes. What matters most in appeals, address the arguments with the highest likelihood of success first. In bail applications, get straight to the test, nature of accusation, severity of punishment, as Justice Maheshwari said, and earlier speakers, and Justice Menon, that sometimes even basic document like FIR is not read and whole argument is made. Present facts with precision. Facts are crucial but also must be economical. Focus on material facts, those relevant to the legal issues you will raise. Be chronological wherever possible. It aids comprehension. Be absolutely accurate. Moment a judge catches an inaccuracy, credibility suffers and irreparable damage occurs. When you cite legal authorities, it is not the quantity as to how many judgments you cite, but the quality which matters. Read full judgments, but not only the head notes. Those who only skim head notes are noticed. State the ratio precisely. If a judge goes against you, acknowledge it. Explain why it should not apply through factual distinction, obiter status, or subsequent overruling. Judges appreciate advocates who help them reach correct legal position even against their client's interest. Respect the court's intelligence. Do not misquote. Do not take passages out of context. These do backfire. Do not assume. Carry citations with you. Do not assume. Sometimes during the course of submissions, lawyers sometimes cite case law without giving a copy. Do carry physical copies or place them on record digitally. Structure your arguments logically. Think syllogistically. Major premise. For example, major premise, section 103 of BNS Act provides that. On facts, in this case, the evidence. So the argument should be developed. Therefore, the ingredients of section 103 have been met or not met. This logical structure helps courts follow reasoning and make submissions more persuasive. Answer, I'll take the fifth topic. Answers questions directly. This is perhaps the most important aspect of oral advocacy. When a judge asks a question, answer it directly. Do not evade, do not say, I am coming to that. Answer first, then elaborate if necessary. If you do not know the answer, say so. Judges respect honesty. As earlier session Justice Maheshwari said, that I do not know, you can be converted to, I'll find out. If you do not understand the question, ask for clarification. When judge asks hypotheticals, engage seriously. Listen actively, maintain composure. examination in chief. Prepare your witness before the trial, familiarize him with the facts, questions that will be asked, and the process of testifying. However, do not engage in tutoring the witness. When you ask questions, what, when, where, who, why, how, this allows the lawyers to control the logical flow of testimony without asking leading questions. Ensure that key facts are established. Ask follow-up questions. If your witness omits to mention any key detail, do not shy from taking permission of court to cross-examine them or put a leading question. Introduce documentary evidence. What has not been put by the prosecution, you can always put. Cross-examination. This is heart and soul of any trial. The cases are won at this stage. This is what it decides, not only the trial but also the appeals. Leading questions can be put but not open-ended. Establish your goal for witness who you wish to cross-examine. One has to see whether cross-examination of a witness is required at all or not. I remember an incident where a witness had turned hostile. The prosecutor, with the permission of court, asked a question if his statement given at the stage of 164 was truth or not. He said yes. The defense lawyer asked a question if he was prepared by the IO or the APP for this leading question, to which he answered no. There was no need for this question. The testimony which is said in the court is what becomes the evidence and not the earlier statements. You can always, cross-examination, one must decide the goal, whether you want to discredit them by showing them their uncreditworthy and unreliable, whether you want to dilute their testimony by getting them to admit minor inconsistencies or bias, whether you intend to extract some favorable admission or neutralize some harmful points. Depending on goal, you can decide whether you want to do a constructive cross-examination or a destructive cross-examination. They, on the lighter side, they say a good cross-examiner is a poor dinner guest. Constructive cross-examination and deconstructive cross-examination. Constructive cross-examination is when you, while cross-examining a witness, you are trying to draw out a helpful testimony from an adverse witness. Cross-examination should feel like a conversation and not an attack. Destructive cross-examination is when you attempt to control an adverse witness and damage their credibility, but not to us. This is probably even in cross-examination, the most crucial thing what a lawyer must remember. I'll give some examples which I have noticed in practical life. While dealing with an appeal, I was going through the cross-examination. The reading of it would show that defense was trying to discredit a witness, established that the witness was not present at the spot, and simply added to the list. He had not seen the incident of stabbing. The witness was asked in cross-examination, were you present on the spot at the time of the incident? Witness said yes. The whole cross-examination or the whole case stood proof with this one wrong question. And this is from a practical experience. While I was dealing with the appeals, I noticed this, and this obviously returned to a conviction. Next example: why did you go to the police station next day? Because I was scared for my life. That's why. Why questions invite explanations and make the witness look reasonable and honest. Ask questions. Asking questions without knowing their answers is again detrimental to the client's interest. For example, how many people were present there? Around 50-60 people saw the accused beating the victim. You never ask something that can produce new harmful facts. Repeating the examination in chief, you said you saw accused at 9 p.m., correct? Witness would say yes, and the accused hit the victim, yes. You are reinforcing the prosecution story by repeating it. I'll stop and add one more example. A very leading lawyer, while cross-examining, asked the witness, was it this knife or some other knife? The witness answered, this knife. That was the end of the trial. Things to keep in mind while cross-examining. These are various techniques: soft cross-examination, storytelling cross-examination, or impeachment cross-examination. I'll not dwell much on that. Then the written submissions. When you have made your submissions, oral submissions, one must try to give written submissions. But one must remember the purpose, the length, language, style, citations, then the relationship between oral and written submissions. What make arguments persuasive? It is your, as I already said, that it is your thoroughness with the facts, the case law you cite, and how you collate your facts with the law. What courts expect from advocates? Assistance, respect for time, practical consequences, fairness, preparedness for difficult questions, civility and courtesy. Relationship between bar and bench is not adversary. Both are partners in administering justice. Judges need good advocacy to reach correct decisions. Advocates need fair judges to get justice for their clients. When judges create an atmosphere where good advocacy is valued, the quality of arguments improve. The good judgments always come when there is a good assistance. When judges maintain ethical standards, advocates naturally follow. Similarly, when advocates are intellectually honest and ethically sound, judges depend on their submissions even when deciding against them. This relationship requires mutual respect. Effective submissions are both art and science. Science lies in thorough preparation, systematic organization, accurate citations, and logical reasoning. Art lies in presentation, communication, persuasion, and ability to connect with the court. But beyond art and science, effective advocacy requires character, honesty, integrity, courage, and commitment to justice. These qualities cannot be taught, they must be cultivated through conscious effort and ethical practice. Treat the responsibility with respect, prepare thoroughly, argue honestly, present effectively. With this, I end, and I hand over the mic to Justice Mukta Gupta, who used to be our go-to person, whether we were in doubt or crisis, she would be always available.
Thank you, Justice Ori. Good noon to everyone. At the outset, let me thank Chief Justice Sanjeev Sachdeva and his companion judges for calling us as a part of this interaction. And let me tell you, by this interaction, if you are richer with our experience, we'll be also going richer with your experience. It's always interactive, and we learn a lot when we go back from here. Whether it's criminal law or civil law, one must understand many a times you appear for a marginalized sections. So one thing you must understand, those people do not know the niceties of law or what fact is relevant, what should be done, what is better for them. Give a very patient hearing, because you may understand that he or she may not know, but you will be able to point out from those facts what is relevant and what is admissible, what is legal, what would be in the best interest before drafting a petition, complaint, evidence, anything. So give a very patient hearing and then start drafting it. A good lawyer is one who is good on facts, who has good command on facts. Law always comes later. Today, many of your petitions you will see people start with law, but will that law apply on the facts is the main issue. So if you're clear on facts, most of the judges and everybody knows the law, but the law will follow later on. So be clear on the fact. And thirdly, it is very essential that you stand for the rights of people who are marginalized. You should have the guts to say what is the problem. Many of times parties don't even spell out what is the real problem. And you may get them the relief, but if the real problem is not solved, that relief is meaningless. Now, I'll start with the two subtopics of the day. This session, understanding the concept of evidence and pre-trial preparations, understanding the case, witness preparation, and document management. What is evidence? The Act defines the Indian Evidence Act under Section 3 and Section 2(1)(e) of the Bharatiya Sakshya Adhiniyam, which I will now call as BSA, defines evidence, but it's an inclusive definition. What it says is evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to the matters of fact in inquiry, which is called oral evidence, and all documents including electronic records produced for the inspection of the court, which is called documentary evidence. Do you think that this definition is a complete definition of evidence? It is in fact not an exhaustive definition. It's a very sketchy definition. Entire Evidence Act is required to define what is evidence. Now, when a person is making an oral statement in the court, how does he make it? It is what he perceives through his five senses. He or she perceives through his five senses, whether it was seen, whether it was heard, whether it was smelt, whether it was tasted, or whether it was felt. You will say that how a feeling can be expressed. Some of the witness will say, आप पूछो कि कौन से महीने में हुआ था, वो कहेगा गर्मी का महीना था. तो उसने महीना तो नहीं बताया आपको, जून का था, मई का था, पर ये तो बता दिया कि सीजन ऐसा था जो उसने फील करके बताया कि गर्मी का महीना था. So this is, it's an expression of your senses. Based on these things, the Evidence Act or the BSA, which is almost paramateria the same except reorganizing and additions of the electronic evidence into it, can be divided into 5 distinct conceptual divisions. Firstly, understanding the concept of definition of what is a fact in issue, what is a relevant fact, and what is a fact relevant to the fact in issue. Secondly, what is relevancy, admissibility, and reliability of evidence. Thirdly, proof of facts, whether it's a proved fact which has been further disproved or a fact not proved. Then the witness's competence, then presumption and onus of proofs. Now coming to fact in issue and facts relevant to the fact in issue. आपको कोई भी केस प्रूव करना है तो आपको जैसे X ने Y को मारा, that is a fact in issue, पर उसको प्रूव करने के लिए बहुत सारे facts adjoining आते हैं. जैसे किसी ने नहीं देखा तो X 5 मिनट पहले उस जगह पे गया था जहाँ Y था. That is not a fact in issue, but that's a fact relevant to the fact in issue. So जब आप इस सारे वेब को बुनते हैं, बनाते हैं, तभी आप अपनी स्टोरी पूरी क्रिएट कर सकते हैं. So जब आप अपने क्लाइंट को सुनते हैं तो पहले उससे पूछिए मेन प्रॉब्लम क्या है, मेन फैक्ट इन इशू क्या है, फिर उन फैक्ट से देखिए कि उन फैक्ट इन इशू को क्या क्या फैक्ट्स रेलेवेंट हैं जो सपोर्ट करके उस फैक्ट इन इशू को प्रूव कर पाएंगे। ना कोर्ट में आप एविडेंस सिर्फ रेलेवेंट फैक्ट का दे सकते हैं, आप हर किसी फैक्ट का नहीं दे सकते, सिर्फ रेलेवेंट फैक्ट का दे सकते हैं जो फैक्ट इन इशू के लिए रेलेवेंट है या फैक्ट्स विच सपोर्ट द फैक्ट इन इशू। सेक्शन 6 से लेके सेक्शन 50 तक इंडियन एविडेंस एक्ट और बीएसए सिर्फ यही एक्सप्लेन करता है कि फैक्ट इन इशू या उसके सपोर्टिंग फैक्ट्स क्या हैं। एक्स को यहाँ से भागते हुए जाते देखा, दैट्स अ कंडक्ट, सो इट सपोर्ट्स द फैक्ट दैट ही वाज हियर एंड ही वाज इन अ हरी गोइंग फ्रॉम हियर। ऑफन जब हम करते हैं हम रेलेवेंसी, एडमिसिबिलिटी एंड रिलायबिलिटी में डिफरेंस भूल जाते हैं। कोर्ट में आप सिर्फ रेलेवेंट फैक्ट का एविडेंस दे सकते हैं, ये फर्स्ट स्टेज होती है एडमिशन की। फिर देखा जाता है कि वो जो रेलेवेंट फैक्ट है वो एडमिसिबल भी है कि नहीं है। एक्स एक्यूज ने स्टेटमेंट दी कि मैंने ये जुल्म किया है, मैंने ये ऑफेंस किया है, इट्स अ रेलेवेंट फैक्ट, it's a confession, but whether it is admissible, if it is not admissible, again it's strucken off. So you have to see, जैसे इलेक्ट्रॉनिक एविडेंस का है, जब तक आपका 65B का सर्टिफिकेट नहीं होता था या 63 BSA का सर्टिफिकेट which is slightly more elaborate now नहीं होगा, तो आपका वो फैक्ट इलेक्ट्रॉनिक एविडेंस का चाहे रेलेवेंट है, बट जब तक आप वो सर्टिफिकेट नहीं आएगा एविडेंस में वो एडमिसिबल ही नहीं होगा। तो सेकेंड थ्रेशोल्ड आपके लिए होता है कि उस फैक्ट जो रेलेवेंट है उसको एडमिसिबल करना। तीसरा फैक्ट जो होता है उसके बाद स्टेज जो आती है वो रिलायबिलिटी ऑफ फैक्ट आती है। एक रेलेवेंट फैक्ट आया, उसके बाद वो एडमिसिबल हो गया, फिर वो कोर्ट देखती है कि हाँ ये रिलायबल है कि नहीं है। उस रिलायबिलिटी के लिए भी आपको पूरी मेहनत करनी पड़ती है। आप उस रिलायबिलिटी के लिए उसको सर्टन थिंग्स से सपोर्ट करते हैं। अब मैं आपको एक छोटा सा एग्जाम्पल देती हूँ। एक कमरे में 4 जनों ने एक जने का पिस्टल से गोली मार के मर्डर हुआ। गेट पे 100 मीटर दूर 2 जने खड़े हैं। एक कहता है मैंने उसको गोली मारते देखा, दूसरा कहता है मैंने आई हर्ड द शॉट एंड एक्स फेल डाउन। अगर एक पिस्टल बड़ी है जो आप देख सकते हैं तो जो पहला विटनेस है वो सही कह रहा है, पर अगर पिस्टल इतनी है कि आपको दूर से दिख ही नहीं रही है, किसी को लेड बुलेट 100-200 मीटर से नहीं दिखती है, उसको तो वो यही दिखता है कि पर्सन गिर गया, तो देन व्हाट ही वाज सेइंग द अदर पर्सन कि आई हर्ड द शॉट एंड एक्स फेल डाउन, then that witness cannot be discounted as an eyewitness and he or she is a truthful witness because आप उस एक्शन को परसीव ही अपनी ईयर से कर सकते हो। आप एक शॉट को हियर करते हो, आप देखते नहीं हो लेड बुलेट को, कोई भी नहीं, उसकी वेलोसिटी और उसकी डिस्टेंस से इतनी जल्दी परसीव करना हर के बस की बात नहीं होती है। तो टू से अगर राइफल से मार रहे हैं शूट करके, देन द पर्सन सेइंग कि हाँ मैंने उसको मारते देखा इज रेलेवेंट। नाउ व्हेन वी टॉक अबाउट रिलायबिलिटी, जनरली पीपल से कि ओरल एविडेंस है, आई विटनेस अकाउंट है, तो ठीक है बिल्कुल हो जानी चाहिए, बट लेट मी टेल यू, कोई भी केस आपका जब तक आप उस आई विटनेस की रिलायबिलिटी को नहीं सपोर्ट करोगे तो आपका मिनट में ख़त्म हो जाएगा। आपको कुछ ना कुछ डॉक्यूमेंट्री सर्कमस्टेंशियल एविडेंस से सपोर्ट करना पड़ेगा। आज तक मैंने नहीं देखा कि कोई एक्सक्लूसिवली सिंपलीसिटर ओरल एविडेंस आई विटनेस अकाउंट पे केस टिक सकता है, क्योंकि हर केस में कहीं ना कहीं सर्कमस्टेंसेस बुने हुए होते हैं. आई विल गिव यू वन अदर एग्जाम्पल. उस इंसान को डेथ सेंटेंस हुई, सुप्रीम कन्वर्ट कर दिया लाइफ सेंटेंस में. बट व्हाट वाज द फैक्ट्स ऑफ द केस? हस्बैंड वाइफ और दोनों के पेरेंट्स ने इकट्ठे डिनर किया. दोनों के फादर्स ऊपर छत पे सोने चले गए. रात को हस्बैंड वाइफ डॉटर रह गई 8 years की. एंड थोड़ी देर बाद उन्होंने चिल्लाने की आवाज़ सुनी. वो नीचे आए तो जो लेडी थी हु वाज 7 months प्रेग्नेंट, वो उसको स्टैब इंजरीज थी. जो बच्ची थी 7 साल की, उसको स्टैब इंजरीज थी. द हस्बैंड वॉजंट देयर, हस्बैंड वॉज आउटसाइड. सो दिस इज नॉट अ केस ऑफ आई विटनेस. किसी ने नहीं देखा. ऑब्वियसली जो लड़के का फादर था, एविडेंस में ही टर्न्ड हॉस्टाइल. नाउ द टेस्टिमनी ऑफ ओनली विटनेस वाज of the father of the girl. That father, the plea was taken कि वो तो यहाँ रहता ही नहीं था. He is a planted witness. Now these are circumstances when you look towards documents. Incident हुआ रात के 10 बजे. फादर का घर दिल्ली से 50 किलोमीटर दूर था, पर within 15 minutes of the information to the police, उसने उसको नियरेस्ट हॉस्पिटल में अपनी डॉटर को एडमिट किया. वो MLC पे नोटेड था. दिस वॉज वन क्रूशियल फैक्ट विच वॉज रिक्वायर्ड टू बी शोन कि देयर प्ली इज कि ही वॉज नॉट प्रेजेंट, बट द फैक्ट दैट ही वॉज प्रेजेंट इज प्रूव्ड दैट within 15 minutes he is the one who is admitting that girl. His presence is over there. So what they all perceived, they heard, they immediately saw. The fact that उस टाइम जब ये इंसिडेंट हुआ तो कमरे में सिर्फ हस्बैंड वाइफ बच्ची थी, और इमीडिएटली इंसिडेंट के बाद हस्बैंड नहीं है और वो दोनों पड़े हैं. एविडेंस एक्ट सेक्शन 106 में उसको ओनस हस्बैंड पे डाल देता है दैट नाउ यू आर टू एक्सप्लेन, बिकॉज दीज आर फैक्ट्स अंडर योर स्पेशल नॉलेज. सो इवन इफ इट वॉज नॉट अ केस ऑफ आई विटनेस अकाउंट technically, but the circumstances which created around that case showed that no other person except that husband was the guilty one, and his conviction till the Supreme Court was upheld. Now imagine if you don't take care of these incidental documents which are filed in the trial court, or ignore, then it becomes very, very difficult, either in favor of the accused or against him, or you don't highlight, such a document is not proved. So it is very important to look into each and every document and then see how it connects to the fact in issue. So based on these things, 5 concepts, the Evidence Act gives you interplay between section 6 to 55, and it says things connected with the fact in issue as part of the same transaction, or transaction, occasion, cause, effect, motive, conduct, state of things and persons, relation of things, opportunity for occurrence, preparation, time, place, and identity of things or persons, including those which rebut or support an inference from the preceding, are relevant facts and relevant to the fact in issue. And unless there is a bar on admissibility, every relevant fact is admissible in evidence. And the more relevant facts you build up in your case, the more reliability quotient will be there. So please understand the difference between these three concepts of relevancy, admissibility, and reliability, and you have to cross all these three stages to get the best results. Under section 6, there's something called res geste evidence. I don't know how many of you have come across that, but it's a very important piece of evidence. Some facts are so intertwined, like I gave the first example कि उन्होंने गेट पे देखा, उसके बाद accused भागता जा रहा है, तो simultaneously the witness runs and says, "Oh, the chubby man in the white shirt, white t-shirt and blue jeans has killed so and so and is running, catch hold, catch hold." This is admissible in evidence despite the fact it is hit by hearsay, but as an exception, this evidence, if it is too proximate in time, is relevant and admissible in evidence. इसी basis पे section 10 of the Evidence Act, which gives the theory of agency, conspiracy, आप लोग सब conspiracy के cases करते होंगे और कितना difficult होता है. X and Y ने कुछ act की, A and B ने कुछ की, but it's a complete chain. A doesn't know what X has done and Y doesn't know what B has done. But on the basis of theory of agency, each one will be responsible. But to get into this theory of agency, one of the fundamental principle is there has to be a strong inference from the fact that each one knew the object of that conspiracy. So, फिर अगर उनका minimal participation भी है, and there is a participation and they were working in furtherance of a common object, then each one on the basis of this theory of agency will be liable. Of late, I am seeing a very disturbing trend. We all know a statement to the police officer, which may call confession statement, disclosure statement, is not admissible in evidence. Only that portion of the statement is admissible which leads to discovery of a fact, and to that extent I need not explain the judgment in Pullu Korikotaya still holds the field. What is coming forth is in affidavits, disclosure statements of the accused are treated as evidence and said, look, this is the evidence collected by the prosecution. So please take careful, be clear on the facts and find out if it is a disclosure statement which has led to no recovery, it is inadmissible, it cannot be taken into consideration, and it is your duty to point out that this is an inadmissible piece of evidence which cannot be looked into, because pursuant thereto there is no discovery of fact. Now, we have in most of the cases expert witness. What is important to see in the case of an expert witness? Opinion of an expert is relevant, but that is never binding on the court. Court may or may not accept that opinion, because then that comes into the import of relevancy of that evidence. Now to make, reliability of that opinion evidence. Now to make that evidence should or should not be relied upon, what you need to show is cross-examine the expert thoroughly. He must show that he has knowledge in that special science or technique, then that he applied the proper technique. The opinions of the experts are written later on, but when they are performing the test, they keep rough notes. Insist that the witness should get that rough notes because they are the contemporaneous documents, and once those rough notes are available, you can cross-examine and find out whether there is a difference between the rough notes and the final opinion given by that witness. Then, whether this witness has an expertise or not in that field, you can cross-examine the witness on that aspect. Based on the interplay of these provisions and the decisions of the Honorable Supreme Court, 13 principles can be culled out for appreciation of evidence. I'll just hurriedly tell those principles. While appreciating the evidence of a witness, the approach must be whether the evidence of the witness read as a whole appears to have a ring of truth. Once that impression is formed, it is undoubtedly necessary for the court to scrutinize the evidence, more particularly keeping in view the deficiencies, drawbacks, and infirmities, and whether the credibility is shaken. If the court before whom the witness gives evidence had the opportunity to form the opinion about the general tenor of the evidence, that's why they say trial courts must write the general tenor. Please point out that, note the tenor of this witness. Then the appellate court should give due weightage to it. When eyewitness is examined at length, it's quite possible for him to make some discrepancy. Nobody can make a parrot-like statement. But court should bear in mind that these are mere discrepancies and they are not incompatible with the credibility of the version. Minor discrepancies on trivial matters need to be ignored. Too serious a view to be adopted on minor variations is unrealistic. The witness cannot be expected to possess a photographic memory. Now let's take, for instance, most of the incidents happen on the spur of the moment. X sees a portion of it, Y sees another portion of it. जैसे वो example है, एक ने हाथी की पूंछ देखी, एक ने उसके दांत देखे. So everybody doesn't see the entire, but that doesn't mean what portion they are speaking. And if they are not able to speak about the other, that their evidence needs to be discarded. So please appreciate in that context. Then people are overtaken by course of events, and all these things need to be ignored. Then we must know the onus of proof. The onus of proof is in the civil or a criminal case. Criminal, it's on the prosecution, and in a civil case, it is with the person who asserts the fact, except for the exception of 106, which I gave you the example, and 114 of the Evidence Act. There is yet another way to classify the evidence, direct and indirect. Direct, as I said, oral, but then you've always to support it with indirect. Primary and secondary, that's for documents. Oral and documentary, real, original, and hearsay. The main task comes in today's time is when we are dealing with evidence of which is not real in nature. You can produce a document, but when a chip it is written, how does one see? And I'm sure your Chief Justice will take one of the sessions on this kind of evidence, which is today's testing time, that this evidence, which is the real world, and the virtual world, how to make a distinction and how to find out the various aspects out of it. So with these, I would like to just sum up that unless we get to know the basics and we are clear on the facts, we cannot apply all these principles and take our client out of the into a winning streak. Secondly, put yourself dedicatedly into the facts of the case and then see what law is applicable. And we, I think, have some 5-10 minutes. The house is now open to all of you to ask any question what you want to ask.
Thank you, Justice Mukta, for taking us through. Even this turned out to be even a refresher course for us to have gone through the nuances of Evidence Act. Before that, I asked Justice Kaurav if he can recollect any experience of in
No,
trial or
I
cross-examination.
think let us the participants to raise a question, and at the end of it, if time permits, then I'll
Any questions,
give my 1 or 2 examples. Yes.
Yes. Please give them the mic.
हेलो सर, पहला मेरा ये क्वेश्चन है सर कि पहले जो सीआरपीसी थी उसमें 200 के तहत स्टेटमेंट रिकॉर्ड होते थे, और अभी जो है इसमें डायरेक्ट अगर एक्यूज्ड को नोटिस होते हैं, आरोपी को नोटिस होते हैं, इससे फॉल्स केस रजिस्टर्ड होंगे और बाद में वो कहीं ना कहीं दबाव बनता है उसमें। पहले ये होता था कि पहले रजिस्टर्ड परिवाद रजिस्टर्ड कराना पड़ता था, न्यायालय ये देखती थी कि केस बनता है कि नहीं बनता। तो मेरा पहला ये एक क्वेश्चन है। दूसरा क्वेश्चन ये है कि जहाँ एमएलसी होती है ये एक्यूज्ड की, तो आजकल क्रिमिनल ट्रायल में ये देखा जा रहा है कि एमएलसी में एफआईआर की समरी लिखी जाती है कि इस व्यक्ति को ऐसी ऐसी चोट आई है, चाकू से मारा है या गन शॉट है, तो डॉक्टर के नॉलेज में पहले से वो चोट आ जाती है। तो उसमें एमएलसी, मेरा ये सजेशन सर कि उसमें इस तरीके से नहीं होना चाहिए। डॉक्टर अपना पर्सनल ओपिनियन दे कि वो चोट किस प्रकृति की है, किससे मारा है, उस समरी में सारी जानकारी हो जाती है।
पहले मैं सीआरपीसी, यस, आपका कहना बिल्कुल सही है, और ये जो अमेंडमेंट का मंतव्य है ये बड़ा पवित्र है, और ऐसे बहुत सारे संशोधनों का मंतव्य होता है, लेकिन उसके बाद जो लिटिगेशन जनरेट होता है उसको हैंडल करना भी बड़ा मुश्किल होता है। जैसे फॉर एग्जांपल 12A कमर्शियल कोर्ट एक्ट, उसमें प्रावधान है कि आप मीडिएशन में जाओगे, प्री मीडिएशन में कमर्शियल डिस्प्यूट है, लेकिन उन केसेस में जहां अर्जेंट रिलीफ आपने क्लेम किया है आप सीधे सिविल सूट दायर कर सकते हो। लोग आते हैं, एक एप्लीकेशन लगाते हैं, प्लीज़ ग्रांट मी एग्जम्पशन फ्रॉम 12A, क्योंकि मैंने अर्जेंट रिलीफ प्रार्थना की है। अब वो अर्जेंट रिलीफ प्रार्थना की है, उसने एक एप्लीकेशन लगा दी, मुझे ये फला फला स्थगन दे दो आप, तो दूसरा पक्षकार आता है, बोलता है साहब अर्जेंसी यही नहीं है, ये तो 4 महीने पहले भी इनको ये रिलीफ मांग सकते थे वो। तो उस पर पहले बहस होती है घंटों, फिर जज साहब का जजमेंट आता है 15-20 पन्ने का, तो एक ये स्क्रूटनी हो गई, इसकी कोई ज़रूरत थी नहीं। अगर ये मंतव्य था तो ये जब लॉ डेवलप होता है तो ऐसी अनोमली क्रिएट होती है। यहाँ पर भी आपका कहना सही है, और मैंने इसको पहले जब बात कर रहा था तब इसको थोड़ा एक्सप्लेन भी किया कि ये भी इमर्जिंग लॉ है, ये अनोमली है, लेकिन अगर वहीं पर जैसी कंप्लेंट आई और आपने पहले स्टेटमेंट रिकॉर्ड किया, फिर आपने नोटिस दिया उसको, तो वो तो टेकिंग कॉग्निजेंस हो गया। सुप्रीम कोर्ट को बोलता है कि आपने चूंकि दिमाग अप्लाई कर दिया आपने, यू हैव ऑलरेडी अप्लाइड योर माइंड, वंस यू अप्लाइड योर माइंड एज पर द सुप्रीम कोर्ट इट्स टेकिंग कॉग्निजेंस, देन द एक्यूज विल कम, ही विल से कि हाउ कैन यू टेक अ कॉग्निजेंस, यू हैव नॉट गिवन मी नोटिस। So it is for that reason I have very specifically emphasized that this is how this law has to be understood, so as to avoid the anomaly, so as to align with the mandate which the amendment seek to achieve, but it will take some time to take its the final shape. But your question is very pertinent.
So coming to the second question. Yes. As far as noting of the in the MLC of the entire FIR is concerned, the doctor is not supposed to note the FIR in it. Doctor has to note the history given by the patient. So history given by the patient is noted. Now, if the patient is unconscious, people who take the patient, whatever their version is, that is noted. So many a times when the victim is unconscious, whatever the version police gives, they noted that. But if you see the column below it is observation. They are the independent observations of the doctor कि कहाँ कहाँ चोट है, lacerated wound है या gunshot injury है, prima facie, वो सारा देते हैं. Then if they need, they refer to X-ray or further opinion. Finally opinion देते हैं simple है या grievous है. So it's the history to be given by the victim, and in the absence of the victim, the one who takes it. Now unfortunately accused के case में जब वो होता है तो accused तो खुद है ना, वो अपना बताए उसको कैसे लगी है, उसको कोई रोकता थोड़ी है, तब तो डॉक्टर और accused है, अंदर पुलिस थोड़ी है. He must protest कि ये मेरा, मैं जो कह रहा हूँ मेरा वर्जन लिखा जाए. So उस टाइम एंड आज के टाइम जैसे ही अरेस्ट होता है accused, information is given. The counsel is there. If the counsel is there, he can say that this is not his version. Please write his version. Because अगर आप accused का वो कर रहे हैं, MLC कर रहे हैं, तो जो accused का version है वो note होना चाहिए वहाँ.
सर एक क्वेश्चन और था सर, जो चार्ज लगता है, अपराध विवरण बनता है, उसमें भी न्यायालय द्वारा लिखा जाता है कि मैं ऐसा ऐसा, तुमने जो कृत्य किया है वो भारतीय दंड संहिता की धारा 302 के तहत आता है. तो वहाँ भी न्यायालय कहीं ना कहीं अपना विवेक मन, मतलब न्यायालय का माइंड तो यूज हो जाता है.
See, at the stage of charge,
जी सर,
the trial court has to come to a prima facie finding that a case is made out and case is fit for trial. Unless the court expresses that mind, it will be considered a non-application of mind in case the facts of the case or the exact charge is not stated. This also helps the accused or the defense counsel to know as to what is to defend. The charge is not only for the purpose of prosecution but also to help the accused as to what he has to defend. Any other questions, please?
My question, Madam
With
spoke
the permission of the Honorable Chair, maybe the last question, please.
My question is to Madam that you just spoke about Section 10 of Evidence Act. Do you think that this section needs to be reframed in the light of modern technological development? Because what Section 10's disastrous effect is that it led to acquittal of prime suspect in Mrs. Indira Gandhi's case as well as Mr. Rajiv Gandhi's case also. So do we think that this section needs to be reframed? Because we have done extensive amendments in our criminal law.
See, BSA retains that section as it is. There is no amendment which has been brought in the BSA also. This section is based on the theory of agency. And conspiracies are always hatched in secrecy. That is the biggest problem. Now with the advent of electronic evidence, most of the conspiracies are unearthed. At that time, we didn't have so much of electronic evidence like the phone call details, how to get into their data and all. Probably today, I don't think, because this theory of agency, which is the principle behind it, otherwise many other accused, if we reframe it, will go out of the net.
Last question, please.
मेरा क्वेश्चन सर जस्ट मैं क्वेश्चन नहीं, एक समस्या है. समस्या ये है कि अब सारे जो आईपीसी, सीआरपीसी, एविडेंस, इनके नाम बदल गए. स्थिति ये है कि हमारा सफ़र पूरे होने वाला है और हमारा लास्ट टाइम पे हमारा बोगी नंबर बदल दिया गया और सीट नंबर बदल दिया गया. अब
आपकी समस्या के तो हम भी भागीदार हैं ना, हम भी एग्जिट मोड में हैं, पर हम सीख रहे हैं. अभी सुबह सेशन में बताया था ना कि इस प्रोफेशन में टिल द एंड यू आर लर्निंग. सो अब हमें फिर से दोबारा सीखना पड़ेगा. इट्स अ चैलेंज एंड लेट्स एक्सेप्ट इट. हम भी उसी एग्जिट मोड में जिसमें आप हैं, पर हम भी सब सीख रहे हैं.
I seek permission of the Honorable Chair to close the session.
I think the Chief Justice wants to
say. Time for the Chief Justice to say something.
Yeah, Chief Justice wants.
All right. Thank you, everyone. Thank you.
Thank you, Lordship.
Thank you.
As we move to the end of the session, on behalf of the Madhya Pradesh High Court and Madhya Pradesh State Judicial Academy, I extend heartfelt gratitude to the Honorable Chair and esteemed panelists for sharing insights and enriching us with their valuable expertise. I invite all for the lunch. Arrangements for the dignitaries, honorable judges, former judges, and President Secretary of Bar Associations are in the VIP hall, and arrangements for others in the common area behind the auditorium. Thereafter, we shall begin 5 p.m. So please kindly reassemble in this hall by 2:35 p.m.
ये नीचे सब मैं सभी प्रतिभागीगण से निवेदन करूंगा कि कृपया अपने अपने स्थान पर बैठ जाएं। हमारे अगले सेशन के पैनलिस्ट हमारे मध्य उपस्थित हो चुके हैं। Namaste. We welcome everyone to the second technical session of this conference, Writs and Road to Supreme Court. The title of the session is Writs and Road to the Supreme Court. This session shall be chaired by Honorable Mr. Justice V. Kameshwar Rao, Judge, Delhi High Court, and joined by esteemed panelists, Honorable Mr. Justice Subramaniam Prasad, Judge, Delhi High Court, and Honorable Ms. Justice Rekha Palli, former Judge, Delhi High Court. Let me take a brief moment to introduce our distinguished chair and esteemed panelists. Honorable Mr. Justice V. Kameshwar Rao, a BA Honours and LLB graduate from Delhi University, was an accomplished practitioner in service and administrative law before the Honorable Supreme Court and various high courts. His Lordship was designated Senior Advocate in 2010, elevated to Delhi High Court in 2013, and later transferred to Karnataka High Court, and served as Acting Chief Justice in 2025, before joining Delhi High Court in the same year. Honorable Mr. Justice Subramaniam Prasad, a BCom Honours and LLB graduate from Delhi University, was an advocate on record since 1996. His Lordship served as a Standing Counsel and Additional Advocate General for State of Tamil Nadu and was designated Senior Advocate by Supreme Court in 2015. His Lordship was appointed Judge of Madras High Court in 2018 and transferred to Delhi High Court in 2020. Honorable Ms. Justice Rekha Palli, an alumna of Hindu College and Campus Law Center, was designated Senior Advocate in 2015 and elevated to Delhi High Court in 2017. Her Ladyship played a pivotal role in Delhi's COVID-19 management and has represented India internationally in arbitration and environmental law forums. Her Ladyship retired in 2025. To welcome our dignitaries, may I request Mr. Sudhir Pandey, Secretary, District Bar Association, Dhammo, to kindly come forward and welcome Honorable Mr. Justice V. Kameshwar Rao by presenting His Lordship a planter. Since we would be welcoming and felicitating other esteemed panelists for the first time in the conference, I request Shri Suyash Sanjay Chaurasia, Advocate District Bar Association, Mandla, to kindly welcome Honorable Mr. Justice Subramaniam Prasad, Judge, Delhi High Court, with a planter and a memento as a mark of our gratitude. Thank you very much, sir. Moving ahead, I now invite Mr. Nikhil Kachwa, Advocate, District Bar Association, Mandla, to kindly welcome Honorable Ms. Justice Rekha Palli, former Judge, Delhi High Court, by presenting her Ladyship a planter and a memento. We are deeply honored to have such an eminent panel with us today. May I now request Honorable Chair to kindly address us.
Thank you, Anirudh. First of all, I think we must thank the Honorable the Chief Justice, Justice Sanjeev Sachdeva, and all the judges of the Madhya Pradesh High Court for giving this opportunity and hosting us for this conference. And I must say that we are delighted on the gathering of all of you for this occasion. Well, on my right is Justice S. Subramaniam Prasad, a judge of the Delhi High Court. On my left is my sister, Justice Rekha Palli, a former judge of the High Court of Delhi. Now you have the topic which we intend to interact is Writs and Road to Supreme Court. हमें ज्ञात है कि ये जो इंटरेक्शन हो रहा है एकदम लंच के बाद हो रहा है. I know the difficulty, to sustain yourself. So we decided that हम इसको interactive session बनाएंगे. And for that purpose, people would be at liberty to ask any questions so that we can answer it. That will become more in two ways. Now the topic is writs and roads to Supreme Court. जो फर्स्ट impression आता है इस टॉपिक का कि what is the remedy a litigant has for going to the Supreme Court. एंड जब रेमेडी की बात आती है तो आपको सबको पता ही होगा, रेमेडी होगी आर्टिकल 32 जो बेसिकली होती है आर्टिकल 32 एंड आर्टिकल 136. नाउ आर्टिकल 32 इज ए रिट जुरिसडिक्शन ऑफ द सुप्रीम कोर्ट फॉर वायलेटिंग एनी ऑफ द फंडामेंटल राइट्स. आपको पता होगा कितने नेचर ऑफ रिट्स हैं. और 136 जो होती है कि जो कि एक अपील प्रोविजन है विच इज़ प्राइमरीली बेसिकली ऑन ए सब्सटैंशियल क्वेश्चन ऑफ लॉ विच इज़ बीइंग फाइल्ड बिफोर द सुप्रीम कोर्ट अगेंस्ट एनी ऑर्डर पास बाय द कोर्ट, और ट्राइब्यूनल के ऑर्डर के खिलाफ भी आप सुप्रीम कोर्ट जा सकते हैं. बेसिकली दीज आर द टू ब्रॉड रेमेडीज विच आर जनरली अवेल्ड बाय लिटिगेंट गोइंग टू द सुप्रीम कोर्ट. बाकी और भी हैं प्रोविजंस 131, 133, 134. ऑल्दो एक प्रोविजन है where the reference is made by the president to the Supreme Court, we may not be really concerned with that kind of a provision. There are provisions relatable to between the dispute between state to state. Possibly we will not be really concerned. आज के दिन हम जो concentrate कर रहे हैं basically what are the remedies which are available going to the Supreme Court for a litigant, and also a little bit of provisions, a little bit of discussion on Article 226 of the Constitution, because ultimately the High Court here, being a constitutional court, आपको पता होगा और आपने avail भी करी होगी ये remedy under 226 to approach this High Court. थोड़ा सा हम reflection देंगे जो suo motu power exercise करती है High Court, और पब्लिक इंटरेस्ट लिटिगेशन पे भी. पब्लिक इंटरेस्ट लिटिगेशन दो तरीके की हो सकती हैं. एक वो हो सकती है जो कि you will recollect way back maybe somewhere in 1975-76 Justice Bhagwati has propounded on the basis of a letter written which is we call it Bandhwa Mukti Morcha, a public interest litigation का concept originate करा था जो आज के दिन तक भी लागू है. एक वो होगा. दूसरा है जो कि PIL जो कि एक litigant फाइल करता है in a larger public interest. So ये basically हमारा topic of discussion होगा. And I will only request my brother Justice Subramaniam Prasad to give in brief his views on the topic.
Thank you, Justice Rao. Good afternoon to all of you. First of all, thank you for inviting us to interact with you all. And as Justice Rao said, the session post lunch and after that was sumptuous lunch is generally you attract sleep. And we promise you to make it as entertaining and as interesting as possible. Now, when the topic, as Justice Rao said, is writs and way to Supreme Court. Now, since I was born and brought up in Supreme Court, from day one I was in Supreme Court till I became a judge. And I know that many of you and many youngsters here would be interested in, at some point of time, shifting to Supreme Court also. So a bit of the interaction will also be as to what do you keep in mind when you want to shift or intend to start in Supreme Court. Many counsels who have established themselves and would like to go for greener pastures, when they want to go to Supreme Court, what they have to keep in mind, what is the Supreme Court thought process, how to approach, how to tackle the Supreme Court is another aspect of which we would like to dilate on. So wishing you all a good and a happy session. Thank you.
Oh, sorry. Am I sorry? Yeah, now I will request my sister Justice Rekha Palli to give her views in brief.
Thank you, Justice Rao, though I had to remind you to tell me to start. That's okay. A very good afternoon to everybody. First, I must पहले तो आपके चीफ जस्टिस को मुबारकबाद दूंगी, नॉट पर्सनल रीजन से, पर इसलिए कि उन्होंने इतना अच्छा टॉपिक चूज़ किया, आर्ट ऑफ एडवोकेसी, और आप सबको इतने अच्छे से इन्वॉल्व किया. हम दिल्ली में भी बहुत सारे सेमिनार्स कॉन्फ्रेंसेस करते आए हैं, पर लंच के बाद हमने इतना बड़ा हॉल इतना फुल कभी नहीं देखा. तो उसके लिए आप सबका बहुत बहुत आई थिंक धन्यवाद. एंड आई थिंक ये इससे पता चलता है कि टॉपिक भी इंटरेस्टिंग है और आप सबका इंटरेस्ट है कि आप दिल्ली के लोगों को इतने खुले दिल से वेलकम कर रहे हैं. सो आई मस्ट थैंक नो एज जैसे जस्टिस राव ने बताया, हम लोग आपसे बात करने वाले सुप्रीम कोर्ट की रेमेडीज़ के बारे में कि कैसे सुप्रीम कोर्ट जाना है, किस रिट्स कैसे फाइल होनी है, कैसे आप SLP फाइल कर सकते हैं, उस चीज़ पे बात करेंगे। और क्योंकि ये लंच के बाद का सेशन था तो हमने ये सोचा है कि हम सिर्फ प्रेजेंटेशन नहीं देंगे, आप लोग से बातें करने की कोशिश करेंगे ताकि आप लोग को हमारी बात समझ में आए और आपको इस कॉन्फ्रेंस का पूरा फ़ायदा मिले, जिससे कि आप जाएं तो सोचें दिमाग में कि हाँ ये बात हमें समझ में आई और ये सीखने को मिली। तो हम लोग और जैसे उन्होंने बताया कि मैं मार्च 25 में रिटायर होकर दिल्ली हाई कोर्ट से अब मैं वापस सुप्रीम कोर्ट में प्रैक्टिस कर रही हूँ, तो मैं आपसे कुछ केसेस डिस्कस करूँगी जहाँ अब मैं वापस जाके प्रैक्टिस कर रही हूँ एक्सपीरियंस के साथ और क्या नई चीज़ें सीख रही हूँ। तो आई होप आप इस सेशन के बाद एटलीस्ट आप लोग सोच के ये जाएंगे कि हाँ हमें इस कॉन्फ्रेंस में कुछ नया सीखने को मिला जो गूगल से नहीं पढ़ पाए आप लोग खाली, क्योंकि आजकल AI की वजह से सब कुछ, कोई प्रोविज़न के बारे में आपको ढूंढना है तो आप वहाँ से ढूंढ लेंगे, बट आइडिया सेमिनार एंड कॉन्फ्रेंस का ये है कि आप हम लोगों के एक्सपीरियंस से कुछ सीख सके और हम आपसे सीख सकें। I think now this is all.
Yes, now I'll only requesting any moderator who can put the questions and we can put the, we will just, and thereafter we'll put it to the house for any question जो आप पूछना चाहेंगे पूछ सकते हैं आप।
Thank you, Lordship, my Ladyship. In the context of the topics given, my first question to the dignitaries, the theme Gateway to the Supreme Court can be interpreted constitutionally, procedurally, or even philosophically, that is, access to justice. From your perspective, which of these gateways do you find the most complex for a litigant to navigate and why?
Right, I'll take this question. Now, when you say that you want to approach the Supreme Court, the various remedies that are available to you, various avenues are, first, which is the bread and butter of any lawyer at Supreme Court, is 136, which is against any judgment or order of any court or tribunal. And when they say any court or any tribunal, means from a single judge Supreme Court, from a trial to Supreme Court, from a tribunal to Supreme Court. The 136 is a gateway where you can approach Supreme Court from any court. But of course, as a matter of practice, normally the Supreme Court expects one to exhaust their remedies before approaching the Supreme Court and not jump forums. The second, of course, is for enforcement of fundamental rights, which is only in Part 3 of the Constitution. As we go on, we would dilate on the difference between 226 and 32, but yes, 32, any of the writs. So 32 itself comes under Part 3, therefore it's a fundamental right in itself. There are cases galore from Kochunni, Daryao, which says that Supreme Court is sentinel on the quive, which is it's always open to any of the persons to enforce this fundamental right in Supreme Court. As far as habeas corpus is concerned, yes, at any point of time, at any time of the hour, you can approach the Supreme Court. The third avenue, of course, is a dispute between a state and a center, or between two states when you approach the Supreme Court under 131, which is for the purposes of a suit, by filing a suit and to adjudicate that dispute. No doubt, Article 262 bars the river disputes from any other court, and only Supreme Court does it. Covenants are barred to be challenged under Article 363. The third, of course, is that after the Supreme Court, after a High Court decides that it decides to grant a certificate by saying that there's an interpretation of Constitution under Article 133, or by a substantial question of law under Article 134, the certificate being given under 134A. The last one, of course, is the transfer jurisdiction, which is under 25 and 406, 25 of the CPC and 406 of the new BNS is the corresponding provision, or the transfer of any case from one state to the other. The last one being various appeals now being provided, which was not earlier there under the Electricity Act, under the IBC, under the Consumer Protection Act. There are few statutory appeals available. The election of president or the vice president is again called only in Supreme Court. You cannot challenge it anywhere else. So these are the various avenues by which you enter the Supreme Court. That's the.
I'll just add on to this. See, the challenges which जो कुछ सवाल में जो challenges की बात है 136 32 में भी है. 132 में in any case जो Justice Prasad ने कहा था habeas corpus in any case the Supreme Court will entertain because ultimately it governs the liberty of the citizen and the individual. और 136 में जब क्वेश्चन ऑफ लॉ होता है वहाँ क्वेश्चन ऑफ लॉ आपको सेटिस्फाई करना पड़ता है. अगर क्वेश्चन ऑफ फैक्ट होगा कोर्ट कहेगा नहीं वी विल नॉट एंटरटेन. व्हाट इज द क्वेश्चन ऑफ लॉ अनलेस एंड अनटिल वो क्वेश्चन ऑफ लॉ की परवर्सिटी है, कोई एविडेंस नहीं था जिस बेसिस पे हाई कोर्ट ने उस कंक्लूजन पे आ सकते हैं. सो दैट वुड बी ए वेरी डिफिकल्ट टास्क फॉर अस टू कन्विंस द सुप्रीम कोर्ट कि जी हाँ ये 136 मेंटेनेबल होगा. ये थोड़ा सा आपको ध्यान देना पड़ेगा बिकॉज इट वुड बी ओनली ऑन ए क्वेश्चन ऑफ लॉ एंड परवर्सिटी वुड बी a क्वेश्चन ऑफ लॉ.
Thank you for your insights, sir. Speaking of the gateways, the admission stage of an SLP is known to be one of the most restrictive and difficult gateways as per lawyer practicing in the Supreme Court. In your experience,
Would you answer?
in your experience, what generally persuades the court to issue the notice in an SLP? In this context, considering the principles laid down as far back as 1962 in Chuninal Mehta regarding what constitutes a substantial question of law under Article 136, how can one convince the apex court that a matter demands its interference? Do you feel the thresholds for this determination has changed over time, and what strategies or advocacy habits have you found most effective for counsel trying to cross that narrow threshold?
I'll take it. See, the question is कि 136 में सुप्रीम कोर्ट कब इंटरफेयर करता है, क्योंकि जैसे जस्टिस राव ने बताया कि it's a very narrow window. Every case you can go to Supreme Court under Article 136 in every case, but it is not कि हर केस में सुप्रीम कोर्ट इंटरफेयर करेगा. क्वेश्चन आप लोगों के लिए भी ये है सोचने के लिए कि कैसे सुप्रीम कोर्ट को कन्विंस किया जा सकता है कि ये जजमेंट ऐसा है कि इसमें आपको अपनी डिस्क्रिशन एक्सरसाइज करके 136 में लीव ग्रांट करनी है या नोटिस करना है. उसके लिए आई थिंक द मेन थिंग इज द लॉ इज सेटल्ड. इट सेज ओनली व्हेन देयर इज अ सब्सटैंशियल क्वेश्चन, बिकॉज अगर आपने कभी किसी ने एसएलपी बनाई हो तो वहाँ पे लिखना पड़ता है क्वेश्चंस ऑफ लॉ. उसमें लिखना पड़ता है दीज आर क्वेश्चंस ऑफ सब्सटैंशियल इम्पोर्टेंस, दीज आर क्वेश्चंस ऑफ दैट वो लेकिन हर केस में वो नहीं होता. कभी सपोज आपके किसी क्लाइंट की एक दुकान है वो खाली कराई जा रही है, वहाँ पे क्वेश्चन ऑफ लॉ क्या है, वो तो कहेगा मालिक मकान खाली करा रहा है. लेकिन अगर आप एज अ काउंसिल वहाँ प्रैक्टिस कर रहे हैं, ये आप सबके लिए सोचने की बात है, वहाँ प्रैक्टिस कर रहे हैं तो आपको उस क्लाइंट का तो पर्पस ये है कि मेरी दुकान खाली ना हो, या उसके लिए आपको उसको कैसे क्वेश्चन ऑफ लॉ में कन्वर्ट करना है, ये लॉयर्स के लिए आर्ट है. ये वहाँ पे आपको फिर दिखाना पड़ेगा कि जजमेंट में ऐसी फाइंडिंग्स आई हैं जो लॉ सेटल्ड प्रिंसिपल्स ऑफ लॉ के अगेंस्ट है. ओनली देन यू विल बी एबल टू कन्विंस. that is why it is said the gateway to the Supreme Court under Article 136 is most restrictive. But with my experience earlier and now, I can say that if you know how to present your case and the judgment gives you some scope, तो आप उस गेट को खुलवा सकते हैं. इतना मुश्किल नहीं है कि खुलेगा ही नहीं.
Thank you, Ladyship. Speaking of the interference, my next question is, what guidance would you offer young lawyers about balancing the urge to appeal against every adverse order with the understanding that no case warrants recourse to Article 136?
Well, you see, एक पुरानी कहानी है सुप्रीम कोर्ट में. एक केस आया था आरएमडी चमारबाग वाला. उसमें सवाल ये उठा था कि गैम्बलिंग क्या है. बॉम्बे गैम्बलिंग एक्ट में एक केस फंसा था एंड क्वेश्चन उठा था गैम्बलिंग क्या है. तो जस्ट जो मिस्टर दफ्तरी थे उस वक्त सॉलिसिटर जनरल ऑफ इंडिया, उनसे पूछा गया था कि मिस्टर दफ्तरी, अकॉर्डिंग टू यू व्हाट इज गैम्बलिंग. So Mr. Daftari said, gambling is something which is at stake when a person approaches the Supreme Court. So, अगर एक वकील के भांति पूछें कि क्या करना चाहिए, जाना चाहिए कि नहीं जाना चाहिए, ऐसे अब तो जज हूं लेकिन ऐसे वकील कहूँगा जाओ. अब क्यों जाओ? सुप्रीम कोर्ट पे 2 आर्टिकल्स हैं, एक 136 और एक 142. 136 कहता है द सुप्रीम कोर्ट में इन इट्स डिस्क्रिशन ग्रांट स्पेशल टू अपील अगेंस्ट अ जजमेंट और ऑर्डर. 142 कहता है द सुप्रीम कोर्ट कैन पास एनी ऑर्डर टू डू सब्सटैंशियल जस्टिस बिटवीन द पार्टीज इन अ मैटर पेंडिंग बिफोर इट. जब ये 2 आर्टिकल देखते हैं, दैट एक्चुअली मेक्स आवर सुप्रीम कोर्ट वन ऑफ द मोस्ट पावरफुल कोर्ट्स इन द वर्ल्ड. बिकॉज हर चीज सुप्रीम कोर्ट इंटरफेयर कर सकता है और किसी चीज को सुप्रीम कोर्ट इंटरफेयर नहीं कर सकता है. तो इट बिकम्स a court where you balance law, justice and equity. There are also judgments of Supreme Court which says that it is not a court or correction. ज़रूरी नहीं है कि कानून बिल्कुल गलत है, लेकिन फैक्ट्स इतने ग्रॉस हैं, सुप्रीम कोर्ट कहेगा मैं इंटरफेयर नहीं करता. और उसके लिए भी एक रास्ता निकाला सुप्रीम कोर्ट ने कि दैट क्योंकि उन्होंने इंटरफेयर नहीं किया, इसका ये मतलब नहीं कि हमने हाईकोर्ट का जजमेंट मान लिया है या वो लॉ बन गया है. उस केस में सुप्रीम कोर्ट ने इंटरफेयर न करने का फैसला किया है. ये 136 हो गया. 142 है, हाँ माना कानून में शायद अब केस नहीं बनता है, लेकिन फिर भी अगर मैं चाहता हूं कि मुझे आपकी मदद करनी है, फॉर एग्जाम्पल ए विडोड lady in a house who in law is not entitled to any kind of maintenance approaches the court after losing in 3 courts. There are cases in Supreme Court where the Supreme Court in 142 has said, I will grant you some relief. Though you cannot go against law, but the urge to Supreme Court, so therefore now coming to this more serious aspect of it, if it is a completely an interim order, like the High Court has only issued notice. अगर कोई क्लाइंट आपसे कहे कि क्या मैं सुप्रीम कोर्ट में जाऊं, आप कहेंगे नहीं जाओ. क्यों? क्योंकि सिर्फ नोटिस हुआ है, फैसला होना बाकी है, कोई इंटरम ऑर्डर पास नहीं हुआ है, एक एडजर्नमेंट हुआ है. क्या मैं सुप्रीम कोर्ट जाऊं? मत जाओ. अगर ऐसा कोई इंटरम ऑर्डर पास हुआ है जहां पे कोई राइट डिसाइड नहीं हुआ है, नहीं जाना चाहिए. लेकिन हाँ, इफ एनी राइट ऑफ अ पार्टी हैज बीन टेकन अवे, then as a lawyer one would say that we can go to Supreme Court, but of course we must tell the client the chances of being successful is exceedingly remote. With that caveat, you go to Supreme Court, you can go to Supreme Court. Otherwise, as I said, interim order, completely interim order, no rights being affected, so what to go to Supreme Court?
Thank you, Your Lordship.
Just 1 minute, ma'am. अगर यहाँ कोई बैठे हों, एटलीस्ट यंग एडवोकेट्स की बात कर रहे हैं, जिन्होंने SLP बनाई है 136 में, हाथ उठा सकते हैं आप? इन्होंने बनाई है, ऊपर उठाइए. हाँ हाँ, बताइए आप, आपकी क्या अंडरस्टैंडिंग है 136 की? माइक दे दीजिए जरा उनको. या यू कैन ऑल्सो स्पीक. आप ही बात कर सकते. आपने बनाया है SLP?
जी. Lords, my understanding to drafting of an SLP is that the
what was the issue about?
Lords, the issue was with regard
First introduce yourself and then speak in the mic. You're not speaking.
Just introduce.
Lords, my name is Chiranjeev. I'm working as an advocate in MP High Court. Lords, I drafted an SLP with respect to a service matter.
Okay.
The writ appeal was dismissed by this honorable court. Now, Lords, what I understood with the drafting of this SLP was that the fact portion is very limited. The Supreme Court is only concerned with the question of law. Lords, with this follows the question, my lords. What I understood with the Supreme Court's working is that we only get a minute of hearing. No, my lords, what should that a minute would include that the SLP gets admitted?
See, that's the challenge, you know. In the morning, Justice Ori has told you, you should put your best point forward. And if you are convinced you have a point in law, in that SLP, maybe based on fact, saying that this is the fact which makes the interpretation in my favor, you must put forth that. And mind it, ultimately what Justice Prasad has said, not in every SLP, you may have a good case, the court will issue notice. There is one case of KGS Bhatt versus CSIR, Supreme Court saying that this may be erroneous order, we will not still interfere. So it's not necessary every matter the notice will be.
I know, I think I can share an experience जो आप वकीलों के साथ भी होता होगा, बोलते होंगे उस बेंच में लग गया. आज से करीब 15 साल पहले आई थिंक एक दिन मेरे 2 केस लग गए. एक लेबर मैटर था जिसमें मैं मैनेजमेंट की तरफ से गई. लेबर का केस खराब था, मैनेजमेंट का केस अच्छा था, लेकिन वो बेंच में जब गए 136 में थे, कोई बात नहीं, हाई कोर्ट ने गलत किया है, लेकिन 136 में वो बेचारे वर्कमैन हैं, उनको कोई रिलीफ नहीं दे रहा, उनके अगेंस्ट हम नहीं जाएंगे, उनको जो मिला है हाई कोर्ट से जाने दो. और दूसरा केस था टेक्निकली बहुत ही साउंड जिसको कहते हैं बिल्कुल ही वीक केस था, लेकिन इक्विटी पे अच्छा था. अब वो जज साहब कहते हैं कि सॉरी, आपका तो टेक्निकल पॉइंट ही नहीं बनता, लॉ क्वेश्चन ऑफ लॉ ही ओपन नहीं है. तो कभी कभी ये होता है कि आप सोच के जाते हैं, आपको वहाँ पे क्या, ऐसे जैसे राव ने बोला कि क्वेश्चन हो तो भी ज़रूरी नहीं है, क्योंकि सुप्रीम कोर्ट की वहाँ पे डिस्क्रिप्शन आ जाती है.
चलिए उनसे पूछते हैं पीछे जो बैठे हैं. अच्छा आगे दीजिए आप.
He is going to ask us. First, give him a big hand.
I'm not asking a question, I'm just responding to him. You see, in Supreme Court, I was an AOR in Supreme Court, practiced in Supreme Court for a long time. आपने कहा ना, you get a minute in Supreme Court, you get 30 seconds in Supreme Court. And in that 30 seconds, and that is the difference between a senior counsel and a normal counsel, and you say, ये senior क्यों बन गए? Because that 30 seconds, you'll either have the complete attention of the court and get a relief, or you lose the court. So you have to choose every word. When you're going to Supreme Court, your opening sentence, that 30 seconds जो आपको मिलेंगे, that has to be well thought, well chosen. वो तभी होगा if you are fully prepared with your matter, and you should know कि what is it that will appeal to the court. अगर आप शुरू में जी I am so and so, वो 30 सेकंड निकल गए और फाइल गई नीचे. So in that 30 seconds, you have to be very, very careful in what you speak. So Supreme Court advocacy is, you have that 30 seconds will either get you the order, or you will not get an order even if you argue for half an hour. So prepare very well. Choose your words in that 30 seconds extremely well. And that is where the question of law also comes in. When you're drafting an SLP, judges will read the question of law. अगर उन्होंने question of law पढ़ा and they've convinced with how you've drafted the SLP, you'll get notice without even having to open your mouth. So that's how Supreme Court advocacy is very, very skilled.
Thank you, Chief. Thank you very much.
There was one lawyer
Yeah.
I wanted to पीछे. अब उससे पूछ लो, whether he should not feel उसे इतनी बुरी से हालत. SLP के बारे में बोल रहा था.
Good afternoon, judges. My name is Samar Singh Rajput. I'm practicing in MP High Court. I have drafted a matter pertains to a bail. And the question was respect to the instigation, the ingredients. But what I have learned from my experience is basically that I have 30 seconds, and in that 30 seconds, I have to summarize my facts. I have to point out the essential ingredients as well as the facts. So that was my quite a great experience, and I really enjoyed that 30 seconds of my life.
Very good.
Good.
Very good. Keep it up. Keep it up.
Thank you, sir.
See, one thing we must add is this. The judges in Supreme Court, please take it that most of them have read the brief before they come to court. They've read everything. And therefore, they are not the first court. They are the third court. So once they are the third court or fourth court, it's that one small thing which hits them. In law, in equity. And it's that one chord you hit. If you hit it properly, you're through. Otherwise, you're not.
And now, But turning to the heart and soul of our Constitution, Article 32, it has long served as a direct gateway to the Supreme Court for enforcement of fundamental rights. In your experience, how has the court balanced this expanding rights for jurisprudence with the need of judicial restraint?
See, I'll go back. ये जो इस question का answer, I'll go back to the real initiation of public interest litigation, and largely Article 32 has been invoked by the litigants in PIL matters, and the PIL which is relatable to the larger public interest, and the court have actually entertained those petitions. But there are disputes which are basically, interstate disputes between a landlord and a tenant, or a service matter, or a personal disputes. Those are generally view of the, unless and until the petition deals with an interpretation of a statute, will have a larger ramification across the Supreme Court. We generally say that you go to the High Court, get the matter issue decided by the High Court, and then you can come back to the Supreme Court. So this is one way of looking at it, where the 32 has been entertained, 32 have not been entertained. Now we have also said that 32s have been entertained in a matter like habeas corpus also, where the larger public interest is involved. In those matters, Supreme Court generally entertains it. But what has been said is, this is very important. Article 32 itself is a fundamental right. And Dr. Ambedkar has said that this is the heart and soul of the Constitution. That is the provision of 32 which we find in our Constitution, and that basically is the, invoking a fundamental right to go to the Supreme Court. Person can argue, this is my fundamental right, I can go. But the Supreme Court will say that normally, though it is a fundamental right for him to litigant to come to the Supreme Court, पर हम इस केस में इंटरफेयर नहीं करेंगे, क्योंकि आपके पास एक ऑल्टरनेटिव रेमेडी है हाई कोर्ट जाने की, वहाँ ये मुद्दा कराइए. ये ऐसा मुद्दा नहीं है कि जो हाई कोर्ट डिटरमिन नहीं कर सकता. हाई कोर्ट डिटरमिन करेगा. अगर हाई कोर्ट ने डिसाइड कर दिया आपके खिलाफ, आप यहाँ आ सकते हैं. दिस इज बेसिकली हाउ द सुप्रीम कोर्ट हैज डेल्ट विद in petitions governing section Article 32.
I think on that I'll add that Article 32, there are cases, sometimes if you feel this is a question which is arising different high courts में, एक ही तरह की question, then maybe you can try your luck in the Supreme Court and convince the Supreme Court that this is a question जो और भी high court में आएगा and different answers आएंगे उसके, इसलिए आप इसको entertain करिए. Fundamental right तो है ही है, तो petitions entertain होती हैं. एंड कई बार होता है अगर आर्टिकल 226 में भी पिटिशंस अलग अलग जगह फाइल हो गई, तो 32 में आप सुप्रीम कोर्ट चले जाते हैं और सुप्रीम कोर्ट सब पिटिशंस वहाँ ट्रांसफ़र कर लेता है. तो कभी कभी ये भी होता है कि इसलिए भी सुप्रीम कोर्ट आर्टिकल 32 में फंडामेंटल राइट को एंटरटेन कर लेते हैं. दैट
इन एक्सटेंशन ऑफ दिस क्वेश्चन, माय क्वेश्चन टू ऑनरेबल जस्टिस राव, most petitions filed under Article 32 are either public interest litigations, or even though filed in individual capacity, try to raise issues of public interest. The Supreme Court has repeatedly emphasized that frivolous public interest litigations should be discouraged. Yet such filings continue. This, I'm sure, happens in high courts as well. In your experience, what measures, procedural, institutional, or cultural, could help curb this practice and ensure that PILs serve their true purpose?
Yes, you are right. जैसे हमने पहले भी कहा था, 32 में तो वही litigation फाइल होनी चाहिए as a public interest, which has a larger public interest. मैं आपके मुद्दे पे मैं बताता हूँ. ऑल 32 पे तो है ही, 32 में तो कहीं है. Like बंधुआ मुक्ति मोर्चा on any environment related issues. अभी जो गोवाद रामन भी चल रहा है, that's also 32 petition. We had MC Mehta, n number of cases in MC Mehta where the courts have entertained. But कई मुद्दे होते हैं कि जो कि पब्लिक इंटरेस्ट नहीं हो सकते, जैसे कि एक सर्विस मैटर के लिए ले लीजिए. सर्विस मैटर में तो इनफैक्ट सुप्रीम कोर्ट ने कह दिया देयर इज नो पब्लिक इंटरेस्ट लिटिगेशन इन सर्विस मैटर. बट कई इश्यूज होते हैं कि जहाँ पिटिशन मोटिवेटेड होती है, इट इज़ नॉट ए पब्लिक इंटरेस्ट बट इट इज़ ए पर्सनल इंटरेस्ट विच इज सॉट टू बी अचीव्ड. In those cases, Supreme Court said this is nothing but a personal interest, we will not entertain it, and rightly so. मैं आपको एक मुद्दा, एक केस बताता हूँ, एक केस की बात बताता हूँ. था सर्विस मैटर, पब्लिक इंटरेस्ट लिटिगेशन फाइल हुआ था, और वो सर्विस मैटर ये था कि एक पर्टिकुलर जगह लोकेशन पे एक आदमी ने, लेट्स अज्यूम फॉर ए मोमेंट, पोर्ट ब्लेयर में एक पिटीशन फाइल करी एज ए पब्लिक इंटरेस्ट लिटिगेशन। उसने वो फाइल करी एक डायरेक्टर की अपॉइंटमेंट चैलेंज करने के लिए। वो आदमी एक इंस्टीट्यूट था गवर्नमेंट ऑफ इंडिया का, उस डायरेक्टर की अपॉइंटमेंट चैलेंज करने के लिए करी एज ए पब्लिक इंटरेस्ट। वो एम्प्लॉय नहीं था, बट ही वॉज ए मेंबर ऑफ द पब्लिक एट लार्ज। पॉसिबली ये दिखाना चाहता था कि देखिए, आई एम ए मेंबर हु इज इंटरेस्टेड इन द अपॉइंटमेंट ऑफ दैट पर्सन एज ए डायरेक्टर ऑफ दैट इंस्टीट्यूट। अब उसमें पता लगा कि पहले एक राइट टू इंफॉर्मेशन एक्ट में एक रिप्रेजेंटेशन हुई थी, उसमें मांगा गया था कि इस डायरेक्टर की एलिजिबिलिटी बताइए और इसने ये कैसे अपॉइंट हुए हैं। और ये रिप्रेजेंटेशन पब्लिक जो राइट टू इंफॉर्मेशन में मांगी गई थी, एक जो व्यक्ति था जो कि नॉर्थ इंडिया में था, पोर्ट ब्लेयर में नहीं था। तो जवाब उसको मिला गया और उसको ये बताया गया कि जी इसकी ये एलिजिबिलिटी थी और ये फुलफिल करता था और इसको अपॉइंट करा गया था। उस लेटर के तहत पिटीशन फाइल हुई थी पोर्ट ब्लेयर में। अब देखिए, नॉर्थ इंडिया और पोर्ट ब्लेयर में क्या कनेक्शन था उस चिट्ठी का? कोई कनेक्शन नहीं था। जब आर्ग्यू किया गया था और सबसे पहले यही दिखाया गया था, देखिए जी पिटिशनर है पोर्ट ब्लेयर में और रिप्रेजेंटेशन हुई थी वहाँ से और जवाब मिला था वहाँ से, हाउ कैन दिस पिटिशन बी फाइल्ड इन ए पोर्ट ब्लेयर? तो कहने का मतलब है कि दिस वाज नथिंग बट ए मोटिवेटेड पिटिशन at the behest of a person who was in Port Blair, but impression was given that this is a representation made in North India and it is a bona fide. And कोर्ट ने खारिज कर दिया। खारिज ये करा कि ये मोटिवेटेड पिटीशन थी और ये इसको खारिज करना चाहिए और इन एनी केस सर्विस मैटर में तो हो ही नहीं सकता। हाँ, आप को वारंट तो फाइल कर सकते हैं, पर सर्विस मैटर में PIL would not be maintainable. So these are the things which need to be looked into, whether it is a personal right or a public interest or public right which is sought to be agitated in this petition.
See, public interest litigation is primarily giving voice to the voiceless. That's the concept of a PIL. A section of society which is not capable of espousing its rights in court is espoused by somebody else on their behalf. That's a PIL. What does PIL do? PIL dilutes the scope of locus standi. That's the purpose of PIL. So, when a locus standi is diluted for the purposes to give voice to a voiceless, if a PIL is filed with which is completely motivated or to gain the publicity in its own, that is what you try to discourage. For example, there was one case in Supreme Court where an Advocate General's appointment is challenged on the ground that is against public interest. Now that's where the Supreme Court laid down the guidelines of what amounts to public interest, and that is what is now being followed by every High Court also, as to what should be the basic criterion which has to be followed to be called as a public interest. And what does it, if it's abused, what happens? A, judicial time is wasted. B, genuine causes are affected. And that's why the court comes down to a very strong hand if it's a PIL which is motivated or if it is publicity interest or a personal interest litigation.
Closely connected to this question of forum's choice, in your view, how should a lawyer decide to file a writ in the High Court or approach the Supreme Court directly? What are your thoughts on the almost parallel jurisdiction of Article 226 and Article 32? Should the Supreme Court entertain the matters directly or insist on the exhaustion of High Court remedies first?
See, इसका आंसर तो अभी जस्टिस राव ने दिया ही है कि जनरली सुप्रीम कोर्ट विल नॉट इंटरफेयर एंड शुड नॉट इंटरफेयर, बट एज ए लॉयर कभी कभी आपके पास क्लाइंट आएगा कि नहीं हमें तो जाना है, हमारा तो बहुत इंपॉर्टेंट मुद्दा है। आप कैसे क्लाइंट को कभी कभी समझाते रहोगे कि नहीं इतना इंपॉर्टेंट नहीं है कि सुप्रीम कोर्ट डायरेक्टली एंटरटेन करे? तो प्रॉपरली तो यही है, जब तक कोई इतना इंपॉर्टेंट क्वेश्चन नहीं है जिसके ऊपर कोई डिसीजन नहीं है तो आप जाएंगे खाली 32 में तो कोर्ट को, अदरवाइज। लेकिन कभी कभी स्ट्रैटेजिकली नाउ दैट आई एम प्रैक्टिसिंग एज ए लॉयर आई कैन ऑल्सो टेल यू समटाइम्स स्ट्रैटेजिकली लोग चले जाते हैं सुप्रीम कोर्ट की, अच्छा विड्रॉल हो जाएगा, लिबर्टी टू फाइल इन द हाई कोर्ट, तो उससे भी हाई कोर्ट में एंटरटेन हो जाएगा। अदरवाइज आप उसको रिट पिटिशन को हाई कोर्ट में स्ट्रेट अवे फाइल करते तो शायद एंटरटेन नहीं होती. अब उनको लगता है कि सुप्रीम कोर्ट ने लिबर्टी दे दी है तो शायद हमारी पिटिशन एंटरटेन हो जाए. बट फ्रैंकली स्पीकिंग द सुप्रीम कोर्ट शुड, keeping in view कि it's a constitution, it's the apex court, it should not entertain petition for every small issue which can be sorted out in the High Court.
Moving ahead, the wider power. Article 226 scope is often called wider than Article 32's because it can be used for fundamental rights and any other purpose. In practice, how does this other purpose gateway make the High Court the primary court of first instance for challenging administrative action?
The difference, of course, lies in Article 226 and Article 32. Article 32, it only says of fundamental rights. 226 uses the word or for any other right, which makes 226 as much wider than what is merely under 32. So therefore, unless it's a case of a direct violation of a Part 3 right, you generally don't approach the Supreme Court, you approach the High Court. Second, if it's a local issue, a local problem, a local act, you generally approach the High Court concerned and not the Supreme Court. Because otherwise, the Supreme Court's Supreme Court always gets benefited by a view of a High Court. That view of a High Court is extremely important for the Supreme Court to proceed ahead and not be the court of first instance. And therefore, if it's not a fundamental right or even if it's a local issue, you rather prefer going to the High Court rather than go to the Supreme Court.
The interim order problem. The Supreme Court is often flooded with SLPs against interim orders passed in 226 petitions. In your view, should the Supreme Court adopt a strict handoff policy until the High Court disposes of the main writ, or is its intervention necessary to prevent the irreparable harm?
हाँ, ये बड़ा अच्छा क्वेश्चन है आपने जो ये करा है. और तो देखिए 226 में अगर जो आपका ये प्रश्न ये है कि 226 when you file an article 226 petition, it can be either way. An interim order is granted or interim order is denied. Interim order is granted, the other party can go in an SLP. Or interim order is denied, the party which has not got the order, it can go to the Supreme Court. Now what are the chances of, Supreme Court interfering in this kind of an order? These are interim orders are only on a prima facie view. It is not necessary that will be the final order which will be passed by the High Court. So generally Supreme Court doesn't interfere, in this kind of an order, saying that ultimately the High Court need to decide the larger issue to decide करना है High Court ने. तो आप High Court जाइए, we will not interfere. Everything is just only an interim measure till the culmination of the final order. It generally doesn't really interfere unless and until you can show there is a lot of irreparable loss that is going to be caused if this interim order is continued. Whose eventuality, possibly Supreme Court will think over it and possibly try to modify, or it can direct the High Court, since an important issue has been raised, possibly requesting the High Court to dispose of the final petition, जो भी petition pending है, at an early date. That generally is the eventuality. पर हमने देखा, at least in the context of Delhi, even in the application for early hearing which has been decided or which has been rejected, SLPs are being filed. That is another way of looking at it, but Supreme Court doesn't interfere because ultimately वो early hearing की application थी, early hearing आपकी reject हो गई है, तो SLP कैसे maintainable होगी? What is the substantial, what is the question of law which need to be pressed in that kind of a petition? So not necessarily in every matter, but surely in some matters which really has a wider ramification of an order, the Supreme Court will entertain it.
I think here I'll add on. जैसे अब जैसे राव ने बताया उसके एग्जाम्पल देते हैं. सपोज आप कोई बिजनेस करते हैं, आप एक लोगो यूज़ कर रहे हैं, अब कोई आपके अगेंस्ट कोई सूट फाइल करके स्टे ले लेता है कि आप लोगो यूज़ नहीं करेंगे, तो आप इररिपेरेबल डैमेज देके सुप्रीम कोर्ट जाएंगे कि जी मेरा तो बिजनेस ही बंद हो गया. तो उस केस में सुप्रीम कोर्ट कैन एंड वुड इंटरफेयर इफ इट फाइंड्स केस वर्क. So it's not that every interim order, but yes, Supreme Court is very, very reluctant to interfere in interim orders because वो यही बोलेंगे prima facie view है. Similarly, service matter में suppose हाई कोर्ट ने स्टे कर दिया, किसी का टर्मिनेशन हो रहा है और हाई कोर्ट ने स्टे कर दिया कि इसको टर्मिनेट नहीं करिए, तो सुप्रीम कोर्ट मे इंटरफेयर. So the window is very, very small, but and that is the correct approach, that courts should not interfere in interim orders. Otherwise, high courts will, how will the high court function?
We'll only one request we have now. We will just, because of the shortage of time, we can ask. आप लोगों में से कोई प्रश्न पूछ सकता है इस टॉपिक पे. आप you are at liberty, आप पूछ सकते हैं, so that at least we can wrap up this interaction.
सर मेरा ये क्वेश्चन है कि क्या हाई कोर्ट या सुप्रीम कोर्ट किसी लॉ मेकिंग अथॉरिटी को ये डायरेक्ट कर सकती है अगर किसी टॉपिक पे पर्टिकुलर कानून अवेलेबल नहीं है तो?
ये तो दो केसेस तो सीधे सामने आते हैं, एक विशाखा और एक प्रकाश सिंह. जहाँ पे वैक्यूम है और जहाँ पे लॉ नहीं है और सुप्रीम कोर्ट को ये लगता है कि यहाँ पे कानून बनना ज़रूरी है, तो सुप्रीम कोर्ट ने एंटरटेन किया है, सुप्रीम कोर्ट ने गाइडलाइंस फ्रेम किए हैं, सुप्रीम कोर्ट ने हिदायत दी है स्टेटों को कि आप कृपया लॉ बनाइए, और जब तक आप लॉ नहीं बनाएंगे जो हमने बुलाया वो कानून है. सेक्सुअल हैरासमेंट एट वर्क प्लेस नहीं था, विशाखा के बाद ही बना. उसी तरीके से प्रकाश सिंह के केस में जो टॉप मोस्ट ऑफिसर है पुलिस का, चूँकि वो हमेशा पॉलिटिकल प्रेशर आता रहता था, तो 2 साल के लिए उसको उस पोजीशन में होना चाहिए, इसका कोई लॉ नहीं था. सुप्रीम कोर्ट ने लॉ ले डाउन किया है, हर स्टेट को बोला कि प्लीज मेक लॉज टू द एक्सटेंट दैट it is satisfied. So therefore, wherever there is a vacuum, you can make it law. But if there is a law in place, then Supreme Court can't legislate. That's the principle.
मेरा जस्ट एक एग्जांपल के रूप में, जैसे ऑनलाइन गैम्बलिंग एक्ट जो है स्टेट्स के पास अवेलेबल नहीं है, तो उसके लिए वो डायरेक्शन इशू कर सकते हैं.
दोबारा बोलिए.
जैसे मैं एक एग्जांपल के रूप में कहता हूँ, स्टेट गवर्नमेंट्स के पास ऑनलाइन गैम्बलिंग एक्ट अवेलेबल नहीं है, तो उसके लिए क्या?
नो, See, gambling is a state subject. जो अभी जो सुप्रीम कोर्ट में पेंडिंग मैटर है जो ऑनलाइन गैम्बलिंग के ऊपर है, वो सेंट्रल गवर्नमेंट ने एक डायरेक्शन दिया है कि ऑनलाइन गैम्बलिंग नहीं होना चाहिए. तो ये गवर्नमेंट का डायरेक्टिव है, स्टेट का कोर्ट का इसमें डायरेक्शन नहीं है.
थैंक यू.
As we draw this session to a close, I extend heartfelt gratitude to Honorable Chair and our esteemed panelists for their illuminating guidance and valuable perspectives. I request everyone.
Just 1 minute.
10 minutes ago,
Thank you, sir, for coming to Jabalpur, the beautiful city of Ma Narmada. Thank you, sir, for coming to our city. So my question is that as an aspiring law student who wants to have their practice in constitutional matters, what steps or some reading material which I can go through as a third-year law student?
Just can you, if you don't mind, can you repeat the question once again?
Of course, sir. Sir, as a third-year law student, what steps which I can take to have a more competent and a more knowledgeable base for my future practice?
Read well.
See, so right, Justice Prasad has so.
No, not only read well.
This is learning is continuous here. You know, unlike other subjects where you have studied hard and you are getting a job and there is no need for you to read. It's the other way here. You have to continue, and your reading becomes more after you join the profession. Continue reading. Okay.
No, but I will add here, don't only read, keep your eyes and ears open, because you will find situations where you can actually go to the constitutional courts and file writ petitions. That's what your question was, how to practice in I will give you an example here, because we are closing because of shortage of time. Like, if you are all aware, in the army, about 20 years ago, there were no women officers in the army. They were not having any permanent commissions. That time there was no law on that. You had to keep your eyes and ears open And when we saw this was happening, we approached the court by way of a PIL saying that what is this happening? Either you take women or you don't take them. But you can't say that after 5 years you go out without pension. So please keep your eyes and ears open, keep looking for opportunities, and of course you have to keep reading, otherwise you will not know what to say in court. And all the best to you.
We are thankful to our esteemed...
See, एक point है जो कि since ultimately we are talking of the gateway to the Supreme Court, generally this is in the context of at least at the level of the High Court exercising its suo motu power on any issue and initiating a petition or initiating a sort of a litigation which is more in the public interest. एटलीस्ट इन द कंटेक्स्ट ऑफ मैं दिल्ली कह सकता हूँ कि दिल्ली हाई कोर्ट ने दिस इज़ ए पावर विद द चीफ जस्टिस हु हैज़ इनिशिएटेड पब्लिक इंटरेस्ट लिटिगेशंस ऑन द बेसिस ऑफ any press, any the paper reporting, and which the Chief Justice feel this should be in a larger public interest, and this issue should be looked into. And in those cases also, the Supreme Court, the High Court has initiated a suo motu public interest litigation and taken it to its logical end. Be anything relatable to environment generally hota hai, where the FQI, AQI has increased in Delhi. It need to be remedial measures may be taken, and it calls upon the government what remedial measures are being taken so that the AQ level goes down. Ye सारे मुद्दे होते हैं where वो power is there with the High Court. My learned sister now will speak on this.
No, because we were talking of suo motu power. As we know, ये हमारे constitution में, हमारी country में है power. I will tell you, एक बार I had attended a conference with the federal court judges of the Supreme Court of Germany, and they said they don't have the suo motu powers. The courts they don't have. In our court, in our country, the Supreme Court can take suo motu. अगर Supreme Court is the guardian of all fundamental rights, अगर उनको कुछ दिख रहा है कि कोई ऐसी चीज़ हो रही है अन्याय, जहाँ पे कोई कोर्ट का कोई डिसीजन नहीं है, कोई लिटिगेंट आ नहीं पा रहा किसी रीज़न से, तो वो suo motu ले रहे हैं. और लास्ट ईयर में 24 में there were 12 cases जहाँ पे suo motu सुप्रीम कोर्ट ने खुद से बढ़ के किया है. जिस रीसेंट केस में जिसमें मेरे को सौभाग्य है सुप्रीम कोर्ट को अब असेस करने का, एक आप में से शायद किसी को पता हो, जैसे कैडेट्स जाते हैं आर्मी में, उनकी इंजरीज हो जाती है. अगर उनको इंजर्ड हो जाएगा तो हम आर्मी में तो अनफिट इंसान को नहीं रख सकते, उसको निकाल देंगे, क्योंकि हमें अल्टीमेटली अपनी आर्मी तो स्ट्रॉन्ग चाहिए ना. लेकिन उसको जब निकाल देते हैं तो उनको कोई डिसेबिलिटी पेंशन नहीं देते, उनकी कोई नौकरी का कोई वुच नहीं रहता. कई आप उसमें से देखेंगे, आप यंग बच्चों से मिलेंगे, लड़के और लड़कियां भी आ रही हैं जो इतने उससे जाते हैं, ब्राइट स्टूडेंट होते हैं, IIT जा सकते हैं, लेकिन सोच के जाते हैं कि हमें आर्मी में जाना है या एयरफोर्स में जाना है, देश की सेवा करनी है. वो इंजर्ड होके 2 साल 3 साल पढ़ाई कर ली, 3rd ईयर में इंजर्ड हो गए. तो ये एक न्यूज़पेपर में आर्टिकल आया जिससे जस्टिस नागरत्ना ने, जो हमारी फ्यूचर लेडी चीफ जस्टिस ऑफ इंडिया बनेंगी, उन्होंने suo motu इसको मैटर में नोटिस इशू करके सब अथॉरिटीज़ को बुलाया और वो मैटर चल रहा है. अब उसमें मुझे अमाइकस बनाया गया, तो उसमें हम देख रहे हैं कि कोर्ट कैसे उन लोगों की आवाज़ सुन रही है जो होप खो चुके थे, क्योंकि वो नंबर इतना कम था, उनको लग नहीं रहा था कि हमारे पास पैसे हैं हम कोर्ट जा सके. अब सुप्रीम कोर्ट उसमें डिसाइड कर रहा है, गवर्नमेंट को प्रेशर कर रहा है कि उनको मेडिकल तो दो. वहाँ पे ये हाल हो रहा था कि बच्चा 18 साल का 20 साल का बच्चा इंजर्ड हो गया इतनी बुरी तरह, उसके पास मेडिकल भी नहीं, ट्रीटमेंट नहीं था, क्योंकि आर्मी तो बस एक टाइम ट्रीटमेंट, आर्मी एयरफोर्स वो ट्रीटमेंट करके भेज देगी, उसके बाद वो अगर बेड पे है तो वो बेड पे ही है, माँ बाप भी कर नहीं पा रहे. तो ये बहुत इंपॉर्टेंट इशू सुप्रीम कोर्ट ने उठाया है. तो suo motu की पावर जो है वो सुप्रीम कोर्ट बहुत अब एक्सरसाइज कर रहा है एज बिकॉज द मीडिया इज बिकमिंग स्ट्रॉन्गर. तो सबको मीडिया के थ्रू पता चल रही हैं चीज़ें, कोर्ट के सामने नज़र में आ रही हैं. तो दैट इज़ वन इम्पॉर्टेंट पावर. You should think about that and approach the courts.
Thank you.
We thank our esteemed panel for the valuable insights. Thank you, Lordships. Thank you, Ladyship. I request everyone to kindly remain seated as we transition into session 3.
I request Shri Sharad Bhamkar, Principal District and Session Judge, Inspection Jabalpur, to kindly escort our dignitaries on the dais. Thank you, sir. Good evening to all. I, Saurabh Kumar Singh, Officer on Special Duty, Madhya Pradesh State Judicial Academy, welcome everyone to the third and last technical session of the day. The theme of the session is Intellectual Property Rights and Application of Commercial Law in Arbitration and Commercial Trials. This session shall be chaired by Honorable Mr. Justice Naveen Chawla, Judge, Delhi High Court, and joined by esteemed panelists Honorable Mr. Justice Jasmeet Singh, Judge, Delhi High Court, and Honorable Mr. Justice Amit Bansal, Judge, Delhi High Court. Allow me to introduce our distinguished chair and panelists. Honorable Mr. Justice Naveen Chawla completed BCom Honours and LLB from Delhi University. His Lordship practiced in Supreme Court and the Delhi High Court, specializing in telecom and arbitration laws. His Lordship qualified as advocate on record in 1999 and served as a standing counsel for the Union of India in 2001. His Lordship was appointed permanent judge of the Delhi High Court on 15th May 2017. His Lordship's service to the judiciary stands as an inspiring example of wisdom, humility, and ethical excellence. Honorable Mr. Justice Jasmeet Singh holds BCom Honours and LLB degrees from Delhi University. His Lordship practiced in civil and service law before the Delhi High Court and various tribunals. His Lordship was served as a counsel for Delhi Sikh Gurdwara Management Committee and later as Central Government Counsel in 2014. His Lordship was appointed Judge of the Delhi High Court on 24th February 2021. His Lordship is admired for his fairness and clarity in judicial reasoning. Honorable Mr. Justice Amit Bansal completed BCom Honours from SRCC and LLB from Delhi University, followed by an LLM from Northwestern University, USA. A third generation lawyer, his Lordship specialized in arbitration, tax and commercial laws and served as counsel for CBSE, University of Delhi and the Delhi High Court. His Lordship was appointed Judge of the Delhi High Court on 24th February 2021. His Lordship is known for his unwavering commitment to fairness, clarity and judicial integrity. To welcome our dignitaries, I request Mr. Anil Kumar Vishwakarma, Senior Executive Member, District Bar Association, Narsinghpur, to kindly welcome Honorable Mr. Justice Naveen Chawla, Judge, Delhi High Court, by presenting a sapling and a memento. Thank you, sir. I request Mr. Rajendra Kumar Sharma, Executive Member, District Bar Association, Narsinghpur, to kindly welcome Honorable Mr. Jasmeet Singh, by presenting a sapling and a memento. Thank you, sir. I request Mr. Amit Shukla, President District Bar Association, Katni, to welcome Honorable Mr. Justice Amit Bansal by presenting a sapling and a memento. Thank you, sir. I request the Honorable Chair to please address us.
Thank you so much. First of all, my heartfelt thanks to Honorable Justice Sanjeev Sadeva, the Honorable Chief Justice of the Madhya Pradesh High Court, and his companion justices of the Madhya Pradesh High Court for organizing this event and also for inviting us for the same. It's indeed a real pleasure to be here to this beautiful city and to actually see that at about 4 o'clock in the evening, after grueling 2 sessions, in fact 3 sessions, we have such a great audience still sitting here patiently listening to us. Thank you very much. After the road to Supreme Court, I'll have to bring you back to the District Court. So, District Court में I think आज की फील्ड में 2 बहुत important subjects हैं जिसके ऊपर litigation होती है, at least in Delhi. और इस सेशन के थ्रू वो 2 important topics पे हम थोड़ा बहुत discuss करेंगे. पहला है arbitration. I know कि मध्य प्रदेश में there is a special arbitration act, but we have an expert with us in Justice Jasmeet Singh, who's sitting in this roster in the Delhi High Court, dealing in the arbitration matters day in and day out. वो हमें कुछ बताएंगे arbitration की एक्ट के nuances के बारे में, कैसे exercise होती है power 34 में, 9 में, 11 में Arbitration and Conciliation Act 1996 में, क्योंकि ये बहुत ही emerging topic है जो कि ADR जो अब emphasis है alternate dispute resolution का, उसके लिए बहुत ही important topic है. दूसरा टॉपिक जो हम टच करेंगे वो है इंटेलेक्चुअल प्रॉपर्टी लॉ. पुराने ज़माने में प्रॉपर्टी समझी जाती थी इमूवेबल प्रॉपर्टी, उसी के सारे डिस्प्यूट्स होते थे. बट आज की डेवलपिंग इकोनॉमी में सबसे इम्पॉर्टेंट प्रॉपर्टी अगर कोई है एक बिजनेस की, तो आई थिंक वो है उसका इंटेलेक्चुअल प्रॉपर्टी. ट्रेडमार्क, पेटेंट्स, कॉपीराइट, डिज़ाइन, ये सब अब बहुत ही ज़्यादा इम्पॉर्टेंट हो गया है. इसकी इम्पॉर्टेंस समझते हुए इनफैक्ट दिल्ली हाई कोर्ट में एटलीस्ट, क्योंकि वहाँ पे ओरिजिनल साइड है, एक इंटेलेक्चुअल प्रॉपर्टी डिवीज़न बनाया गया ताकि इस टाइप के डिस्प्यूट जल्दी से और एक समानता के साथ रिजॉल्व किए जाएं. तो ये इसकी इम्पॉर्टेंस है आज की डेट में. उसमें वी हैव एन एक्सपर्ट इन जस्टिस अमित बंसल, Honorable Justice Amit Bansal, जो कि in fact, if I'm not wrong, came in top 40, top 50 judges of the world in the intellectual property law. और इन दोनों के बीच में मैं हूँ जो शायद आप लोगों को कुछ बता पाए इन सब दोनों टॉपिक्स के बारे में. सो बिना और डिले किए हुए मैं सीधा माइक दूंगा जस्टिस जसमीत सिंह को, जो थोड़ा हमें आर्बिट्रेशन के बारे में बताएं.
Thank you, Justice Chavla. Good evening, Chief. Good evening, respectable judges, all the people present here. Arbitration Act जो है 1996 में है because of the liberalization of the Indian economy in 1991. उसके बाद देयर वाज अ नीड फेल्ट कि जो जस्टिस सिस्टम है दैट इज there are too many delays. So there were two acts which were promulgated. One was Commercial Courts Act and the other one was Arbitration and Conciliation Act. दोनों का purpose same है कि to address the concerns of complexities of commercial laws and to provide speedier and effective justice. Arbitration Act is now in the present regime, उसके sections are clear कि जिस दिन से dispute refer होता है within 6 months pleadings are to be completed, within 1 year the arbitration has to be concluded, and if not concluded it is only the court 6 months initially arbitral tribunal 18 महीने के बाद 6 महीने arbitral tribunal extension कर सकता है, otherwise it has to be to the court, and court while extending that period may impose restrictions including, and arbitration falls within the definition of commercial courts. So under commercial courts हर एक high court में हर एक high court के commercial divisions बनने हैं. There has to be a commercial division in the high court, there has to be a commercial division in the appellate court, and there has to be commercial division in the trial court. एक मैं अभी देख रहा था तो एक MP हाई कोर्ट की बड़ी अच्छी जजमेंट थी यशवर्धन रघुवंशी की, which said कि it is only commercial court which was at the status of a district judge. Only a district judge can be a commercial court and the civil judges will not be commercial court. However, after some time the Supreme Court clarified कि this is not the right view. It can be the civil judge, the district judge, as well as the high court, which will be the commercial division. Having said that, and as Justice Chawla said, I have been in the arbitration roster for about 9 months now. I will only share with you some issues which come frequently in an arbitration roster. सबसे पहला है जी, आपने देखा होगा a lot of times there are disputes between the parties. A and B have a dispute. The matter goes to arbitration, or there is a contractor का running bill है, 5th running bill, 7th running bill, उसके contract में arbitration clause है. तो जो employer है या जो जिसकी superior bargaining power है, वो कहता है जी ये मैं आपको final bill दे रहा हूँ, आप receipt दे दो, full and final received, all claims settled. So now one of the frequent questions is that after having signed the full and final settlement, will an arbitration proceeding still lie? So the Supreme Court in SBI versus Krish Spinning has clarified the law. वो कहते हैं कि full and final settlement, even if you have given, is not final culmination of the dispute. Arbitration agreement is separate. अगर आपको लगता है या आपकी averment है कि the full and final settlement was executed under duress, coercion, malafide, you can still invoke the arbitration. But it is not merely stating that it was under duress, coercion. There has to be something more. थोड़ा कुछ और दिखाना पड़ेगा आपको कि duress, coercion is actual and not only to invoke arbitration. And if that is so, as a section 11 court, that is court which is जो refer कर रहा है matters to the dispute, to the arbitrator, उसको और कुछ नहीं देखना. उसको देखना है कि जो पार्टी आई है वो कह रही है कि जी मेरा coercion से मैंने full and final settlement किया है, duress था, मेरे को I am a small contractor, अगर मैं ये पैसे नहीं लेता तो मेरा बिल्कुल ही काम बंद हो जाता, या और मैं इंश्योरेंस कंपनी के खिलाफ लड़ रहा हूँ, अगर मैं उनसे ये जो वो एडमिटेड सर्वेयर रिपोर्ट के हिसाब से मेरे को पैसे दे रहे हैं वो भी मैं नहीं लेता तो मेरा बिल्कुल ही आई वुडंट हैव बीन एबल टू सर्वाइव. दैट इज़ गुड इनफ फॉर अ रेफरल कोर्ट जो टू रेफर द मैटर टू आर्बिट्रेशन. अनदर इम्पॉर्टेंट क्वेश्चन विच कम्स इन सेक्शन 11 इज लिमिटेशन. कि जी आप कभी भी आके बोलो कि हमारा डिस्प्यूट है, प्लीज रेफर इट टू आर्बिट्रेशन. अगेन द सुप्रीम कोर्ट हैज़ क्लैरिफाइड द लॉ that if it is absolutely a dead claim, बिल्कुल हर एक एंगल से आपको लगता है कि जी 3 years, 5 years, जो भी limitation period है that has expired, then it is dead wood. You will not refer it to arbitration. But again, as a referral court, आपको थोड़ी सी भी semblance लग रही है कि yes, it can be within arbitration, within limitation, then you have to refer. As a referral, as a section 11 court, आपने mini trial नहीं करनी कि ये आपका limitation barred है, ये आपकी limitation के अंदर है, because there are no 2 trials in a matter. आपको लगता है referral court prima facie view कि ये limitation के अंदर है and it has to be liberally construed. आपको लगता है limitation है, आप उसको refer करोगे and this point ultimately will be decided by the arbitrator after going through the evidence. Most important question जो arbitration roster में आता है is regarding the jurisdiction. Arbitration Act recognizes seat, venue and jurisdiction clause. हमारी ये हो सकता है जी मैं जबलपुर में हूँ, मेरे कॉन्ट्रैक्टिंग पार्टी इंदौर में है, हम दोनों की लड़ाई हो रही है ग्वालियर में. So, but for seat of arbitration we have chosen Delhi. Everything in Madhya Pradesh, but seat of arbitration is Delhi. The court recognizes that the seat of arbitration will be the court where the seat of arbitration is given. That will be the court which will exercise jurisdiction. If the seat of arbitration clause is silent, then section 16 to 21 principles will apply where the cause of action arises in part or fully. Agar seat arbitration की given है, that is the court which will exercise jurisdiction, and seat is different from venue. Venue relates to the geographical seat of arbitration. Next and most important again is section 34. That is when you challenge the arbitral award. Law is clear that under 34, it's not like you have to act as an appeal. You are not to see the evidence, you are not to see factual errors, and even other arbitrator's view is a possible view. 34 court will not interfere. 34 court will only interfere if it is fundamental to Indian law, fundamental policy of Indian law, illegal on the face of the award, and most basic notion of morality and justice. These are terms which have been interpreted time and again and needs to be seen. Evidence, contrary to evidence on record, if it is without any evidence, if it violates any of the sections of law, it will all come under 34. But the 34 court will not sit as an appellate court. It is not an appeal where you will argue merits, you will argue the law, you will only come within the small 3 parameters. So that is the broad sum and substance of the Arbitration Act. I hope if there are any questions, I'll be happy to answer afterwards.
Thank you, Justice Jasmeet. I think he's touched very important aspects of the Arbitration Act. Starting from the time frame for passing of an award, because आपने arbitration तो invoke कर दी, but arbitration का entire purpose था timely disposal, timely adjudication of the dispute. जब पुराना एक्ट जो 1940 एक्ट था उसमें एक खामी पाई गई कि आर्बिट्रेशन चलती रहती थी ईयर आफ्टर ईयर. उसके लिए बहुत ज़रूरी था कि एक टाइम फ्रेम लाया जाए आर्बिट्रेशन एंड कंसिलिएशन एक्ट में ताकि अवार्ड टाइमली आए. अब वो टाइम तो प्रिस्क्राइब कर देंगे लेकिन अब उसको एक्सटेंड कौन करेगा, क्योंकि अगर फॉर सम रीज़न आपका अवार्ड नहीं आया उस टाइम में तो क्या होगा, क्या सारी प्रोसीडिंग नलिटी हो जाएगी? उसको आंसर करने के लिए एक्ट में ही फिर प्रोविजन लाई गई कि नहीं 6 months तक आर्बिट्रेटर के पास पावर है, उसके बाद कोर्ट में आप जाइए, कोर्ट के पास पावर है टू एक्सटेंड द टाइम. दिस वाज वेरी इंपॉर्टेंट प्रोविजन. जस्टिस जसमीत सिंह ने फिर बताया सेक्शन 11 की jurisdiction, वो एज लॉयर्स बहुत इंपॉर्टेंट है, क्योंकि जब एक सेक्शन 11 पिटिशन फाइल होती है, एज अ लॉयर आई थिंक यू शुड नो कि क्या एम्बिट है उस जुरिस्डिक्शन की इन अ हाई कोर्ट. कई बार होता है जब हम उस जुरिस्डिक्शन में बैठे होते हैं, लॉयर्स आते हैं, वो कहते हैं जी ये केस एकदम बोगस है, ये देखिए ये डॉक्यूमेंट है, ये मेरा डिफेंस है, विदाउट रियलाइजिंग कि ये एम्बिट है ही नहीं हमारी जुरिस्डिक्शन का सेक्शन 11 में. सो फॉर अ लॉयर इट इज वेरी इंपॉर्टेंट टू नो कि सेक्शन 11 में कहां तक आप जा सकते हैं एज अ डिफेंस टू अपोज अपॉइंटमेंट ऑफ एन आर्बिट्रेटर. जस्टिस जसमीत सिंह ने फिर उसके बाद एक बहुत जो मुद्दा आई थिंक जजमेंट आफ्टर जजमेंट डील कर रहा है और अभी भी उसका आंसर प्रॉबेबली ठीक से नहीं है सीट वर्सेस वेन्यू. एक जगह आर्बिट्रेशन हो रही है, एक्चुअल उसका वेन्यू है, वो आर्बिट्रेटर जो है वो जबलपुर में बैठ के आर्बिट्रेशन कर रहा है, लेकिन जुरिस्डिक्शनल सीट उसकी जो है वो लेट्स से इंदौर है. अब उसके रिलेशन में जो पिटिशंस फाइल होंगी वो कहाँ होंगी, जबलपुर में होंगी, इंदौर में होंगी. ये बहुत इंपॉर्टेंट क्वेश्चन है जिसका आंसर एज आई सेड बहुत जजमेंट्स आई हैं, लेकिन हर बार ये लॉयर्स की कॉम्पिटेंस है और आई थिंक इस कॉन्फ्रेंस के लिए बहुत ही इंपॉर्टेंट है ये, बिकॉज आफ्टर ऑल टॉपिक इज एडवोकेसी एंड प्रोफेशनल कॉम्पिटेंस. सो आई थिंक ये आप लोगों की ही कॉम्पिटेंस है कि एवरी टाइम आप एक नया पॉइंट ले आते हैं और कहते हैं कि नहीं आप ये देखिए ये सीट नहीं है, ये वेन्यू है, और दूसरा कहता है नहीं नहीं जी ये वेन्यू नहीं है, ये तो सीट है. सो आई थिंक दैट इज वेयर योर कॉम्पिटेंस लाइज एंड हाउ वी नीड टू एडजुडिकेट ऑन एवरी डे and in every case. And lastly, he of course spoke about section 34, the jurisdiction of section 34, which again is very important because again if arbitration is to succeed as an alternate dispute resolution mechanism, the parties have entrusted their faith in the arbitrator. The court's interference has to be most minimal. अगर कोर्ट हर अवार्ड को एक तरह से अपील की तरह डील करने लग गया तो पर्पस ऑफ आर्बिट्रेशन इटसेल्फ विल गेट डिफीटेड. सो व्हेन यू आर आर्ग्यूइंग फाइलिंग अ सेक्शन 34, ट्राई एंड अंडरस्टैंड अगेन द लिमिटेशंस ऑफ दैट जुरिस्डिक्शन. व्हेन यू आर आर्ग्यूइंग अ 34, understand what is the limitation of that jurisdiction. You can't be arguing it as an appeal, we can't be adjudicating it as an appeal. The arbitrator is the final word on facts, in fact also on law in sometimes. So these are very important aspects which Justice Jasmeet Singh touched as far as arbitration is concerned. Now I'll hand over the mic to Justice Amit Bansal, who will tell us something about IP laws, because as I said, this is the most important property nowadays for a business.
Thank you, Justice Savla. Honorable the Chief Justice of Madhya Pradesh High Court, Justice Sachdeva, judges both sitting as well as former judges of Madhya Pradesh High Court, my colleagues from Delhi High Court and former colleagues, all the judicial officers, advocates, law students and everyone else who's present in this audience. Thank you very much for giving me this opportunity. It's indeed a pleasure being here. So intellectual property, as we understand, broadly covers 4 broad headings: trademarks, copyrights, patents, designs. So my focus for today will mainly be trademarks, because trademarks affects our lives on a day-to-day basis. We see the impact of trademarks on a day-to-day basis. So with that background, let me begin. This is just to give you a perspective कि intellectual property enforcement क्यों matter करती है या क्यों ज़रूरी है हमारे लिए. Most important thing is कि it protects the consumers from counterfeit goods, deception, products which may be unsafe. और दूसरी बात ये है कि it encourages innovation, क्योंकि अगर किसी की ब्रांड की प्रोटेक्शन ही नहीं होगी तो वो रिसर्च करके नए प्रोडक्ट्स क्यों बनाएगा. एंड इसको बेस्ट इसको समझने के लिए होता है फार्मास्यूटिकल प्रोडक्ट्स. ड्रग कंपनीज इतना रिसर्च करती हैं, R&D में पैसे लगाती हैं और नए नए प्रोडक्ट्स निकालती हैं जो हम सबको, जिसका हम बेनिफिट उठाते हैं। तो जब तक उनको थोड़े पीरियड के लिए आप मोनोपोली नहीं देंगे कि ये प्रोडक्ट आपका कोई और कॉपी नहीं करेगा, द इंसेंटिव टू इनोवेट विल गो। So these are the brief topics which I will quickly touch upon in the course of the presentation today. Now, most common issue which comes is infringement and passing off. So just there's a technical difference between the two terms. Infringement वहाँ होती है कि जब किसी ने अपना ट्रेडमार्क रजिस्टर्ड कराया हुआ होगा ट्रेडमार्क रजिस्ट्री में, तो वो कोई उसका ट्रेडमार्क फिर कोई कॉपी करता है या सिमिलर मार्क करता है तो उसको इन्फ्रिंजमेंट कहते हैं। पर लॉ प्रोवाइड्स इवन अगर आपका मार्क रजिस्टर्ड नहीं है पर बहुत पॉपुलर है, इट कैन स्टिल बी गिवन प्रोटेक्शन इवन इफ इट इज़ नॉट रजिस्टर्ड, उसको पासिंग ऑफ कहते हैं। तो पासिंग ऑफ का रेलेवेंस हो जाता है बाहर के ब्रांड्स जो इंडिया में शायद रजिस्टर्ड ना हो। फॉर इंस्टेंस टेस्ला की गाड़ियाँ हैं, वो अभी इंडिया में अभी शुरू हुई बिकने में, अज्यूमिंग, मुझे नहीं पता वो रजिस्टर्ड है या नहीं है, अगर वो रजिस्टर्ड नहीं है फिर भी वो किसी को रोक सकता है इंडिया में टेस्ला ब्रांड यूज़ करने के। टेस्ला या मेस्ला सिमिलर, इल कवर एवरीथिंग। तो मेनली झगड़े होते हैं आईपी ट्रेडमार्क केसेस में एफएमसीजी सेक्टर में, क्योंकि प्रोडक्ट्स यहाँ पे बिल्कुल लोग बाग जो एक प्रोडक्ट बहुत पॉपुलर हो जाता है उसकी कॉपी करते हैं सिमिलर सॉर्ट ऑफ नेम्स लगा के। तो मैंने ऐसे ही दो चार एग्जांपल्स रखे हैं जिससे कि आपको समझ में आए ये कॉन्सेप्ट। तो एक हैवल्स कंपनी है, उनका केबल्स बनाती है, तो उनका एक बड़ा फेमस प्रोडक्ट है रियो। तो किसी और डिफेंडेंट ने उनका बना दिया प्रोडक्ट कैब्रियो, तो उन्होंने केस डाला भी रियो और कैब्रियो तो सिमिलर ही हैं, तो इन्होंने मेरा कॉपी किया, तो कोर्ट ग्रांटेड इंजंक्शन। एक सिमिलरली एनबीएफसीज हैं, एक है सम्मान कैपिटल, एक है स्वमान। तो यहाँ भी कोर्ट फेल्ड की दोनों स्वमान, दोनों का ब्रॉड मीनिंग सेम ही है कि सेल्फ रिस्पेक्ट, तो दिस विल अमाउंट टू अ इन्फ्रिंजमेंट। ना केवल सिमिलर नेम्स, दिस कैन ऑल्सो बी फॉर लोगोज, जो लोगोज यूज़ करते हैं, या फिर इवन ट्रेड ड्रेस। अब आप कोई प्रोडक्ट अपना सोचिए जो डे टू डे लाइफ में हम यूज़ करते हैं, वो वॉलिनी है पेन रिलीफ क्रीम, आई एम श्योर वी आर ऑल वेरी फेमिलियर ना, उसकी जो बॉटल है उस पर बड़ा स्पेसिफिक कलर स्कीम है, स्पेसिफिक डिज़ाइन है। तो ऐसे भी इंस्टेंसेस होते हैं कि कोई नाम उन्होंने वॉलिनी रखा, कुछ और रख दिया, पर बॉटल एकदम ऐसे ही बताए कि कंज्यूमर जाएगा दुकान में खरीदने तो उसको लगेगा ये तो वही वॉलिनी है, वो ध्यान से नाम नहीं पड़ेगा, खरीद लेगा। तो इसको ट्रेड ड्रेस कहते हैं। ट्रेड ड्रेस also is a part of trademark protection, and nobody can violate the trade dress. And as I mentioned, pharmaceutical sector is one of the most commonly fought areas in IP, because दवाइयों में बहुत सिमिलैरिटी होती है। जो दवाई पॉपुलर हो जाती है उसका लोग लगभग बहुत कॉपी करते हैं। तो इसका मैं एग्जांपल देता हूँ, एक प्लाविक्स है, एक क्लाविक्स कर दिया किसी ने, क्योंकि प्लाविक्स बहुत पॉपुलर है, दोनों एक ही एलिमेंट के लिए हैं, पर उन्होंने सिमिलर कर दिया कि जिससे कि लोग कंफ्यूज हो जाएं। एक और सेगमेंट जहां बहुत ही लिटिगेशन होती है इज लग्जरी एंड डिज़ाइनर गुड्स। दिस विल इंक्लूड लेडीज़ हैंडबैग्स, फुटवेयर, वॉचेस, जिनमें बहुत लुई विटॉन है, लेडीज़ बैग जो बहुत पॉपुलर है, शूज़ के ब्रांड्स हैं, घड़ियाँ हैं रोलेक्स। तो लोग ये काउंटरफीट बनाते हैं, नकली, और ये इतनी महंगी चीज़ें होती हैं, तो इसमें काउंटरफीट बिजनेस बहुत प्रॉफिटेबल होता है। तो रोलेक्स की घड़ी 20 लाख की है, कोई उसके वर्जन बना के 2 लाख में बेच दे, तो कंज्यूमर विल हैप्पीली बाय, नॉट नोइंग कि ये जेन्युइन प्रोडक्ट नहीं है। नाउ ये आजकल के टाइम में व्हेन इंक्रीजिंगली द वर्ल्ड इज मूविंग टुवर्ड्स वर्चुअल वर्ल्ड, सो देयर इज अ लॉट ऑफ ऑनलाइन पायरेसी व्हिच इज हैपनिंग। People will make fake websites resembling, कोई बना लेगा टाटा की कि we are offering you agencies of Tata, और any other famous company, आदित्य बिरला की कि we are offering you agencies। वो customers को they will make them part with money, and फिर वो पैसे लेके निकल जाएंगे। So इस टाइप के फिर इनको पता चलता है, जो ओरिजिनल ब्रांड ओनर है they will sue in court and to prevent that। So these are the typical orders which court will pass. जब आप वेबसाइट कोई खोलते हैं उसके लिए पहले आपको DNR अपना नाम रजिस्टर कराना पड़ता है, डोमेन नेम with a DNR. Which DNR could be in India, could be outside India. So the court will typically order the DNR को direction दी जाएगी, because इसमें the person who's committing piracy is not known, identity is not known. You just see the website, you don't know who's behind it. So the first order the court will pass is to tell the DNR concerned, which DNR stands for Domain Name Registrar, that please block this, please disable this domain name so that the website falls. The second line of order which court passes is the court will direct DOT, which is the Department of Telecommunication and Ministry of Information Technology, that they will issue directions to the internet service provider to block those websites, so that those websites cannot be accessed. And then if the infringement is happening in a social media platform, could be Facebook, could be Instagram, the court can issue directions to Instagram, Facebook to take down the infringing listings. It could be for a product, it could be for a service. The court will, the plaintiff will make these people a party. They will make Facebook a party, or they will make Instagram a party, and court will pass a direction to take that down. Achha, this is another topic I wanted to briefly touch, defamation and disparagement. In today's time, we are all familiar that there is a lot of role of social media influencers. Now, some of them are independent, who constantly put their videos on YouTube. They will comment on a product. They will comment on a service. Now, they are independent people. Question is, while putting their online videos, can they defame and disparage a particular product? So ये एक recent case था जो हमारे आगे आया था, Sand Nutrition versus Arpit Mangal. So Arpit Mangal was the person who was the social media influencer, and Sand Nutrition used to come out. आजकल protein powders बहुत popular हो गए हैं. So this is a company which was selling its own protein powders. So this person said कि ये तो इतना promise करते हैं, protein इतना है, पर इसमें होता तो उससे आधा ही है. So this became a delicate issue, balancing the freedom of speech of a person to air his views, which is a constitutional right, versus the commercial interest of the party. But in this case, the court found कि उसने जो video दिया है, it is based on actual testing he's done for the product in laboratories, which made him come to that view. So the court refused to grant injunction in a case like this. However, there are cases of social media influencers. एक केस था कि एक होम्योपैथिक डॉक्टर हैं, उसने एक बड़ी एक पॉपुलर मेडिसिन है पैंडी, कि ये एसिडिटी वाली दवाई है, इट इज़ वेरी बैड, इट डज दिस. नाउ हियर द कोर्ट ग्रांटेड इंजंक्शन बिकॉज उसका कोई बेसिस ही नहीं था ये कहने का, ना तो वो कोई डोमेन स्पेशलिस्ट है, ही इज़ नॉट अ डॉक्टर, ही इज़ अ होम्योपैथिक डॉक्टर, एंड ही सेड डोंट हैव दिस. एंड द स्टेटमेंट्स लाइक दिस, they become very, very popular on YouTube, and then they affect the sales of the company. So every case, the court has to analyze where the court should grant injunction and where it should not. Similarly, now a lot of the advertising earlier, which used to be on television, happens on the media, on online media. So the law is very clear. You have the right to promote your product in any manner you want. You can say, "Mera product best hai, mera number one hai," but you can't denigrate someone else's product. तो एक case आया था. There's a popular Bollywood actress. She was advising a young girl who was going for a job interview कि यार तुम मेकअप लगा रहे हो, ये ऐसा वैसा मेकअप नहीं लगा. उसने वो फेंक दिया. So जिसका प्रोडक्ट था उसका नाम नहीं आया था, पर उसकी कलर स्कीम वगैरह बॉटल से क्लियर हो रहा था ये कौन सा प्रोडक्ट है. उसने केस डाला कि ये तो मेरे प्रोडक्ट का डिस्पैरेजमेंट हो गया. So this was again once a clear case कि even though नाम नहीं लिया उन्होंने प्रोडक्ट का, बट क्लियर था कि उसको घटिया बोल रहे हैं और ऐसा वैसा बोल रहे हैं. So naturally the court granted injunction in a case like this. Acha, personality rights is something, Atal, I'm sure we are all reading about this. All Bollywood celebrities these days, you must have read in newspapers, are filing cases to protect their personality rights. Be it Anil Kapoor started the trend, after that it has been Aishwarya Bachchan, Amitabh Bachchan, sabne case dala hai. So what is really happening is that आज के time में internet से not only can you reproduce somebody's image, but also the voice. So people unauthorizedly get these pictures, images, voice, and they associate their product with and try to sell their products. So and actual में those celebrities have not given their permission to use either their image or their voice. So immediately that's why all these personality rights cases, court immediately grants an injunction. And here also the perpetrators or the defendants are unknown. There are websites where all these products are selling. So the court immediately then grants a situation in a situation like this. I don't know, एक picture आई थी जो बड़ी popular हुई थी, अंदाज अपना अपना. आप सबने देखी है? It was based out of Bhopal. So that movie became so popular, and उसके characters अमर, प्रेम, crime master गोगो इतने popular हो गए, तो उसमें भी लोगों ने business बना लिया है. तो उसके भी products सारे उसके नाम लगा के, characters के photo, नाम वो लगा के लोग products बेच रहे हैं, T-shirt पे emboss करके बेच रहे हैं. तो उसके producer ने भी case डाला कि unauthorizedly without copyright and all these products lie with me and people can't use it without taking my permission. So this is again a case where the court granted injunction. Now, very briefly, these are the types of injunction orders which a court passes in an IP case. One, of course, we all know permanent injunction, वो तो suit के पूरे trial के बाद, evidence के बाद होता है. Unless defendant कई बार पहली date पे आके बोलता है कि I'm giving a statement, I'm giving an undertaking, I will change the name of my product so that it is non-infringing. So court can straight away then pass a permanent injunction. The other is something called the Anton Pillar orders, which the court appoints a local commissioner, which is generally an advocate, to visit the premises of the defendant, raid, and make an inventory of all the infringing products. Because otherwise होता ये है कि plaintiff case डालता है और जब तक case defendant आता है वो कहता है मेरे पास तो ऐसे कोई product है ही नहीं, मैंने तो कभी deal ही नहीं किए. तो इसलिए local commissioner court appoint करते हैं जिससे कि immediately जाके defendant की जगह वो एक inventory बना दे जो कि evidence होती है कि हाँ defendant was dealing with infringing goods. The other aspect is full trial के बाद इसमें commercial cases हैं, so following principles of commercial case, court imposes actual costs in favor of the plaintiff. कि अगर plaintiff दिखाए इस पूरे case को करने के लिए मेरे 50 लाख रुपए खर्च हुए हैं, तो court will grant as much cost to the plaintiff in its favor. It is not bound by CPC कि आप reasonable cost लगा दो, ये actual cost पे होते हैं. बल्कि एक case में मैंने अभी recently पूरे evidence के basis पे 5 करोड़ cost लगाए थे. Similarly, damages, our law of damages says that damages should be compensatory. But IP cases, since they involve dealing with counterfeit products, pirated products, and products affecting public health and safety, courts impose enhanced damages or punitive damages to act as a deterrent. It is not just to compensate the plaintiff so that the acts of the defendant are of such heinous nature and not just harm, they would cause harm not just to the plaintiff but also to the society at large. Therefore, punitive costs should be avoided. These are just this is my last slide, these are the common defenses जो defendant court के आगे पेश करता है. No likelihood of confusion because defendant कहता है my product even though हमारे नाम मिलते जुलते हैं but my product is in a totally different sphere, so there cannot be any confusion. Like the first case मैंने लिखा Mankind versus Sun Pharma, तो वो कहते हैं goods are different. They are pharmaceuticals and they are sanitary napkins, so unconnected. Similarly, कुछ use होते हैं descriptive or generic use. Like words, if I'm using in my product super, superstar, super dry. So super एक laudatory word है. तो nobody can monopolize words like super, excellent. ये जो मैंने example इसमें दिया है low cal. तो उनका product वो advertise कर रहे हैं कि it's low calorie, so low cal. Now this words like this which describe the character of a goods cannot be monopolized by anyone. So there can't be any injunction. सिमिलरली अगर दोनों साइड बहुत लंबे पीरियड से वो मार्क यूज़ कर रहे हैं तो भी इंजंक्शन नहीं होगी। जैसे कि दो पॉपुलर न्यूज़पेपर्स हैं, हिंदुस्तान टाइम्स और टाइम्स ऑफ इंडिया, दोनों टाइम्स यूज़ कर रहे हैं, बट दोनों यूज़ कर रहे हैं 50 इयर्स और इवन लॉन्गर, तो इसलिए उसमें आज के दिन दोनों में से कोई भी एक दूसरे के खिलाफ इंजंक्शन नहीं ले सकता। सिमिलरली अगर अपना नाम आप यूज़ कर रहे हो तो आपको कोई अपना नाम यूज़ करने से नहीं रोक सकता है। जैसे ये केस था, एक फेमस ज्वेलरी शॉप है वसुंधरा ज्वेलर्स, उसने केस किया एक और लेडी पे, उसका नाम ही वसुंधरा था, तो वो कहती है मैं तो अपना बिजनेस अपने नाम से कर रही हूँ। तो इसमें भी लॉ क्लियर है, यू कांट प्रिवेंट एनीवन फ्रॉम यूजिंग देयर ओन नेम। एंड फाइनली भगवान का नाम में कोई रोक नहीं है, कोई किसी की मोनोपोली नहीं हो सकती। हम लोग इतने बिजनेसेस देखते हैं जहाँ ओम होता है, कृष्णा होता है, सो नोबडी कैन मोनोपोलाइज द नेम ऑफ गॉड in their business. I think that's it for now. So I'll be again happy to answer any questions if anyone has.
Thank you, Justice Bansal. It was actually very informative as to what is the difference between infringement and passing off, what is domain name registrations, disparaging ads, which is actually very, आपको अगर किसी का अट्रैक्शन सीख करना है ऐड में, जो कि उसका पर्पस है, तो सबसे अच्छा पर्पस तो यही होगा कि दूसरे को भी बदनाम कर दो उसी में, उससे आपको और ज़्यादा अट्रैक्शन मिलेगी। बट उसकी कितनी लिमिट है उसके बारे में जस्टिस बंसल ने हमें बताया। पर्सनालिटी राइट्स ऑफ कोर्स, कई बार जो जजेस ये लिटिगेशन हैंडल कर रहे हैं हाई कोर्ट में, तो हम जजेस आपस में मजाक करते हैं कि इनको कभी समन भी कर लो भाई, हम देख भी लें किसकी बात हो रही है। बट अनफॉर्चुनेटली जस्टिस बंसल हमें कभी भी ये प्रिविलेज नहीं प्रदान करते, ये अपने आप ही बस सिर्फ उनकी पर्सनालिटीज़ देखते हैं। फाइनली ऑफ कोर्स कोई भी लॉयर, कोई भी लिटिगेंट कोर्ट जाता है तो रिलीफ के लिए जाता है, तो किस टाइप का उसे रिलीफ मिल सकता है उसके बारे में जस्टिस बंसल ने हमें बताया, किस टाइप का रिलीफ दे सकते हैं, मांगना चाहिए, किन किन सर्कमस्टांसेस में वो रिलीफ मिलेगा, उसके बारे में हमें बताया। थैंक यू अगेन। मैं इसी टॉपिक को थोड़ा और अब आगे लेके जाऊंगा। जस्टिस बंसल ने ब्रॉड फ्रेमवर्क बताया हमें इंटेलेक्चुअल प्रॉपर्टी के बारे में, अब उसको थोड़ा और ग्रास रूट पे लेके आते हैं। कौन सी कोर्ट है जिसको आप अप्रोच कर सकते हैं फॉर इन्फोर्समेंट ऑफ दीज इंटेलेक्चुअल राइट्स? आपके पास क्लाइंट्स आते होंगे, वो कहते होंगे भाई मैं तो यहाँ जबलपुर में एक शॉप चला रहा हूँ और किसी ने मेरे ऊपर दिल्ली में केस डाल दिया, ये दिल्ली में कैसे डाला? ये बहुत इंपॉर्टेंट क्वेश्चन है, बिकॉज उस लिटिगेंट को नहीं समझ आ रहा है कि मैं जो जबलपुर में बैठा हूँ मेरे ऊपर दिल्ली में क्यों केस डल रहा है, जबलपुर क्यों नहीं आ सकता वो? उसके दो आंसर्स हैं। जनरल सीपीसी जो हमने अंडरस्टैंड की है अभी तक, वो यही है कि जहां पे डिफेंडेंट है या जहां कॉज ऑफ एक्शन है, आप वहां पे सिविल दावा डालेंगे। लेकिन इंटेलेक्चुअल प्रॉपर्टी लॉ में एक्सेप्शंस कार्व आउट किए। सेक्शन 134 ऑफ द ट्रेडमार्क एक्ट एंड सेक्शन 62 ऑफ द कॉपीराइट एक्ट कार्व्ड आउट दीज एक्सेप्शंस। जैसे जस्टिस बंसल ने बताया कि इंफ्रिंजमेंट और पासिंग ऑफ में डिफरेंस है। इंफ्रिंजमेंट है जहां पे ट्रेडमार्क रजिस्टर्ड है, कॉपीराइट में भी कॉपीराइट रजिस्टर्ड है। वहां पे जहां प्लेंटिफ है वहां पे वो अपना दावा डाल सकता है, उसको डिफेंडेंट को नहीं सीक करना जहां पे उसका वायलेशन कर रहा है। वो जहां पे वो है वहीं पे वो दावा अपना डाल सकता है। ये एक्सेप्शन है टू द सीपीसी। बट दूसरा, और जो आज मेरा टॉपिक है बताने का, वो है ज्यादा कि अब सुबह आई थिंक जैसे महेश्वरी ने भी बोला और बाकियों ने भी बताया, with the increasing use of internet, how has this concept of jurisdiction changed as far as IP law is concerned? ये जो इंटरनेट है इसका क्या इफेक्ट हुआ है IP law की jurisdiction पे? अब आज की डेट में आपके पास शायद शॉप हो ही ना, आप सारा का सारा जो सामान है वो उसको सिर्फ ऑनलाइन बेच रहे हैं। ऐसे में कौन सी कोर्ट की जुरिस्डिक्शन है अगर एक प्लेंटिफ कहता है कि मेरा ये मार्क इन्फ्रिंज हो रहा है या मेरा ये कॉपीराइट इन्फ्रिंज कर रहे हैं? उसके लिए कोर्ट ने 2-3 टेस्ट निकाले। उन्होंने कहा कि आप उस वेबसाइट को टेस्ट कीजिए कि वो किस टाइप की वेबसाइट है। क्या वो इंटरैक्टिव वेबसाइट है या पैसिव वेबसाइट है? इंटरैक्टिव वेबसाइट है कि अगर आप एक्चुअली इंटेंड कर रहे हैं कि ये आदमी इस वेबसाइट से इस चीज को खरीदे। पैसिव वेबसाइट है जैसे कि एक बिजनेस की अपनी एक वेबसाइट होती है, वो सिंपली बस अपना एक वेबसाइट उसने खोली हुई है कि ये बिजनेस है मेरा। ही इज नॉट इंटेंडिंग, ही इज नॉट गोइंग फॉर एनी कस्टमर इन अ पर्टिकुलर एरिया, वो बस सिंपली अपने बिजनेस के बारे में एक वेबसाइट उसने खोली हुई है। उसका टेस्ट फिर बताया गया कि अगर वो इंटरैक्टिव वेबसाइट है और अगर वो टारगेट कर रही है एक पर्टिकुलर जुरिस्डिक्शन में कस्टमर्स को, तो उस जुरिस्डिक्शन में कॉज ऑफ एक्शन अराइज होगा और उस कोर्ट की जुरिस्डिक्शन होगी। सो फॉर एग्जांपल आज की डेट में लेट्स से अमेज़न है। अमेज़न पे आप अपना प्रोडक्ट एडवर्टाइज कर रहे हैं, अवेलेबिलिटी पा रहे हैं, आप टारगेट कर रहे हैं कस्टमर को, वो आपको अगर ऑर्डर करता है तो आप उसको वो सप्लाई करते हैं, अगर विद इन अ पर्टिकुलर jurisdiction maybe, in that event that jurisdiction that court of having jurisdiction over that area will have jurisdiction for that case। चाहे आप कहीं पे भी हो, आप चाहे अहमदाबाद में हो, लेकिन अगर आपने जबलपुर में अमेज़न वगैरह पे आपने अपना प्रोडक्ट एडवर्टाइज कर रखा है तो जबलपुर में उसकी जुरिस्डिक्शन है। दूसरी तरह से पैसिव वेबसाइट में लेट अस से जस्ट डायल है या इंडिया मार्ट है, जो सिर्फ ये बताता है कि इस टाइप का एक प्रोडक्ट है अवेलेबल। यू आर नॉट टारगेटिंग एनी ऑडियंस, यू आर नॉट टारगेटिंग एनीवन। उसमें उस कोर्ट की जुरिस्डिक्शन नहीं है। मेयरली बिकॉज मैंने वो वेबसाइट दिल्ली में खोल ली, इसका मतलब ये नहीं है कि दिल्ली कोर्ट की जुरिस्डिक्शन हो गई उस केस में, क्योंकि ये वेबसाइट कभी टारगेट ही नहीं कर रही थी दिल्ली ऑडियंस को। कभी मेरा इंटेंट था ही नहीं दिल्ली ऑडियंस को इस टारगेट करने का। सो ये ऑनलाइन जैसे अब आ रहा है, उसके बाद अगेन डिफरेंट काइंड ऑफ डिस्प्यूट्स विल कीप कमिंग बिकॉज एवरीवन विल चैलेंज द jurisdiction that why have a person come and sued me in Delhi or sued me in Jabalpur or sued me in Indore? Why not where I am? And these answers lie in these kind of tests that we evolve over the period of time. दूसरी जो प्रॉब्लम आ रही है वो भी जस्टिस बंसल ने थोड़ा पासिंग में बताया आपको कि डोमेन नेम रजिस्टर हो जाते हैं बड़ी बड़ी कंपनीज के नाम पे और उसके बाद उनको मिसयूज किया जाता है कहने के लिए कि भाई हम आपको डिस्ट्रीब्यूटरशिप ऑफर कर रहे हैं, हम आपको कोई एक कंसेशनल रेट पे लोन्स दे रहे हैं, और जो ऑर्डिनरी कस्टमर है उसको नहीं पता है कि ये जो डोमेन नेम है, लेट अस आई एम जस्ट गिविंग यू एन एग्जांपल, लेट्स से टाटा का मिसयूज हुआ, उसको नहीं पता ये टाटा है या ऐसे ही किसी ने बस रजिस्टर करके और उसको ये ऑफर कर रहा है। अब उसमें जब टाटा स्यू करता है तो जैसे बंसल ने बताया एंड ये किसने एक्चुअली शुरू किया, तब तक बहुत फ्रॉड हो चुके हैं, किसने शुरू किया ये नहीं पता लगता। तो एक टाइप ऑफ लिटिगेशन जो अब सामने आ रहा है जिसके आप कन्फ्रंट करेंगे वो ये है कि जो डोमेन नेम रजिस्ट्रांट्स हैं वो कहते हैं हम तो इंडिया में है ही नहीं, मेरा जो सर्वर है वो सिंगापुर में है या मेरा वो सर्वर किसी और कंट्री में है, सो आपके पास जुरिस्डिक्शन है ही नहीं इस केस को सुनने की, आप मेरे को कुछ भी डायरेक्ट नहीं कर सकते। But Delhi High Court in various cases has negated this plea and said कि अगर आपने एक डोमेन नेम रजिस्टर किया है तो आपको उसके जो रजिस्ट्रांट है उसके डिटेल्स आपको डिस्क्लोज करने चाहिए, करने पड़ेंगे। उसके बाद उसको ढूंढा जा सकता है या नहीं ढूंढा जा सकता, वो पैसा रिकवर कराया जा सकता है नहीं कराया जा सकता, सेकेंडरी है। बट पहले कम से कम पता तो लगे कि किसने ये रजिस्टर की है, और उसके लिए आप जुरिस्डिक्शन को नहीं चैलेंज कर सकते बिकॉज आप इंडिया में काम कर रहे हैं। आप इस जुरिस्डिक्शन में ही काम करके आप नहीं कह सकते कि इस जुरिस्डिक्शन, इस कोर्ट की जुरिस्डिक्शन नहीं है उस केस पे। एक और जो चीज जस्टिस बंसल ने डील की वो थी रोग वेबसाइट्स। आजकल इंडिया साउथ अफ्रीका सीरीज चल रही है, वो एक पर्टिकुलर चैनल दिखा रहा है, बट उसकी फ्री स्ट्रीमिंग आप जो भी बच्चे हैं यहाँ पे, वो आई एम श्योर दे वुड बी नोइंग, कोई भी नई मूवी रिलीज होती है किसी भी चैनल पे नहीं आ रही है, बट वो कहीं ना कहीं एक स्ट्रीमिंग वेबसाइट है जो कि इलीगल है और एक्चुअली मे बी डेंजरस भी है बिकॉज उसके साथ वायरस भी आ सकते हैं, लेकिन वो स्ट्रीम करती है वो मूवी। दीज आर इन लीगल पार्लेंस कॉल्ड द रोग वेबसाइट्स। रोग वेबसाइट क्यों है? क्योंकि आप एक साइट के अगेंस्ट अगर इंजंक्शन लेंगे, ये सारी की सारी अल्फा न्यूमेरिक वेबसाइट्स होती हैं, वो कुछ नहीं है, वो अपना एक नंबर चेंज कर देगा, अपना एक अल्फाबेट चेंज कर देगा वेबसाइट का, और वही स्ट्रीमिंग फिर से चालू हो जाएगी। सो दिल्ली हाई कोर्ट में जब ये फर्स्ट टाइम प्रॉब्लम आई, यूटीवी केस बहुत फेमस है, तो उसके लिए उन्होंने एक नाम दिया इंजंक्शन का, डायनेमिक प्लस। What is this dynamic injunction? That for this content, कोई भी वेबसाइट उसका चाहे अल्फा न्यूमेरिक नंबर चेंज भी हो जाए, जो उसका ओनर है कंटेंट का, वो गवर्नमेंट को लिख सकता है मिनिस्ट्री ऑफ इंफॉर्मेशन एंड टेक्नोलॉजी में कि ये मेरा कंटेंट है, ये वेबसाइट मैंने अभी देखी है, इसमें ये चल रहा है, आप प्लीज इसको इंजंक्ट करो। और उसके लिए उसे कोर्ट नहीं आना है हर बार। एक जनरल इंजंक्शन ऑर्डर इज गुड इनफ for him to go to the ministry and ask for a blocking of a site. Of course, he has to then immediately move an affidavit in the High Court saying कि मैंने इस वेबसाइट के अगेंस्ट भी इस तरह से इंजंक्शन अपना यूज किया है, ताकि अगर वो वेबसाइट उसको चैलेंज करना चाहे, they can come to the court and they can defend themselves. इस डायनेमिक प्लस को फिर और एक्सटेंड किया गया, डायनेमिक प्लस। Now, one of the honorable judge has used the word superlative injunction. Superlative is कि आपने injunction has been passed on one particular platform. Let's say आपने Twitter पे एक injunction दे दिया, but वो Twitter से कल को वो Telegram पे वही चीज स्टार्ट हो गई। So एक बार आपके पास injunction है तो आप उसको different platforms के लिए भी लेके जा सकते हैं कि मेरे पास इस content के ये है इंजंक्शन, और इसको आप प्लीज एक्सटेंड कीजिए इस प्लेटफॉर्म पे बिना कोर्ट आए। और उसके बाद आफ्टर, बिकॉज ये डैमेज इमीडिएट है, एक बार मूवी की लाइफ है ही सिर्फ एक हफ्ता प्रॉबेबली आजकल, या स्पोर्टिंग इवेंट की तो उसी टाइम है, उसके बाद हाइलाइट्स में तो कोई फन है नहीं, वो तो लाइव इवेंट ही है। तो उस लाइव इवेंट में अगर जब तक मैं कोर्ट आऊंगा, कोर्ट से एक इंजंक्शन लूंगा और उस इंजंक्शन को इन्फोर्स करने जाऊंगा, इवेंट तो खत्म हो गया, उसकी लाइफ खत्म हो गई, उसकी इंजंक्शन की वैलिडिटी खत्म हो गई। सो कोर्ट ऑलवेज हैज टू इवॉल्व विद द टेक्नोलॉजी and has to come out with new type of concepts, new type of relief which can be given, and this again is an ingenuity of a lawyer. कोई जज अपने आप नहीं लेके आता है, आप जैसे ही कोई एडवोकेट हैं जिन्होंने रिसर्च किया what is happening worldwide, what is happening in technology, and then inform the judiciary कि ये इस type से इसका answer है, आप please इसको कीजिए. And of course, within the parameters of law, within the four corners of law, we are always willing to see that the order is fully enforced and in a proper manner. So this is again two arms of the judiciary which are working together to show that the rights of the people are protected. At the same time, we don't cross the borders, because everything is very territorial in nature, especially the intellectual property law. It is very, very territorial in nature. You can't go beyond your boundaries of your country and say, oh, I am injuncting someone in America to do something. You can't. But if he is coming to India and doing something in India, you certainly have that jurisdiction. And if he is wanting to violate it in different manners, then the law will try and give you a remedy in one form or the other. As someone said, where harm is felt and market is targeted, the law follows. I think that's beautifully put as far as IP jurisdiction is concerned. Thank you very much for your patience with us. And now, as both my brothers have offered, we are open to questions. अगर किसी का कोई question है तो please. We'll just come to you. Let him.
My question is regarding the last part of the lecture. I want to ask that what is the scope of anti-suit injunction in IPR? Because you said that you can't travel beyond the territories, but where there are foreign entities and Indian firms are involved, in order to prevent Indian firms from oppressive legal proceedings in foreign courts, your court certainly has jurisdiction to give anti-suit injunction to a foreign entity in order to prevent oppressive litigation in a foreign country, to prevent an Indian firm.
See, anti-suit injunction presently is being used in two forms. One is a general form which is, let's say, in arbitration, where a foreign party is wanting to initiate arbitration maybe without even having an agreement in the arbitration act, of an arbitration agreement. In that event, suits are filed in India to take an anti-suit injunction or anti-arbitration injunction as far as those matters are concerned. Of course, because of committee of courts, the court in India will always be constrained and always feel restricted to grant an injunction on a foreign jurisdiction and to say the court can't proceed. It can at best try and give that injunction against that party from proceeding against in a foreign jurisdiction. In IP law, because we have a topic of IP law also, especially in patents, actually there is a special provision where you can take a anti-suit injunction which is called a unlawful threat injunction against someone who claims that he has a patent, but actually you are wanting to challenge that patent and say that that patent is not valid. So you can say that this was an unlawful threat to me as far as patent is concerned. So both the ways, it's not a matter of lack of jurisdiction, it is more a matter of restriction of that jurisdiction, self-contained restriction on that jurisdiction.
Sometimes it's used.
Justice Bansal may like to, or Justice.
My question is to Justice Bansal. Sometimes could it be used in trademark litigation also?
Yes, let me give you a live example जो बहुत often court में हो रहा है, that in patent cases which involve our mobile phone market is now dominated by Chinese players, Oppo, Vivo, etc. So there is a lot of litigation between the mobile phone owners and the companies which provide technology, which could be Nokia, Ericsson, and these Dolby. So the litigation is, supposing it is happening in China, these Chinese mobile companies get an injunction against the Indian party, a foreign party, saying that you will not get an anti-suit injunction, you will not file a suit in India. But that person comes and says to the Indian court, I have registered my patent here. So how can you ask the jurisdiction of Indian courts when the patent is registered here? It involves Indian law. Every court has a different patent law. So Indian court in this case has been granting something anti-suit injunction. So they will say that so far as the Indian rights are concerned, because of the registration of IP in India, the party cannot restrain the Indian courts to decide this issue.
Sir, I will also add in, Justice Chawla said in the arbitration thing. So there's a very landmark judgment given couple of days ago by Justice Purushendra Kaurav, which is so well written. There were two parties, one Indian party and one a foreign company. They had a international arbitration under Singapore, ICC arbitration under Singapore. In the Arbitration Act, the arbitrator, सर मेरी बात सुनेंगे नहीं तो फिर मैं आपको बताऊंगा कैसे आपके सवाल का जवाब. तो उसमें arbitrator has to disclose his interest that I am not connected with any party. Arbitrator साहब ने वो disclosure दिया, but that was a wrong disclosure. Kaurav साहब ने in a section 9, was it section 9, 37, civil suit, he injuncted Singapore arbitration, ICC arbitration, which according to me is anti-suit and a fantastic judgment.
Anti-arbitration हुई ना?
सर आप वो
I think you can.
दिल्ली हाई कोर्ट की जजमेंट कहेंगे या एमपी हाई कोर्ट की, वो आप देख लीजिए.
सभी ऑडियंस से रिक्वेस्ट है, प्लीज रिस्ट्रिक्ट योर क्वेश्चंस एंड फ्रेम देम सो वेल दैट वी आर एबल टू टेक मेनी मोर क्वेश्चंस. 5 मिनट में और जो किसी के क्वेश्चंस हो तो प्लीज 1 क्वेश्चन पर पर्सन. यू कैन ग्रिल देम लेटर ऑन.
सर नमस्कार. सर मेरा क्वेश्चन आर्बिट्रेशन एंड कमर्शियल लॉ के सब्जेक्ट से नहीं मगर आज के सब्जेक्ट से है. जितने आगंतुकगण आज आपको सुन रहे हैं और जितने नहीं आए उन सबकी तरफ से कि मैं 2011 से प्रैक्टिस में हूँ, पर 14 वर्ष के मेरे प्रैक्टिस अवधि में पहली बार ऐसी कार्यशाला आयोजित माननीय मुख्य न्यायाधिपति महोदय के सानिध्य में हुई. तो जो आए हैं वो भी मन प्रश्न कर रहे हैं, जो नहीं आ पाए वही प्रश्न कर रहे हैं कि आगामी ऐसी अद्भुत कार्यशाला अब कब आयोजित होगी.
ये आपको जैसे सदेवा से ही पूछना पड़ेगा.
हम आने के लिए तैयार हैं.
सर उसका कारण ये था कि माननीय न्यायाधिपति महोदय दिल्ली से पधारे हैं और शीघ्र दिल्ली प्रस्थान करने वाले हैं. अंतर सिर्फ
यही हमारी होप है और यही हमारी प्रेयर है.
अंतर सिर्फ इतना सर कि दिल्ली उच्च न्यायालय से पधारे और दिल्ली के सर्वोच्च न्यायालय जाने वाले हैं. तो ऐसा कुछ माननीय मुख्य न्यायाधिपति महोदय, माननीय श्री विवेक अग्रवाल साहब और माननीय नए एडमिनिस्ट्रेटिव न्यायाधीश महोदय करते कि कम से कम हर 3 माह या 6 माह में हम अधिवक्ताओं के लिए ऐसी कार्यशाला.
अभी कॉन्फ्रेंस के बाद आप इनको पकड़ लीजिएगा प्लीज. बट लेट दैट लेडी हैव अ क्वेश्चन एंड आई थिंक वी विल रैप अप.
A very good evening, sir. So my
Yes.
question is, sir, what is the line crossing which the alleged contravention or infringement could be declared infringement in a true sense? Like it should reach the public domain in a very true sense. Like I, for example, in a very rural and a remote area, I open a Louis Vuitton bags shop or a Chanel perfumes where people are really unaware of the brands which are present. So will it also damage or infringe the trademark or the very brand's name or use?
तो रूरल एरिया में क्यों वो कोई बेचेगा लुई विटॉन?
So because I want to keep that name, I'm very fascinated about but people are unaware of the thing.
उसकी इंटेंट ठीक नहीं है ना. If they want to open in a rural area and people don't know, why would they open Louis Vuitton and Chanel? Obviously the intent is you can make good bags and have your own brand, but if you're using some famous brands, then obviously the idea is to take benefit of the goodwill and reputation of those brands, no?
इसमें एक और कॉन्सेप्ट भी है, डाइल्यूशन ऑफ मार्क का. सी एक बहुत ही वेल नोन मार्क अगर आप उसको ऐसे ही यूज करने दें तो उसकी वैल्यू खत्म हो रही है. सी व्हाई डिड आई स्टार्ट बाय सेइंग दैट इट इज नाउ द मोस्ट इंपॉर्टेंट प्रॉपर्टी ऑफ अ बिजनेस, ऑफ एनी बिजनेस. वो जो कॉन्सेप्ट पहले होता था, व्हाट्स इन द नेम इज गॉन, एवरीथिंग इज इन द नेम, राइट? सो इफ यू अलाउ इवन अ स्मॉल प्लेयर टू डू समथिंग स्मॉल one day, there'll be another one, another one, and another one. And eventually you'll be told that, sorry, this is such a common mark. As Justice Bansal in one of the defenses said, is that it is such a common name. Why are you wanting to injunct me? So that is very important, that why even a small player, even in a remote village maybe, it is for that business to decide, is it worthwhile for him to actually approach court and take an injunction against him. And most of it actually evolves around the dishonest intent. That person is not doing it because he got a message from the Almighty that this is a very good name in which you are going to do a very good business. He wanted to copy something and he felt that he will make some money out of it.
Thank you so much.
Good evening, dignitaries. My question is, a lot of social media influencers today are promoting the use of products directly, indirectly. My question is, they use the word disclaimer in that. So can that word disclaimer be nullify or waive off their accountability if any mishap happens to regarding that specific product?
No, disclaimer will not help at all. Disclaimer will, and social media influencers these days, famous brands hire them. If somebody is very famous on YouTube, a big brand will hire them to promote their products. So it's not they are doing it independently, they are acting like an advertising agency of that big brand. So disclaimers and all will not at all help them.
Thank you, sir.
I think we can close the...
I seek permission of the Honorable Chair to close the session.
Yes, thank you.
Thank you, Lordship.
Just last question.
Okay.
जनरली सर कंपनीज आर्बिट्रेशन अवार्ड पास करवाती हैं, हैदराबाद, मुंबई, कहीं से भी करवा लेती हैं. बहुत सी कंपनियां हैं, ऑटो पार्ट्स वाली हैं, ऑटोमोबाइल्स वाली हैं, या फाइनेंस से रिलेटेड होती हैं. समस्या ये होती है कि जब हम वहाँ पे पहुँचते हैं तो आर्बिट्रेटर का पता नहीं चलता है, या आर्बिट्रेटर कहता है कि हमारे पास वो केस ही नहीं है. तो उस समय पे क्या रेमेडी कर सकते हैं, ले सकते हैं उस अवार्ड को चैलेंज करने के लिए?
एक तो जी ये जो आपने कहा कि कंपनीज आर्बिट्रेटर अपॉइंट करके, दैट इज नाउ सेटल्ड. जजमेंट्स ऑफ द सुप्रीम कोर्ट, पर्किंस, टीआरएफ के जो पार्टी इंटरेस्टेड है आर्बिट्रेशन में, वो अपना आर्बिट्रेटर अपॉइंट नहीं कर सकती. सो वो आप ऑब्जेक्शन इनिशियली ले सकते हो. अगर इनिशियली आपको जैसे एक्स पार्टी अवार्ड हो गया, आपको पता भी नहीं चला, व्हेन यू कम इन एग्जीक्यूशन, इन एन एग्जीक्यूशन ऑल्सो व्हेन दे कम, आपके वो एग्जीक्यूशन डालेंगे कि जी इन्होंने 120 दिन में चैलेंज नहीं की, 34 नहीं डाली. तो जब एग्जीक्यूशन डालेंगे, द मोमेंट यू गेट समन्स, यू गो एंड से इट इज़ यूनिलैटरल अपॉइंटमेंट, वो दैट अवार्ड विल बी सेट असाइड. द लॉ इज, इट इज़ अ नलिटी इन लॉ फ्रॉम डे वन, सो देयर इज नो प्रॉब्लम.
उसके लिए केस लॉ कौन सा है?
एग्जीक्यूशन में सेक्शन 47 में आप डालेंगे ऑब्जेक्शन सीपीसी की.
पर्किंस जजमेंट है सुप्रीम कोर्ट का. पर्किंस.
Thank you, Lordship. As we conclude the final technical session of the day, on behalf of the High Court of Madhya Pradesh and Madhya Pradesh State Judicial Academy, I express deep gratitude to the Honorable Chair and esteemed panelists for their scholarly insights and meaningful deliberations. Thank you. I request everyone to kindly please remain seated as we move into the valedictory session. We are about to begin the valedictory session, so please remain seated. Thank you.
May I request Registrar General Sir to please escort our dignitaries on the dais. Honorable Mr. Justice Sanjeev Sachdeva, Chief Justice High Court of Madhya Pradesh, Honorable Mr. Justice Vivek Rusia, Administrative Judge High Court of Madhya Pradesh, Honorable Mr. Justice Vivek Agarwal, Judge High Court of Madhya Pradesh and Chairman Governing Council State Judicial Academy, Honorable Judges Delhi High Court and High Court of Madhya Pradesh, Shri Dhanya Kumar Jain, President Madhya Pradesh High Court Bar Association, Shri Sanjay Agrawal, President High Court Advocates Bar Association, Shri Radhelal Gupta, Chairman Bar Council of Madhya Pradesh, Shri Umesh Pandav, Director Madhya Pradesh State Judicial Academy, dignitaries present in the auditorium, esteemed participant advocates, ladies and gentlemen, warm greetings to everyone. We welcome everyone for the valedictory session of the Conference on Advocacy and Professional Competence, Pursuit of Excellence for Advocates, being organized by the High Court of Madhya Pradesh and Madhya Pradesh State Judicial Academy. Commencing the valedictory session, we would begin the session with felicitation of our honorable dignitaries. May I request Shri Dharminder Singh, Registrar General, High Court of Madhya Pradesh, to kindly welcome Honorable the Chief Justice by presenting His Lordship a planter. Next, I request Shri Krishnamurti Mishra, Principal District and Sessions Judge Jabalpur, to kindly welcome Honorable Mr. Justice Vivek Rusia by presenting His Lordship a sapling. May I now request Ms. Suman Srivastava, Member Secretary MPSLSA, to kindly welcome Honorable Mr. Justice Vivek Agarwal by presenting His Lordship a sapling. May I now request Shri Rajendra Kumar Sharma, Principal Registrar Vigilance, High Court of Madhya Pradesh, to welcome Shri Dhanya Kumar Jain, President Madhya Pradesh High Court Bar Association, by presenting him a planter and a memento. Next, I request Shri Sharad Bhamkar, Principal District Judge Inspection, High Court of Madhya Pradesh, to welcome Shri Sanjay Agrawal, President, High Court Advocates Bar Association, by presenting him a planter and a memento. I would now request Shri Sunil Kumar, Principal Registrar Judicial, to welcome Shri Radhelal Gupta, Chairman High Court Bar Council, to present him a planter and a memento. Thank you, sir. Now I would request Shri Ajay Singh Thakur, Principal Registrar Examination, to welcome Shri Aditya Adhikari, General Secretary, Senior Advocates Council, by presenting him a planter and a memento. Lastly, I would request Srimati Archana Singh, Secretary, High Court Legal Services Committee, to kindly welcome Shri Umesh Pandav, Director, MPSJA, by presenting him a planter and a memento. Thank you very much, ma'am. I would request Shri Radhilal Gupta, Chairman, State Bar Council of Madhya Pradesh, to kindly address us.
Honorable Justice Sri Sanjeev Sachdeva ji, Chief Justice High Court of Madhya Pradesh, Honorable Sri Vivek Rusia ji, Administrative Judge, High Court of Madhya Pradesh, Sri Vivek Agarwal Sahab, Senior Most Judge, High Court of Madhya Pradesh, Sri Umesh Pandav Sahib, Director, Judicial Academy, D.K. Jain Sahab, High Court Bar Association, Jabalpur, Sanjay Agarwal Sahab, High Court Advocate Bar Association, Jabalpur, Sri Adhikari Sahab, Senior Counsel, and उपस्थित सभी मेरे कनिष्ठ अधिवक्तागण, वरिष्ठ अधिवक्तागण, माननीय न्यायमूर्तिगण और स्टूडेंट्स, आज सबसे पहले मैं धन्यवाद दूंगा माननीय मुख्य न्यायाधिपति महोदय को, जिन्होंने इतने बड़े सेमिनार को ऑर्गेनाइज किया और हम सभी को ये अपॉर्चुनिटी दी कि आज हम इस प्रकार के सेमिनार को अटेंड करें और यहाँ पर अपना ज्ञान वर्धन करें। इसी तरह का सेमिनार इंदौर में आयोजित हुआ था जो 2 दिन चला था, वहाँ भी हम लोग ने अटेंड किया था सेमिनार, और अब अगला सेमिनार ग्वालियर में होगा जो दिसंबर में है। माननीय विवेक अग्रवाल साहब, माननीय विवेक रूसिया जी भी जो इंदौर से यहाँ आए हैं, ये भी इस दिशा में बहुत सार्थक प्रयास कर रहे हैं और हम लोगों को भी सहयोग दे रहे हैं बार काउंसिल को, कि ताकि हम लोग ऑनलाइन और जितना भी सिस्टम है उसको अप टू डेट कर सकें। आज जो भी सब्जेक्ट्स आए उसमें PIL, आर्बिट्रेशन, सभी प्रकार का हम लोगों ने देखा। चूँकि मैं बार काउंसिल से हूँ तो मैं ये बताना चाहूँगा कि बार काउंसिल का काम भी है एडवोकेट्स का पहले रजिस्ट्रेशन करना, वेलफेयर करना, और उसके बाद मुख्य चीज़ जो है वकीलों में डिसिप्लिन। आज की जो हमारी समस्या है सबसे ज़्यादा ये बढ़ रही है कि रजिस्ट्रेशन कराते हैं मान लीजिए 10,000 वकील एक साल में, लेकिन प्रैक्टिस में हार्डली 2,500 या 3,000 ही आ पाते हैं। 7,000 जो रजिस्ट्रेशन होते हैं ये पता ही नहीं चलता कि वो कहाँ रहते हैं, कौन सा व्यवसाय कर रहे हैं, क्या कर रहे हैं, इस प्रकार की स्थिति है। और इसी चीज़ को देखते हुए ऑनरेबल सुप्रीम कोर्ट ने एक हाई लेवल कमेटी बनाई है जिसमें 2 सुप्रीम कोर्ट के न्यायाधीश, एक चीफ जस्टिस, एक हाई कोर्ट जज रिटायर्ड और एक बार काउंसिल ऑफ इंडिया का मेंबर रहेगा। उस कमेटी ने अपना काम स्टार्ट भी कर दिया है, सुपरवाइजरी, और वेरिफिकेशन का काम पूरे देश में तेज़ी से चल रहा है। वेरिफिकेशन जो हो रहा है उसका रिजल्ट भी आ रहा है कि जितने डॉक्यूमेंट्स हम लोग वेरीफाई कराते हैं यूनिवर्सिटी से, उसमें अगर 5,000 हम लोगों ने वेरीफाई कराए हैं तो 50 डॉक्यूमेंट ऐसे हैं जो पूरे देश में फेक पाए गए हैं, और पाया गया कि उन वकीलों ने फर्जी सर्टिफिकेट पेश करके वकालत का संस्करण किया। हम लोगों ने उनके खिलाफ तत्काल एक्शन लिया और यहाँ तक कि FIR करके उनके खिलाफ पुलिस कंप्लेंट में केस दर्ज करवाया। वेरिफिकेशन कंपलसरी, सुप्रीम कोर्ट तक भी जब बात आई तो सुप्रीम कोर्ट ने भी वेरिफिकेशन को कंपलसरी कर दिया। और आज स्थिति यह है कि हमको हर महीना रिपोर्ट देना पड़ती है जो सुपरवाइजरी कमेटी बनी है उसको, कि हम लोगों ने इस महीने कितने वेरिफिकेशन किए, और तेज़ी से वेरिफिकेशन का काम चल रहा है। हालांकि इसमें हम लोगों को यूनिवर्सिटी का सहयोग कम मिल रहा है। यूनिवर्सिटी में अगर हम सर्टिफिकेट भेजते हैं 1000, तो मुश्किल से महीने में 100 सर्टिफिकेट्स का भी वेरिफिकेशन नहीं हो पाता। जब हमने ये कंप्लेंट सुप्रीम कोर्ट में पेश की, अपना पक्ष रखा, तो वहाँ से डायरेक्शन हुआ कि यूनिवर्सिटीज़ में अगर सहयोग नहीं देंगी तो उनके खिलाफ भी कार्रवाई होगी। तो इस तरह से जुडिशरी से साइड से भी, सुप्रीम कोर्ट तरफ से भी, हाई कोर्ट तरफ से भी हम लोगों को जो सहयोग मिल रहा है वो अभूतपूर्व है। हमारे हाई कोर्ट में चूँकि माननीय सचदेवा साहब हमारे चीफ जस्टिस बार काउंसिल ऑफ इंडिया के काउंसिल भी रहे हैं, वो भी बार काउंसिल के मामलों में हम लोगों को डिसिप्लिन के साथ चले इसके लिए बड़े जागरूक रहते हैं। ऑनलाइन के मामले में हमें विवेक अग्रवाल साहब और विवेक रूसिया जी इंदौर से ही एडवाइस करते थे कि अपना पूरा काम ऑनलाइन से कर दो। आज स्थिति यह है कि इन दोनों के सहयोग से हम लोगों ने ऑनलाइन रजिस्ट्रेशन 90% हमारा काम ऑनलाइन स्टार्ट हो चुका है। इस तरह से बार काउंसिल का जो काम है डिसिप्लिन का ये चल रहा है। रहा वेलफेयर का, तो जितनी स्कीम्स है वो भी हम लोग कर रहे हैं और समय समय पे हमें मार्गदर्शन प्राप्त होता रहता है। मुझे ये मौका दिया, 3 मिनट बोलने का समय था, लगभग समाप्त हो गया है। मैं आप सभी ऑर्गेनाइजर्स को उसके लिए धन्यवाद देता हूँ।
I now request Shri Aditya Adhikari, General Secretary, Senior Advocates Council, Jabalpur, to please address us.
Honorable Chief Justice Sanjeev K. Sachdeva, Honorable Justice Vivek Rusia, Administrative Judge, High Court of MP, and Honorable Justice Vivek Agarwal, Honorable Judges of the Delhi High Court and High Court of Madhya Pradesh present today. Additional Advocate General Mr. Harpreet Rupra, speakers and resource persons for the conference, judges of the District Judiciary, officers of Madhya Pradesh State Judicial Academy, presidents, secretaries, and esteemed office bearers of various bar associations, senior advocates, distinguished guests, ladies and gentlemen, and participants. A very good evening to all of you. As we come to the conclusion of today's program on advocacy and professional competency, pursuit of excellence for advocates, it is with great satisfaction and gratitude that I address you all. Throughout the day, we were privileged to hear enlightening insights from honorable judges and distinct speakers who guided us and enriched us with clarity, direction, and renewed purpose in vital areas of legal practice. As the legal landscape grows more intricate, be it the expanding horizons of technology, the dynamics of commercial disputes, or the complexities of constitutional governance, continuous learning becomes indispensable. Programs like today are designed to strengthen these qualities, enabling advocates to serve their clients and society with excellence. As Justice Oliver Wendell Holmes said, the life of the law has not been logic, it has been experience. And experience becomes meaningful only when we continuously learn, reflect, and evolve. This program has been a step forward in that never-ending journey of learning. A word to the young lawyers and students of law present here today. Your journey may have challenges, but programs like this exist to support your growth. I hope you have taken inspiration from the great jurists before you and learned to hone and refine your craft. The foundation you build today will shape justice tomorrow. With this, I thank one and all of your patience, all for your patience and attention. Thank you.
Thank you, sir. I now request Shri Sanjay Agarwal, President, High Court Advocates Bar Association, Jabalpur, to share his thoughts with us.
Honorable the Chief Justice Shri Sanjeev Sachdeva, Honorable Administrative Judge Shri Vivek Rusia, Honorable Shri Justice Vivek Agarwal, Chairman, MP State Judicial Academy, Honorable Judges of the High Court, Honorable Judges of the Delhi High Court, Shri Radhelal Gupta, Chairman, State Bar Council of Madhya Pradesh, Shri Dhan Kumar Jain, President, High Court Bar Association, Shri Aditya Adhikari, Secretary, Senior Advocates Council, Registrar General and Officers of the Registry, Shri Umesh Pandav, Director, MP State Judicial Academy, its faculty and staff, Shri Krishnamurti Mishra, District Judge Jabalpur, and judges of the District Judiciary, members of the bar, ladies and gentlemen. Good evening to all of you. As we gather for the valedictory session of this remarkable program on advocacy and professional competence, pursuit of excellence for advocates, it is both an honor and a privilege to present our reflections at the conclusion of a truly enriching day. The MP State Judicial Academy has once again demonstrated why it stands at the forefront of judicial education in our state. Throughout its meticulous planning and seamless execution, it has created a space for meaningful learning, candid dialogue, and professional growth. We are sincerely grateful to the Academy for organizing a program of such depth and relevance as reflected in the official schedule and invitation shared with us. Throughout the day, the sessions have reminded us that advocacy is not merely a profession, it is a responsibility. Whether it was the discussion on the appreciation of evidence, the strategic understanding of writ jurisprudence and the pathways to the Supreme Court, or the powerful insights into intellectual property rights and commercial law in arbitral and commercial trials, every engagement has broadened our perspective and reaffirmed our commitment to excellence. The themes addressed in today's conference are not just academic, they reflect the future direction of our legal fraternity. As disputes grow more complex and litigants' expectations evolve, advocates must develop sharper analytical skills and a deeper grasp of emerging legal frameworks. These subjects prepare us for a rapidly changing legal landscape, ensuring we remain competent, adaptable, and effective in upholding justice. I wish to place on record our particular gratitude to the chief guest of today's inaugural function, Honorable Shri Justice J.K. Maheshwari, Judge Supreme Court of India, as also Honorable Shri Justice Satish Chandra Sharma and Honorable Shri Justice Alok Aradhe, Judges Supreme Court of India, for lending their presence and guidance to this initiative. Their encouragement fuels our resolve to uphold the finest traditions of the legal profession. On behalf of the entire bar, I extend my heartfelt thanks to all the honorable judges from the Delhi High Court and the distinguished former judges who graced these sessions with their wisdom. Their willingness to share experience, not just jurisprudential, but practical, has strengthened the bridge between the bench and the bar, a bridge essential for the health of our justice system. It is fitting to acknowledge the guidance and leadership of our patron-in-chief, Honorable Shri Justice Sanjeev Sachdeva. My Lord's vision for strengthening the bench-bar relationship and his unwavering commitment to enhancing the standards of legal practice in Madhya Pradesh have been instrumental in shaping initiatives such as this conference. And now it is my privilege to extend our deepest appreciation to the chairman of this prestigious Judicial Academy, Honorable Shri Justice Vivek Agarwal. We thank you, sir, for your efforts for organizing today's event and for always reminding us that learning is a continuous, lifelong process. I wish to acknowledge the invaluable efforts of the director of the Academy, Shri Umesh Pandav, and his entire team. Their coordination, hospitality, and attention to detail, whether in the sessions, the logistics, or the interactions, have ensured that the day was productive, meaningful, and memorable. The Delhi High Court is one of the most vibrant High Court of the country because of its diversity of litigation and the challenges the judges of the High Court are required to face. The Madhya Pradesh High Court is also an equally vibrant High Court and is also distinguished by an exceptional bench, judges whose clarity of thought, depth of learning, and commitment to justice set a standard for all of us at the bar. Their insights enrich every interaction, and we are fortunate to practice before a judiciary that combines wisdom with compassion. We look forward to future conferences where the esteemed judges of the Madhya Pradesh High Court may share their perspective, guidance, and vision, enriching our understanding and contributing to the continued advancement of our legal community. To my fellow members of the bar, I say that today's discussions are not meant to end here. They must translate into better preparation, sharper advocacy, deeper research, and a renewed sense of professional integrity. As the custodians of justice delivery on the front lines, our learning must reflect in every brief we handle, every argument we advance, and every client who places faith in us. Let us take forward the spirit of this program with seriousness and sincerity. Let us reaffirm our collective promise to the court, to society, and to the rule of law that we will keep striving for excellence both in competence and in character. With these words, I once again thank the State Judicial Academy, the Honorable Chair, and all dignitaries and participants for making this program a success.
Thank you, sir. I now request Shri Dhanya Kumar Jain, President, Madhya Pradesh High Court Bar Association, Jabalpur, to please address us.
माननीय मुख्य न्यायाधिपति महोदय, माननीय न्यायाधिपतिगण, दिल्ली से पधारे सभी माननीय न्यायाधिपतिगण, आप सभी को सादर नमस्कार। वैसे मैं बोल तभी पाता हूँ जब पहले से कुछ लिख लेता हूँ। आज मैंने कुछ भी नहीं लिखा है और यहीं पर बैठे दिमाग में जो आया मैं बोलूँगा। सबसे पहले मैं अपने माननीय मुख्य न्यायाधिपति को बहुत बहुत धन्यवाद देता हूँ। बहुत बेहतरीन उन्होंने यह कॉन्फ्रेंस कराई। इसके पहले की मैंने दिल्ली जो इंदौर की हुई थी वही भी मैंने अटेंड की थी। मैं इसलिए नहीं कहता हूँ कि मेरी जबलपुर में हुई है। वाकई में इंदौर की दोनों कॉन्फ्रेंस बहुत बेहतर कॉन्फ्रेंस है। मुझे लगता है कि हमारे यहाँ पर जो हुई है बहुत ऊंचे दर्जे का आपने यहाँ पर हमारे यहाँ पर हम लोगों के बीच में कार्यक्रम रखा है। अभी जो आपने हमारे सेकंड सेशन में हमारी मैडम माननीय रेखा पाली जी ने और ऑनरेबल जस्टिस ने कहा कि सेकंड सेशन में लोग बाग बहुत कम दिखते हैं, यहाँ के श्रोता बहुत लगता है बहुत अच्छे हैं। बाकी में पहले तो 2 हॉल भरे थे, अब इतने हैं। मैं इस संबंध में यही कहना चाहता हूँ हमारे मुख्य न्यायाधिपति महोदय को कि हम पहले जब छोटे थे और समय कोई मनोरंजन के साधन नहीं हुआ करते थे और कवि सम्मेलन आयोजित हुआ करता था तो सुबह जब प्रारंभ होता था तो पूरा मैदान भला रहता था और सुबह होते होते तक गिने चुने श्रोता बचते थे। तो वो जो श्रोता रहते थे वो वाकई में वो रहते थे, चूँकि जो आयोजक जो कवि सम्मेलन संचालक की ऐसे कवियों को रखा जाता था जो कि वाकई में सुनने की जो श्रोता थे समझने की क्षमता रखते थे। तो वास्तव में ये जो बैठे हैं वो श्रोता हैं जो आपने भी अच्छे जो वक्ता थे वो रोक के रखे, अच्छे आपने रोक के रखे और वो समझने वाले हमारे यहाँ जो बैठे हैं श्रोतागण वो वाकई में जो सच्चे श्रोता हैं वो आपने रोक के रखे। तो आपके लिए बहुत बहुत धन्यवाद कि ये जो सेकंड सेशन में जो हमारे बीच में जो हमारे ऑनरेबल जजेज आए और बहुत ऊंचे दर्जे की उन्होंने हम लोगों के सामने बात रखी। मैं उन सभी माननीय ऑनरेबल जजेस को बहुत प्रणाम करता हूं। अभी मैंने ये भी देखा कि माननीय जस्टिस रेखा पाली जी, मैंने देखा कि पता नहीं वो कैसे जज रही होंगी। यानी मुझे तो लगता है हाँ मुझे लगता है जैसे कोई मरने वाला मरीज जो आता है ना डॉक्टर के पास, मालूम है 2 दिन की ज़िंदगी बची है और डॉक्टर कहता तुम मरने वाले तो लेकिन तुम बहुत आराम से मरोगे दवाई, यानी उसको ये दवाई तो ऐसे मुझे लगता है ऑनरेबल जस्टिस गुप्ता जो है अगर वो कोई की पिटीशन डिसमिस भी करती होंगी तो ऐसे करती होंगी कि लोग तो लगता हो मेरे को बड़ा रिलीफ मिल गया। यानी हकीकत में क्या उनके चेहरे पर मुस्कुराहट हमें बड़ी ऐसे वाकई में ऐसे जज होते हैं, मुझे बड़ी प्रसन्नता हो रही है। मैं ये कहना चाहता हूँ सुबह जस्टिस हमारे जस्टिस माहेश्वरी साहब ने कहा कि सत्य का पालन करना चाहिए। वाकई में हम जब न्यायालय में खड़े होते तो हम कहते जो कुछ भी कहेंगे सत्य कहेंगे, लेकिन क्या वाकई में ऐसा होता है क्या? वाकई में हमारे न्यायालय की गरिमा घट क्यों रही है? क्या जो हम कहते हैं क्या वो सच होता है क्या? हम सच को कितना बेइज्जत करने का प्रयास करते हैं वहाँ पर। हम जानते हैं सच है तो भी हम उसे बेइज्जत करते हैं। तो कम से कम वाकई में अगर हम सत्य का पालन करेंगे तो वाकई में हमारे न्यायालय की मर्यादा बढ़ेगी। और मैं अंत में एक और बात मैं कहूँगा कि अभी हमारे माननीय मैंने एक बात देखी है समय की, अभी कहा था कि वो समय का ध्यान रखना चाहिए, कम समय में अपनी बात रखना चाहिए, कम समय हो और कम समय में अपनी बात रखो तो बहुत जल्दी आपको सही रिलीफ मिलता है। मैं इस संबंध में सिर्फ एक छोटी सी बात करना चाहता हूँ और वो मैं जैसे कई बार बसों में हम सफ़र करते हैं और बसों में सफ़र करते किसी का आने वाला स्टाफ है वहाँ उतरना है तो वो वहाँ पे बीच में रोका बस वहाँ पे उतरना है। लेकिन कुछ लोग ऐसे होते हैं जो हमें मालूम वहाँ उतरना, वो सामान बैग वैग बांध के तैयार रखते हैं, वैसी बस रुकी उतर जाते हैं। लेकिन कुछ लोग ऐसे होते हैं जब बस वहाँ खड़ी हो जाएगी तब वो अपना बैग ढूंढेंगे, तब अपने जूते ढूंढेंगे, यानी उनको कोई लेना देना नहीं है कि बस में बैठे हुए यात्री कितने परेशान हो रहे, उतने उनका कितना समय खराब हो रहा। ये ऐसे लोग होते हैं। ऐसे ही लोग न्यायालय में, जब न्यायालय में आप खड़े हो, आप तैयारी से खड़े हो ना। अरे समय आपके पीछे भी लोग केस देने वाले हैं, आपके और भी लोग लगे हैं, तो आप क्यों नहीं पूरी तैयारी से खड़े होते? वहाँ उस समय की कीमत क्यों नहीं समझते हो? इस समय की कीमत को हमें समझना चाहिए। हमारा समय समय नहीं है, दूसरे का भी समय समय है। इस बात की हमको हर समय ध्यान रखना चाहिए। मुझे इस बात के कई बार होता क्या, मेरे जैसा आदमी अगर बैठा हो और सामने वाले ने टाइम लगाया तो हम तो कहेंगे गाड़ी आगे बढ़ाओ या सामान इसका छोड़ा लो। तो सवाल ये है कि ऐसा नहीं होना चाहिए। अभी वेरिफिकेशन की बात करी, ऑनरेबल हमारे हाई कोर्ट स्टेट बार के प्रेसिडेंट साहब ने, ये वेरिफिकेशन चल रहा है। मैं इस संबंध में कहना चाहता हूँ, आप भी वही वाली बात कर रहे हो। बस स्टेशन पे आ गई, चुनाव स्टार्ट होने वाले, कर हम वेरिफिकेशन कर रहे हैं। अरे ये 5-6 साल आपको गुजर कर हम वेरिफिकेशन कर रहे हैं। अरे कुछ तो सोचो भैया, कुछ भी चिंता नहीं है आपको। सारे प्रदेश के 1.25 लाख वकील क्या बेवकूफ हैं क्या? हम वेरिफिकेशन कर रहे हैं। अब कोई ऐसा ना आ जाए कि बहुत बहुत धन्यवाद आपको, बहुत बहुत धन्यवाद।
Thank you, sir. I would now request Honorable Mr. Justice Vivek Agarwal, Chairman Governing Council, MPSJA, to please address us.
Honorable Chief Justice, Justice Sanjeev Sachdeva Sahab, Justice Vivek Rusia, Administrative Judge, Madhya Pradesh High Court, मंच पर आसीन श्री राधेलाल गुप्ता, चेयरमैन मध्य प्रदेश स्टेट बार काउंसिल, श्री धन्य कुमार जैन, प्रेसिडेंट हाई कोर्ट बार एसोसिएशन, श्री संजय अग्रवाल, हाई कोर्ट एडवोकेट, प्रेसिडेंट हाई कोर्ट एडवोकेट्स बार एसोसिएशन, श्री आदित्य अधिकारी, सेक्रेटरी जनरल सीनियर एडवोकेट्स काउंसिल, श्री उमेश पांडव, डायरेक्टर मध्य प्रदेश स्टेट जुडिशल एकेडमी, दिल्ली से आए सभी मेहमान, जज साहिबान, मेरे भाइयों, मध्य प्रदेश के जज साहब जो कि अभी बहुत बेताबी से चाय का इंतज़ार कर रहे हैं, रजिस्ट्री के सभी रजिस्ट्रार जनरल साहब एंड रजिस्ट्री के सभी लोग, प्रिंसिपल डिस्ट्रिक्ट जज जबलपुर, अधिवक्तागण एवं सभी दोस्त जो कि NLUI और अन्य लॉ कॉलेजेस से यहाँ पर आए हैं। वैलिडिक्ट्री का जो मतलब होता है वो होता है समिंग अप। तो एक तो ये अब समझ में आया कि जैन साहब ने जो है पूरे सेशन में बैठ के गरिमा तो बढ़ाई, लेकिन पहले सेशन से सीखा नहीं, क्रॉस एग्जामिनेशन में खुद ही गोल कर दिया। उन वकीलों के बारे में कह दिया जो कि बस में टाइम से नहीं बैठे, जो कि इनका वोट बैंक है अगले चुनाव के लिए। दूसरी बात यह है कि मैं जब ये सेशंस चल रहे थे तीनों, तो मेरे दिमाग में एक बात आ रही थी कि एडवोकेसी अल्टीमेटली, ये टॉपिक्स तो ठीक है भाई, रिट, रोड टू सुप्रीम कोर्ट, क्रिमिनल केसेस को कैसे डील करना है, ठीक है, इंटेलेक्चुअल प्रॉपर्टी राइट्स के मैटर को कैसे हैंडल करना है, लेकिन एक बात मेरे दिमाग से गुजरी जो कि मैं आपसे शेयर करना चाहता हूँ, वो ये कि एक किसी ने मनचले ने कहा कि बड़ी इज्जत थी तेरी इंटेलिजेंस, लेकिन कमबख्त वो भी आर्टिफिशियल हो गई। तो जब अब नौजवानों के मन में यह सवाल आएगा कि जब आर्टिफिशियल इंटेलिजेंस का युग है तो हम क्या करें, तो आपके लिए 2 सुझाव हैं। एक, अपनी जो नेचुरल इंटेलिजेंस है उसको आर्टिफिशियल इंटेलिजेंस के संबंध में मॉडगेज मत करिए, अपनी नेचुरल इंटेलिजेंस यूज़ करिए। एंड देन इंटेलिजेंस का शार्पन करने का एक तरीका है डिलीजेंस, दैट इज़ हार्ड वर्क, उसको जो है कभी भी पीछे मत हटने दीजिए। गोस्वामी, मैं अपनी बात कंक्लूड करने के लिए गोस्वामी तुलसीदास जी ने एक दोहा कहा है, उसको आपके साथ शेयर करना चाहता हूँ। साथी विपत्ति के विद्या विनय विवेक, साहत सुकृत सुसत्य व्रत, राम भरोसे एक। इसका अर्थ यह है कि विद्या विनय ज्ञान उत्साह पुण्य और सत्य भाषण आदि विपत्ति में साथ देने वाले गुण हैं, और अगर आप इन गुणों को आत्मसात करेंगे तो वकालत में या जीवन के किसी भी क्षेत्र में अपने आप को पीछे नहीं पाएंगे। धन्यवाद।
Thank you very much, Lordship. Now I take the privilege of inviting Honorable the Chief Justice to deliver the keynote address.
Justice Vivek Rusia, Administrative Judge, High Court of Madhya Pradesh. Justice Vivek Agarwal, Chairman, Governing Council, Madhya Pradesh State Judicial Academy. Judges of Madhya Pradesh High Court, Delhi High Court. Mr. Radhilal Gupta, Chairman, Bar Council of Madhya Pradesh. Mr. Dhanya Kumar Jain, President, High Court Bar Association. Mr. Sanjay Agarwal, President, Advocates Association. Mr. Aditya Adhikari, Secretary, Senior Advocates Council. Mr. Umesh Pandav, Director, State Judicial Academy. Advocates, Senior Advocates, members of the registry. It's been a long, grueling day. I don't think we are waiting for any more speeches, but after a long, tiring day, when a person like Mr. Dhanya Kumar Jain comes in and makes us forget all our worries. He is a tremendous speaker, और ये कहते हैं कि जब मैं लिख के नहीं लाता तो मैंने ये देखा है कि जब ये लिख के लाते हैं तो हमें परेशानी होती है, जब नहीं लिख के लाते तो बहुत अच्छा बोलते हैं। ये कहते ज़रूर है कि मैं कुछ मेरे को समझ नहीं आता क्या बोलूं, लेकिन बोलते बहुत अच्छा है, बहुत सोच समझ के बोलते हैं। और वकील की यही खूबी होती है कि जज को लगे कि भी मैटर ऑफ फैक्टली बोल दिया, कोई बहुत बड़ी बात नहीं, लेकिन उस बात में गुण बहुत होते हैं और गुड़ बहुत होता है उसमें। और ये धन्य कुमार जैन की उसमें होता है कि अगर 5 मिनट भी बोलेंगे तो इसमें 5 ज़रूर चीज़ें ऐसी बोलेंगे जिनमें हर एक के लिए किसी ना कुछ मैसेज होगा। जजेस के लिए भी मैसेज दिया, आप लोगों के लिए दिया, बार काउंसिल के लिए भी मैसेज दे दिया इन्होंने। खैर एक चीज़ ये वो हो गया कि बार काउंसिल जो कर रही है वेरिफिकेशन, ये सुप्रीम कोर्ट के ऑर्डर से कर रही है, ये नहीं कि इन्होंने अभी शुरू किया है। लेकिन खैर ऑल दीज आर इन द लाइट ऑफ एन, वी आर नॉट हेयर टू सॉर्ट ऑफ लुक एट दिस, बट एक चीज़ मैंने देखी इस आज की कॉन्फ्रेंस से कि ऑल ऑफ यू बिन वेरी सपोर्टिव। ये हॉल छोटा नहीं है, हमें पहले फ़िक्र थी कि ये हॉल भर भी पाएंगे। अब जब ये कॉन्फ्रेंस शुरू हुई तो हमें बल्कि साथ वाला हॉल भी एक लेना पड़ा। इट हैज़ बीन सो फुल एंड ऑल ऑफ यू हैव बीन हियर। इट्स बीन अ ट्रिमेंडस लॉन्ग लर्निंग डे। हमें भी बैठ के कुछ नई चीज़ें सीखने को मिली, बिकॉज आई बीन हियर फॉर अ ईयर। तो आई एम थैंकफुल टू माई ब्रदर जजेस फ्रॉम दिल्ली, जिन्होंने मेरे को बताया कि अब दिल्ली में क्या डेवलपमेंट हुई है। जब मैं यहाँ आया तो मैंने देखा कि भाई यहाँ पे कमर्शियल लिटिगेशन ज़्यादा डेवलप नहीं है। ये नहीं है कि यहाँ स्कोप नहीं है। थिंग इज़ वी हैव नॉट बीन मेड अवेयर ऑफ कमर्शियल लिटिगेशन। आज देव टोल्ड अस समथिंग अबाउट IP लॉ, IPR, ट्रेडमार्क। When you learn, you will be able to advise your clients will bring in more litigation. Jabalpur High Court will also develop in that kind of litigation, arbitration, commercial litigation, trademark, patent, copyright. हमारे पास आते हैं केसेस, आजकल भी आते हैं, लेकिन उतने नंबर के नहीं हैं जितने पहले होते थे। I used to come to Indore High Court, Madhya Pradesh High Court 20-25 years ago to practice. उस समय यहाँ IP litigation बहुत होती थी। Over the years it has gone down. Probably with your effort you will be able to bring the litigation which has gone to other states back to your state, and that kind of litigation, exposure to international law, exposure to commercial law, will make a very rich bar, rich not only in terms of wealth but in terms of knowledge. So I would not like to detain you any further. There is, I am told, high tea waiting for all of us. Thank you very much. And just one thing I'd like to say, if any one of you has any suggestions on what kind of topic we need to cover in in the next conference that we want to do, Mr. Jain said we should do more, we will do more, and this is just a trailer of the film that is going to come. So please give us your suggestions. The Madhya Pradesh State Judicial Academy will take it forward, the High Court will support it, and next time we will have to have people sitting in the aisles also, because we want a full house, a packed house. Thank you very much.
Thank you so much, Lordship. Moving towards the end of the program. Moving towards the end of the program, I request Shri Umesh Pandav, Director, Madhya Pradesh State Judicial Academy, to please propose vote of thanks.
My Lord, Honorable Shri Justice Sanjeev Satdeva, Chief Justice, High Court of Madhya Pradesh, Honorable Chief Justice Vivek Rusia, Administrative Judge, High Court of Madhya Pradesh, Honorable Chief Justice Vivek Agarwal, Judge, High Court of Madhya Pradesh, and Chairman, Madhya Pradesh State Judicial Academy, Honorable Judges, High Court of Delhi, Honorable Judges, High Court of Madhya Pradesh, Shri Radhilal Gupta, Chairman, State Bar Council of Madhya Pradesh, Shri H.S. Rupra, Additional Advocate General and Officers of AG Office, Shri Dhanya Kumar Jain, President, High Court Bar Association, Jabalpur, Shri Sanjay Agarwal, President, High Court Advocates Bar Association, Shri Aditya Adhikari, General Secretary, Senior Advocate Council, Jabalpur, President and Office Bearer of and members of bars from adjoining districts, Shri Suish Mohan Guru, Deputy Solicitor General for Union of India, learned members of bar, Shri Dharmender Singh, Registrar General and officers of Registry and Madhya Pradesh State Judicial Academy, ladies and gentlemen. Warm greetings to everyone. On behalf of the Madhya Pradesh State Judicial Academy and the entire judicial fraternity, it is my privilege to extend a heartfelt vote of thanks at the conclusion of this enlightening conference on advocacy and professional competence, pursuit of excellence for advocates. At the very outset, I express my deepest gratitude to Honorable Mr. Justice Jiten Kumar Maheshwari, Honorable Mr. Justice Satish Chandra Sharma, Honorable Mr. Justice Alok Arade, and Honorable Mr. Justice Rajendra Menon for gracing the occasion and sharing their insights with us in the inaugural session. I express my profound gratitude to Honorable Mr. Justice Sanjeev Satdeva, Chief Justice, High Court of Madhya Pradesh and Patron of the Academy, for his inspiring leadership and constant encouragement. Under his leadership's dynamic vision, the Academy has continued to expand its initiatives for the training of advocates, thereby strengthening the very foundation of the justice delivery system. We are truly honored by your Lordship's gracious presence and continued guidance in steering the Academy's endeavor towards greater inclusivity and excellence. Thank you, Lordship. I also express my gratitude to Honorable Mr. Justice Vivek Rusia, Administrative Judge, High Court of Madhya Pradesh. His Lordship has only recently assumed this assignment, and we are deeply grateful for the encouraging involvement and keen interest his Lordship has already demonstrated. Thank you, Lordship. We also express our thanks to Honorable Mr. Justice Vivek Agarwal, Chairman, Madhya Pradesh State Judicial Academy, for his constant guidance, unwavering support, and deep personal involvement in the planning and implementation of all academic and initiatives of the Academy. His Lordship's keen interest in promoting professional competence and continuing education for advocates has been a source of great inspiration for all of us. Thank you, Lordship. Our sincere thanks are also due to Honorable Judges of Delhi High Court, Honorable Mr. Justice V. Kameshwar Rao, Honorable Mr. Justice Naveen Chawla, Honorable Mr. Justice Subramaniam Prasad, Honorable Mr. Justice Manoj Kumar Ohri, Honorable Mr. Justice Jasmeet Singh, Honorable Mr. Justice Amit Bansal, Honorable Mr. Justice Purshen Kumar Kaurav, Honorable Ms. Justice Rekha Palli, Honorable Ms. Justice Mukta Gupta, for sharing their valuable insights and vast experience on crucial aspects of advocacy, trial management, writ jurisdiction, and commercial law. Your words of wisdom have enriched this forum and inspired every participant. I would also like to place on record our sincere gratitude to all the Honorable Judges of High Court of Madhya Pradesh for their encouragement and keen interest in promoting the training of advocates across the state. This conference marks yet another milestone in Academy's journey of continuous learning and professional growth. The Madhya Pradesh State Judicial Academy, under the able directions of Honorable Chief Justice Shri Sanjeev Sachdeva, has undertaken several pioneering programs for advocates, from foundation courses at the district and tehsil level to the regional and special workshop at international level for young lawyers at High Court level. In addition to physical workshop, the Academy has also been conducting online e-court training programs, enabling advocates across the state to stay updated with evolving legal development and technological advancement. These initiatives reflect the belief that standard of the bar is the standard of the bench, and that an informed and well-trained bar is essential to the cause of justice. A special word of appreciation is due to Shri Dharmender Singh, Registrar General High Court of Madhya Pradesh, for his consistent support and administrative leadership, and to all officers of the registry and the academy for their meticulous coordination and tireless effort in organizing this event. We also thank Shri Radhelal Gupta, Chairman, State Bar Council of Madhya Pradesh, Shri Dhanya Kumar Jain, President, High Court Bar Association, Jabalpur, Shri Sanjay Agarwal, President, High Court Advocates Bar Association, Shri Aditya Adhikari, General Secretary, Senior Advocates Council, Jabalpur, and Presidents and Office Bearers and members of the Bar of the adjoining districts. Due to paucity of time, I am unable to name everyone, but I would like to express my gratitude to the management of IIITDM, IT team, sports staff, volunteers, and our Class 3 and Class 4 employees of the registry and the academy. As we conclude today's deliberation, we remain confident that Inside Shade will not only refine in the art of advocacy but also strengthen our shared commitment to the excellence, ethics, and justice. As the director of the academy, I thank everyone for your presence, your contributions, and your continuing faith in academic's mission of pursuit of excellence. Thank you.
Thank you so much, sir. With that and with permission of my Lord Honorable the Chief Justice, this conference stands formally concluded. All the esteemed dignitaries and participants are now warmly invited to join for high tea. Thank you so much. Namaste.